sponsor is here as well. And we've started to live stream. So we'll start our committee meeting. Good morning, everyone. Welcome to the Joint Standing Committee on the Judiciary. This morning, and actually all of today, we are going to have a public hearing on LD 1626. This is the continuation of a matter that we began a public hearing on last spring and that we tabled. We have the bill sponsor here today and many members of the public, as well as representatives of the Wabanaki Nations in Maine. And we are looking forward to hearing from everyone. Before we do, I wanted to go over a few of the ground rules related to how we conduct public hearings to make sure everybody is aware of them. And then we'll do committee introductions and then we'll begin our work for the day. So the way today's public hearing will proceed is that we are going to first hear from the bill sponsor and other legislators who wish to speak in favor of LD 1626. Then we will hear from elected tribal representatives. Those include chiefs and vice chiefs and members of tribal councils, as well as Ambassador Dana. And then we are going, and all of those people who testify in those groups, they will not have the traditional 3-minute time limit. Once we complete hearing from elected officials, we'll begin to run a 3-minute clock. And as an explanation, I want everyone on the committee, as well as members of the public, to be aware that we have over 100 people signed up to provide testimony today, which is wonderful. We are very much looking forward to hearing from each one of you. In order to make sure that we're able to hear everyone, we will ask that you keep your remarks to a 3-minute time frame. You may get some questions from committee members. And this is the time, and you'll notice this as we go through the hearing, where we really want to hear from the public. Committee members may ask clarifying questions of those who speak before the committee, but we will reserve our comments and debate on the merits of the bill for our work session. And so again, those who speak after elected officials, we ask that you keep your remarks to 3 minutes. Be aware that you may get some clarifying questions from committee members, and also note that if you have extensive written testimony that you have submitted or wish to submit, please do so and just let us know in your live testimony that there is more information, and we will make sure to take a look at your written testimony that you've submitted. We do have people signed up to speak in favor, in opposition, and neither for nor against this legislation. And so we hope to hear from all of the elected officials first, and that will take probably around 2 hours. We plan to take a short break after the elected officials so that people can get a glass of water or otherwise stretch for a moment. And then we'll return and we will hear from first those speaking in opposition, and then neither for nor against. And then we'll return to those who have signed up to speak in favor. And again, we'll try to take a break every 2 hours or so. Let's see, for members of the public who are providing testimony, and actually this goes for the bill sponsor and other legislators as well, please introduce yourself. Let us know your name, where you reside, and then also please let us know if you represent an organization, the name of the organization you represent. And I think that covers all of the process-related information. And so with that, I will start to initiate the committee introductions. And I am going to simply call on committee members according to how I see you all on the screen. And so we will start with Senator Sanborn.
Thank you, Senator Carney. My name is Heather Sanborn. I represent Senate District 28, which is half of Portland and half of Westbrook.
Representative Evangelos.
Thank Thank you, Senator Carney, and good morning, everyone. Jeffrey Evangelos, House District 91. I reside in Friendship.
Representative Newell.
Thank you, Madam Chair. Good morning, everyone. My name is Rena Newell, and I proudly serve as the tribal representative for the Passamaquoddy tribe.
Representative Babbage.
Thank you, Madam Chair. February 15th is a good day because it's my grandson Caleb's 4th birthday, but also because of the many distinguished guests before us today. That doesn't happen that often. My name is Chris Babbage. I represent House District 8, which is most of the town of Kennebunk.
Representative Thorne.
Good morning. Thank you, Madam Chair. Good morning from Carmel. My name is Jim Thorne. I represent House District 103, which are the towns of Carmel, Herman, and a portion of Etna up in beautiful Penobscot County.
Representative Moriarty.
Thank you, Madam Chair. Good morning, all. I am Steve Moriarty, representing House District 45, which is Cumberland and part of Gray.
Representative Sheehan.
Good morning, Madam Chair, and thank you for being here, everyone. My name is Erin Sheehan, and I represent House District 12, which is downtown Biddeford.
Representative Reckitt.
Morning, everyone. My name is Lois Reckitt, and I represent District 31, which is the ocean end of South Portland.
Representative Poirier.
Thank you, Madam Chair. I'm Jennifer Poirier. I represent House District 107, which is all of Skowhegan and part of Madison.
Representative Libby.
Thank you, Madam Chair. My name is Laura Libby, and I represent District 64, which is part of Auburn and all of Minot.
Co-Chair Harnett.
Thank you, Madam Chair, and good morning to my colleagues on the Judiciary Committee, and welcome to the members of the public here today. My name is Tom Harnett. I represent House District 83, which includes the town of Farmingdale and the city of Gardner, where I reside.
And we are joined today, and you will see these folks occasionally throughout the morning, by our committee analysts, Janet Stocco and Peggy Reinsch, and also by our committee clerk, Susan Panett. And I am Ann Carney. I represent Senate District 29, which includes South Portland, Cape Elizabeth, where I reside, and a little bit of Scarborough. As we were doing committee introductions, I thought of two things that I neglected to mention this morning. Actually, just one, well, maybe two. We're live streaming. Everybody should know that. When you are called to speak, you will appear on the panel and be part of the YouTube video and live stream of this public hearing. And then secondly, there is a chat function, but we do not use the chat for substantive matters during committee public hearings or work sessions. If you're having a technical failure and you wish to contact us, you may use the chat for that, but please don't use it for any other comments. Thank you very much. And now we will begin our continued public hearing on LD 1626 and welcome the bill sponsor, Representative Talbot Ross, to begin her presentation. Thank you.
Thank you. Senator Carney, Representative Harnett, and distinguished members of the Joint Standing Committee on Judiciary. My name is Rachel Talbot Ross. I represent House District 40, which includes the Portland neighborhoods of Parkside, Bayside, East Bayside, Oakdale, and the University of Southern Maine campus. It is my honor to present LD 1626, an act implementing the recommendations of the Task Force on changes to the Maine Indian Claims Settlement Implementing Act. While I am truly honored to be the lead sponsor of this legislation in the 130th legislature, its current form is the result of several years of work by this committee and the Wabanaki Nation. Additionally, I want to acknowledge the co-sponsors of LD 1626 by name: President Troy Jackson, Senator Ann Carney, Speaker Ryan Fecteau, Representative Rena Newell, Representative Tom Harnett, Representative Ben Collins, Representative Tom Martin, Representative Ann Perry, and Representative Jeff Evangelos, as well as the supporters of this legislation who were unable to be co-sponsors. The more than 100 organization coalition that has formed to support this bill, and the countless Mainers who have written letters to the editor, reached out to their legislators, and otherwise spoken out in support of this work. LD 1626 is not only a group effort of many people who strongly support the restoration of powers and authorities to the Wabanaki nations, but indeed, I say to you today, I believe this bill reflects the will of the people of Maine. LD 1626 is the product of then Speaker Sarah Gideon and Senate President Troy Jackson affirmatively reaching out to the Wabanaki nations in the spring of 2019 to express the desire of the state legislature to modernize the State Settlement Act that governs the relationship between the state and Wabanaki nations. Their desire to modernize the Settlement Act came as a result of the 2016 roundtable to review the Maine Indian Claims Settlement Act, which was hosted by the Maine Indian Tribal State Commission. That report was one of a long line over the years to conclude the same thing. It is time, it is absolutely past time. It has been more than enough time to restore sovereignty. In 2019, the state legislature enacted a joint resolution to support the development of mutually beneficial solutions to the conflicts arising from the interpretation of an act to implement the Maine Indian Claims Settlement and the federal Maine Indian Claims Settlement Act of 1980. This joint resolution established a task force to develop recommendations on changes that should be made to the Maine Indian Claims Settlement Implementing Act. The task force worked vigorously over the course of several months, conducting research, taking testimony, and developing a report that was presented to this committee in January 2020. The task force report set forth 22 recommendations for modernizing the Maine Implementing Act. Then Representative Donna Bailey introduced a bill last legislature, LD 2094, that sought to implement most of the task force recommendations. That bill was ultimately approved by this committee, but was not brought to the full House and Senate for a vote, in part due to the COVID-19 pandemic. As this bill moves through the legislative process, I think it is important to remember that it was the legislature versus the Wabanaki nations that initiated this process to modernize the State Settlement Act. This is important because we asked the tribal leaders and their representatives to invest significant time and resources towards this effort, and they did. Previous Maine legislators set up a task force to look at this issue, the most recent in 1996. However, no bill has gotten to the full House and Senate for a vote. I repeat, no bill has gotten to the full House and Senate for a vote. Given the time and resources devoted to this effort, it is my sincere hope that LD 1626 will be voted on by the House and the Senate during the 130th legislature. I truly believe that we owe it to the Wabanaki people to have a vote on this bill during this time in this legislature. I also think it is important for the public and my colleagues to understand that the purpose of LD 1626 is to modernize the government-to-government relationship between Maine and the Wabanaki nations. This relationship has been governed by federal and state settlement acts since 1980. Those settlement acts were the product of federal litigation involving the tribal nations' claims to much of the lands of Maine, which a federal court in the US Department of Interior found to be valid claims. This settlement act was supposed to focus on resolving the land claims, but somehow they turned into an effort by the state to severely restrict the inherent sovereign rights of the Wabanaki nations in order to prevent a, quote, nation within a nation scheme and inconvenience the state's jurisdictional authority. The past 40 years of living under the Settlement Act system has shown that the state has benefited far more than from the system than the tribes. In fact, every time a study is conducted on how the tribes fare under the Settlement Act, its conclusion is that the tribes suffer and have been unable to progress at the same rate as most of other tribal nations within this country. I'll give you a few examples. Although the Settlement Acts supposedly guaranteed the tribes the full right to govern their internal affairs, lawsuits brought by 3 paper corporations led to a state court decision in 2001, finding that the Settlement Acts required the tribes to release a substantial amount of their internal documents to the paper corporations under Maine's Freedom of Access Act. In 2012, Congress enacted amendments to the Federal Stafford Act that would allow federally recognized tribes to directly request a presidential disaster and emergency declaration rather than to go through their respective states. Maine opposed these amendments, applying to Wabanaki tribes, and argued to Congress that the Settlement Acts prevent the amendments from applying. The Stafford Act amendments would have allowed the tribal nations to seek federal resources when their disasters occurred on their tribal lands. The Penobscot Nation reported that Maine's efforts specifically prevented them from accessing federal resources when ice jams caused flooding on their tribal lands. The failure of these federal laws to apply in Maine also delayed tribal access to federal resources to combat the COVID-19 pandemic. A 2012 report of the United Nations Special Rapporteur on the Rights of Indigenous People found that the Settlement Acts create structural inequities that limit the self-determination of Maine tribes and contribute to Maine tribal members experiencing extreme poverty, high unemployment, short life expectancy, poor health, limited educational opportunities, and diminished economic development. In 2013, Congress enacted a law that restored the criminal jurisdiction of tribal nations over non-Indians who commit certain acts of domestic violence on tribal lands. The Penobscot Nation was set to be a pilot project for the U.S. Department of Justice. However, the state of Maine, once again, challenged the application of the new federal law to the Maine tribes. The result was that the Penobscot Nation was not allowed to be a pilot project and lost out on millions of dollars of federal law enforcement resources. Worse, women who are victims of domestic violence on tribal lands were denied and delayed access to justice. Continuing in 2014, the Maine Department of Professional and Financial Regulation, which issues licenses to healthcare facilities in Maine, began sending letters to the Passamaquoddy Tribe's health clinic, demanding that the facility only hire Maine licensed medical professionals. However, Congress enacted a law in 2010 that allowed all tribal nations to hire medical professionals that were licensed by any state. Congress did this to address the shortage of medical professionals willing to move to and work on tribal lands. But Maine argued that the Settlement Acts prevent the new federal law from applying to the Maine tribal nations. The conflict has led to the Passamaquoddy tribe continuing to struggle to recruit medical professionals to work at its health clinic. I say to this committee that these are but a few of the examples of the harms to the Wabanaki nations caused by the Settlement Acts, but there are many, many more. The Settlement Acts have not been amended or updated in 40 years. There has been protracted litigation over many provisions related to natural resources, but many other provisions remain ambiguous and subject to the threat of litigation. It has all led to the hampering of progress for the Wabanaki nations and people, but also for the nearby communities who are losing out on opportunities to partner with tribal nations and access federal resources that could be improving the entire rural regions in Maine. Let me be clear. about what 1626 does and does not do. Nothing in LD 1626 impacts the land claim settlements in the 1980 Settlement Acts. Those land claims are forever resolved. It also cannot fully account for the harm that has been caused for several generations as a result of the Settlement Acts. It cannot account for the harm, the generational harm that has been the result of those Settlement Acts, but it will address the legal and political realities of restoring sovereignty. What LD 1626 does is amend the main implementing act to restore back to the Wabanaki nations much of their governmental jurisdiction over their reservation and trust lands as recommended by the task force. It also seeks to treat each of the tribal nations in Maine equally. Under the Settlement Acts, each of the Wabanaki nations is treated differently, and each has different levels of limitations on their inherent powers and authority. LD 1626 seeks to bring all of the Wabanaki nations back to the same level of sovereignty that most other tribal nations exercise in this country. This includes restoring to the tribal governments the power to exercise civil and criminal jurisdiction over individuals and activities occurring on their reservation and trust lands, including the regulation of natural resources and waters that are within the boundaries of their reservation and trust lands. It also includes the power of the tribes to tax individuals who conduct activities on their reservation and trust lands so that the tribes can develop their own economic economies and expand government services. LD 1626 helps ensure that the Wabanaki nations get the full amount of land that they were promised in the Settlement Acts. Both the Penobscot Nation and Passamaquoddy tribes have been unable to obtain the amount of lands that they were guaranteed under the Settlement Acts, even after 40 years. This needs to be resolved. And LD 1626 seeks to ensure that the Wabanaki nations have access to the federal laws and regulations that are passed specifically for the benefit of all Indians and tribes. I know the provisions of LD 1626 scare some people. Change scares some people. But for those who are concerned about the provisions of LD 1626, I urge you to read the task force report. It does a good job of summarizing how the Settlement Acts restrict the inherent powers and authorities of the Wabanaki nations in Maine compared to existing federal Indian law that applies to most other tribal nations. We cannot live in the past forever. We need to move on. Progress will only come if we adapt to the times, evolve our thinking, and fully recognize our tribal nation neighbors as the political governments they are and have been since before the founding of this country. I am honored that the Wabanaki nations asked me to introduce the legislation this session. I do so with the hope that my colleagues will join these efforts to close the chapter of the state-tribal relations that have existed for the past 40 years and to begin a new chapter, one that respects the Wabanaki nations in this state for what they are, the indigenous nations that pre-exist the United States with the full powers and authorities of other tribal nations. Rather than continue to see the Wabanaki nations as enemies or a threat to our state government, let's see LD 1626 as an opportunity to partner with our tribal nations and work with them on a government-to-government basis to develop progress for all of the communities within this state. I have long heard that the goals of the 1980 Settlement Acts were to prevent the existence of government within a government. The state of Maine somehow thought that recognizing the full political existence of our tribal nations would somehow diminish us as a state. Whatever the cause for those feelings were in 1980, they simply have not turned out to be true in Maine or in any of the other states. Instead, state governments that have embraced their tribal nations and developed productive and meaningful political relationships with them have seen those relationships bring progress to their entire state. Sure, there remain disagreements. Just like there remain disagreements between Maine and our neighboring states at times, but having respectful, equal political relationships seems to be much more productive than what Maine has done for the past 40 years, which is to constantly fight to diminish the inherent rights and powers of these tribal nations. In 1970, President Richard Nixon delivered a special message on Indian affairs to the United States Congress. This message was that the federal government's policies up until that time were wrong and not working. Nixon condemned prior federal efforts at forced termination of tribes and proposed recommendations for specific action to allow and support the self-determination and self-governance of tribal nations. The policy set forth by President Nixon remains the policy of the federal government towards tribal nations. And by all accounts, it is only the policy that seems to be providing benefits to both the tribes and the country, so it is not expected to change anytime soon. It is my opinion that Maine should adopt the policy of self-determination and self-governance of the tribal nations and open the doors of opportunity for the entire state. The Wabanaki nations pre-exist the state of Maine. They will continue to be here long after those of us who are here today are gone. The tribes are not looking to harm the state. Rather, they are looking to benefit from the opportunities that other tribal nations in this country have benefited from and elevate the lives of those living within and near their communities. We should support this effort because of what it is. It is in the best interest and future for the entire state of Maine. The progress made by other states who fully recognize their tribal nations show this to be true. I want to close by thanking you for allowing me to present LD 1626. I want to thank the staff, Margaret, Peggy Reintz, Janet Stucco, Sam Sheff. I want to thank the co-sponsors. I want to thank Amy Sylvester, who have all done an enormous amount of work to get us here today. I want to acknowledge the Honorable Donna Loring and the Honorable Gerald E. Talbot, who allowed me to stand here today. I believe this is truly momentous legislation that can provide meaningful benefits to the Wabanaki nations as well as to the nearby communities in the entire state of Maine. It is my honor to present LD 1626. Thank you.
Thank you very much, Representative Talbot Ross. Committee members, are there any questions for the bill sponsor? I am not seeing any. And as you know, it is the custom of this committee to allow you to bill sponsors to remain on the panel for the public hearing, and you're welcome to be here.
Thank you.
Thank you. And now we will next hear from legislators who are co-sponsors of LD 1626. And I would ask, I see that Representative Evangelos has raised his hand, and legislators who are not on this committee but are in the attendee portion of the meeting, please also raise your hands and keep them raised until we have brought you over to the panel to give your testimony. And I will start with Representative Harnett. Did you have a question?
No, I am a co-sponsor. I will speak very briefly after Representative Evangelos.
All right, thank you very much. Representative Evangelos, you may proceed.
Thank you, Senator Carney. Good morning, Senator Carney, Representative Harnett, and my colleagues on the Judiciary Committee. I am Representative Jeffrey Evangelos from Friendship, House District 91. and I am speaking in support of LD 1626, an act implementing the recommendations of the Task Force on changes to the Maine Indian Claims Settlement Implementing Act. The purpose of the reconsideration and rewriting of the Maine Implementing Act is to establish that the Passamaquoddy tribe, the Penobscot Nation, the Holton Band of Maliseet Indians enjoy the rights, privileges, powers, duties, and immunities similar to those of other federally recognized Indian tribes in these United States. This bill does not address the relationship between the state and the Aroostook Band of Micmacs, because that issue was specifically set aside by the task force. We'll address three issues. First, inherent sovereignty. On September 13, 2007, the United Nations adopted the Declaration of Rights of Indigenous Peoples. Inherent sovereignty is the most basic principle of all Indian law. It means simply that the powers lawfully invested in an Indian tribe are those powers that predate New World discovery and have never been extinguished. My state must come to grips with this, that sovereignty cannot be bought, sold, granted, or traded. So why I do testify today, Madam Chair, it is with full regrets and knowledge that my state cannot grant something to my Native brothers and sisters that they inherently already possess. Second, a deal is a deal. From 1778 to 1871, the United States government entered into more than 500 treaties with Native American tribes. All of those treaties have since been violated in some way or outright broken by the US government or its states. Quote, they made us promises, and they only kept one. They promised to take our land, and they did. Chief Red Cloud, Ogalla Lakota Sioux. Former Maine Attorney General James Tierney acknowledged that the settlement and implementing acts were living documents subject to change over time. A deal is a deal? I don't think so. It's more like a deal was a steal. Third, let's discuss the argument that Maine was negotiating in 1980 to protect its interests. It's the absolute obligation of a state to guarantee the rights of its peoples. In 1924, the Indian Citizenship Act, referred to as the Snyder Act, an all-inclusive act, was passed by Congress and signed into law by President Coolidge on June 2nd, 1924. Be it enacted by the Senate and House of Representatives of the United States of America and Congress assembled, that all non-citizen Indians born within the territorial limits of the United States be, and they are hereby declared to be citizens of the United States, provided that the granting of such citizenship shall not in any manner impair or otherwise affect the right of Indian or tribal or other property. The purpose of this act was to ensure that the 14th Amendment of the United States Constitution applied to Native Americans. It was enacted partially in recognition of the thousands of Native Americans who served in the armed forces during World War I. Despite the passage of this act, the state of Maine ignored it. Not until 1954 did Maine allow tribal members the right to vote in federal elections. Astonishingly, despite the passage of the Civil Rights Act of 1964 and the Voting Rights Act of 1965, Maine continued to ignore the provisions of these federal laws. Finally, in Maine, in 1967, allowed Native Americans the right to vote in state elections, the last state in the country to do so. A shameful legacy. How shameful? In 1967, Roger Data was drafted into the Vietnam War before he obtained the right to vote. He's buried in Princeton, Maine, killed in action, May 13th, 1968. Now let's examine whether Maine negotiated in good faith in 1980. In conjunction with that, the University of Arizona discovered a smoking gun that proves that Maine negotiated in bad faith. On March 28th, the Joint Select Committee on Indian Land Claims, that's 1980, March 28th, a memorandum written by then Attorney General Richard Cohen laid out Maine's strategy in the 1980 to rob the tribes of their inherent sovereignty. And I quote, the framework of laws in this settlement act is by far the most favorable state-Indian jurisdictional relationship that exists anywhere in the United States. As a general rule, states have little authority to enforce the state laws in Indian lands. Tax laws, water, air pollution laws, zoning laws, health laws, contract and business laws, and criminal laws, all those state laws are usually unenforceable on state Indian lands. I believe such a result would be intolerable, the Attorney General said. The proposal before you not only avoids such a situation, but recovers for the state much of the jurisdiction over the existing reservations that was lost in recent litigation. It's the litigation that Representative Talbot Ross spoke of in the 1970s. Additionally, on August 28, 1980, Senator William Cohen's aide, Timothy Woodcock, wrote a memo to the senator who was involved in the final negotiations in Washington on the Settlement Act, and I quote, "The municipality concept was adopted because it was believed to be the best device to ensure that the tribes remained under Maine law and did not take on the substantial attributes of sovereignty, which characterized many of the tribes in the West. The municipal construct was also seen as the best way of tying the tribes irrevocably to Maine law. By endowing the tribes with the characteristics of municipalities, the state believed it was avoiding the creation of a nation within a nation, which Governor Longley had so vigorously decried." Memo dated August 28, 1980. What was Maine's motive behind this strategy? Not only did this strategy deny Native American nations their inherent sovereign rights, then Attorney General Richard Cohen laid out this additional motive in March 1980 memorandum. Quote, "This settlement will result in no direct cost to the state. We have every reason to believe that the state will realize a substantial net savings by treating the Indian territories as municipalities. I am confident that the state therefore will realize a substantial net financial gain from this settlement." And let's not forget, members of the Judiciary Committee and my tribal nations and members listening, the state of Maine did not contribute 1 penny to the settlement. And how fair was the 1980 Joint Select Committee on Indian Land Claim Settlement to Maine? Native Americans who had the courage to dissent? Reading directly from the transcripts of that hearing, Penobscot Dana Mitchell challenged Senate Chair as follows. "Well, I find it kind of unusual at this time to find that the Penobscot Nation and representatives and their people are restricted to 5-minute time limit in delivery when the state and other people have had unlimited time limit to speak. I'd like to enter that into the record at this time," said Mr. Mitchell. Just a half an hour later, the Senate Chair said, "I'm going to now limit you to 2 minutes each." So it is for all these reasons that I reject the legacy of the past and endorse the proposals in this bill. Something wonderful is about to happen. Maine is about to acknowledge that we have 4 sovereign nations within our borders. They will attract investment, create jobs, and they will exercise their self-determination for the benefit of all. Happy to answer your questions.
Thank you very much, Representative Evangelos. Committee members, are there any questions for our colleague? Not seeing any. Thanks once again. And Representative Harnett, you may proceed.
Thank you, Madam Chair, colleagues on the Judiciary Committee. My name is Tom Harnett, and I represent House District 83, which is the town of Farmingdale and the city of Gardner, where I reside. I am proud to be a co-sponsor of LD 1626 and was proud to testify and support LD 2094 in the 129th legislature. I just wanted to alert the committee and members of the public, I have submitted written testimony, but given the number of tribal members and members of the public that wish to testify, I will not deliver that testimony orally, but I would ask you to please pay attention to it in your review. I would much prefer to cede my time to tribal members and members of the public. Thank you, Madam Chair.
Thank you, Co-Chair Harnett. And now we are going to hear from legislators who wish to speak on LD 1626. Legislators who are in the attendee space, you're going to be moved over now, and I'll call on you as you reach the panel. We'll start with Representative Dudera.
Good morning, everybody. Thank you very much, Chair Carney. I'm going to follow the example of my esteemed colleague, Representative Hartnett, and I will greatly shorten my remarks as well. My name is Vicki Dudera. I represent House District 94, which includes Camden, Islesboro, and Rockport. I'm here today to testify in support of LD 1626, an act implementing the recommendations of the Task Force on changes to the Maine Indian Claims Settlement Implementing Act. I'm coming to you from ancestral land once known as Magunnacook, or Great Swells of the Sea. I'm here to echo what I have heard from my countless constituents, and that is that we must continue our work to rectify our long and shameful history of broken promises to the Wabanaki people. I was proud to vote for measures that began this process of healing in the 129th legislature, and I applaud our governor for signing them into law. Now we must continue that work and heed the recommendations of the bipartisan task force on changes to the Indian Claims Settlement Implementing Act. So I have provided my written testimony. I will just speed ahead and just close with the words of a neighbor who reached out to me just this morning. And she said, I'm writing today to ask you to support LD 1626. It is asked that I convey how this bill will impact me personally. I am not Wabanaki, but I am a citizen of Maine, and therefore I am living on what was once their land. If this bill helps them, it helps me. They are my neighbors, and we are all one. Please support the tribes and help them prosper. Thank you for letting me speak today.
Thank you, Representative Dudera. Committee members, any questions for Representative Dudera? Not seeing any. Thank you very much. Next, we'll hear from Representative Collins.
Good morning, Senator Carney, Representative Arnett, distinguished members of the Judiciary Committee. I'm Benjamin Collins. I represent House District 42, which is part of the city of Portland. You've heard from others who've stated the case well, and I'll just follow up on their comments about this being a living document that could be changed at any time. Yet in over 40 years, every time the tribes have come to the state in good faith to negotiate changes for the betterment of their communities, the state has pretty much said no every single time. And as you've heard as well, we are an outlier here. Throughout the country, practically every tribe has a relationship with the federal government, which allows them to exercise sovereignty in a manner much greater than we have here in the state of Maine, based on the 1980 Settlement Act. And I'll remind you, it was a settlement act about land. Somehow, at the last minute, this language came in about jurisdiction, and I'm speaking as a metaphor here. The tribes really had a gun to their head where they had to act fast to sign this or they would get nothing. So they did, because they were in a very dire state of affairs. As I mentioned to this committee the last time I testified last year on sovereignty, when this document was signed, the average lifespan of a Native American person in the state of Maine was just a little over 40. Conditions were horrific where they lived. Conditions still remain tough in lots of these communities. And in most states where tribes have a greater control of their destiny, they can do a lot more to help their community members. But this act prevents federal law that benefits Native American communities. This act prevents the tribes here in Maine from getting federal laws applying to them that could really help them have a better standard of living. I want to conclude by saying that it's Black History Month, and a quote by Dr. Martin Luther King I think is very relevant when he talks about making people wait for justice. He said, "Frankly, I have yet to engage in a direct action campaign that was well-timed in the view of those who have not suffered unduly from the disease of segregation. For years now, I have heard wait. This wait has almost meant never. We must come to see with one of our distinguished jurists that justice too long delayed is justice denied. by us refusing to negotiate in good faith with the Wabanaki tribes, we have denied them justice. We have taken away opportunities that greatly benefit Native American members around this country. The arguments I have heard why we can't have the tribes under the jurisdiction of Congress and not under the thumb of the state, in my opinion, don't hold water. And when you go around the country and you talk to tribes and see how they have prospered, there is no reason how, if we negotiate in good faith with the tribes and let them exercise their sovereignty without our interference, that all these unintended consequences are going to happen. These arguments are red herrings. I will challenge anyone in the legislature or anyone in the state who opposes this act to go anywhere in the country where other tribes have their communities, where they have their businesses, where they're working in good faith with their state leaders. I challenge anyone to come there to these states and see how anything is so terrible, and to say that somehow in the state of Maine, and the state of Maine only, that these federal laws cannot apply to our Native American brothers and sisters. I think it's time that we act. It's time that we act in good faith. Don't make the Wabanaki tribes, the Micmac, Maliseet, Passamaquoddy, and Penobscot wait any longer. Please, let's work together to resolve this. Be on the right side of history. Thank you very much.
Thank you, Representative Collings. Committee members, any questions for Representative Collings? Not seeing any. Thank you very much. And Representative Warren, you may go ahead with your testimony.
Thank you. Good morning, Senator Carney, Representative Harnett, and esteemed members of the Judiciary Committee. I am Representative Charlotte Warren. I proudly represent House District 84, which includes the towns of West Gardner and Manchester and the city of Hollowell, where I live. I am here today to present testimony in support of LD 1626. Tribes in Maine have not benefited from more than 150 federal laws passed since 1980. And this piece of legislation in front of you can fix this issue. The tribes in Maine are asking to be treated like the other 570 federally recognized tribes. That's fairness, and that's what this bill is about, fairness. As a lifelong Mainer, born and raised on a farm just a short distance from our state's capital, I was raised by parents who believed deeply in the importance of being a good person and a good neighbor. I take great pride in who we are as Mainers. We are people who help our neighbors, whether we're dealing with a blizzard, an ice storm, or a global pandemic. We look out for each other. When our neighbors are in need, we help as we can. This proposal represents an opportunity for all of us to be good neighbors. The tribes are merely asking to be able to determine their community's futures. They should have that right on their native lands without the state of Maine obstructing them. Colleagues, as member of this distinguished committee, at this time in Maine's history, you have an extraordinary opportunity to right the wrongs of our state government. Please do the right thing. I'm asking that you vote to support LD 1626. I thank you for the time. I apologize for the dog toy squeaking in the background, and I'd be happy to answer any questions.
Thank you, Representative. Committee members, any questions? Not seeing any. We appreciate you being here today.
Thank you.
And next we'll hear from Representative Amy. And Amy, I'm sorry, I'm not going to pronounce your last name correctly. Is it Rader?
Mm-hmm.
Oh, okay. You may proceed.
Thank you so much. I too will make my comments brief. I have submitted written testimony, but there are a couple of things I wanted to highlight today. So good morning, Senator Carney, Representative Harnett, and distinguished members of the Joint Standing Committee on Judiciary. My name is Amy Rader, and I represent House District 125, which includes a part of Bangor. I speak before you today in support of LD 1626, an act implementing the recommendations of the Task Force on Changes to the Maine Indian Claims Settlement Implementing Act. I have been struggling with what to say in my testimony. I'm sure many people testifying in person or virtually will make cogent legal points, provide meaningful data, and quote at length from peer-reviewed journals. And I don't wish for my testimony to be merely a rehashing of others' words. It's important to note that this bill is about recognizing rather than bestowing sovereignty. To quote Dan Newman from the Maine Beacon, the sovereignty of the Wabanaki people is inherent and must be respected. Let me take a moment, though, to tell you the real reason LD 1626 keeps me up at night. Their names are Eben, Amara, Carmela, Layla, Adrian, Nakoa, and Byron. I had the distinct honor of working with these Indigenous young people in my previous role as the Director of Education at Penobscot Theater. During a talk back after a production of a piece created in collaboration with the Penobscot Nation, I remember one young performer saying, "I never thought I would see my stories on this stage. You don't know what that means to me." The ancestors of these young people were hunted for bounties, saw their land, language, and children stolen, their rivers polluted. We are still uncovering the traumas we inflicted with colonization, and those traumas are still affecting the Wabanaki today, including the children that I named. Passing LD 1626 is the first step in the long road to reconciliation, and it is a step we must take today. The time is always right to do right. Waliwani, I'll take any questions.
Thank you. Committee members, any questions for Representative Rader? I'm not seeing any. We appreciate you providing testimony today. And now at this time, we are going to move, we've completed our the testimony of representatives. And we are now going to hear from elected representatives of the Wabanaki nations who wish to speak in favor of this legislation. And so I would ask, if you are in the attendee portion of the meeting and you are an elected representative of a Wabanaki nation, to please raise your electronic hand and keep your electronic hand raised as we bring you over to the attendee, to the panel, to address us. And we will hear first from Chief Kirk Francis, who will be joining us momentarily.
Good morning. Can you hear me?
We can hear you just fine, Chief Francis. Welcome and thank you very much for being here this morning. You can begin whenever you're ready.
Thank you so much. And Senator Carney, Representative Harnett, honorable members of the Joint Standing Committee on Judiciary, I am honored and thank you for the opportunity to speak on behalf of, in favor of LD 1626. My name is Kirk Francis. I proudly serve as the chief of the Penobscot Indian Nation, where I've done so for the past 15 years, and it's been my honor to do it. I want to just begin, I guess, by saying thank you to the legislators that spoke before me, that have sponsored and been a part of this process. As you can see, it's not only been a substantive process, it's been an emotional process, and it's been a great experience for me. I've participated in a lot of these, and I think that 1626 has been a remarkable opportunity for both the state and the tribes. As I begin my testimony, I would point out as well that I have submitted more extensive written comments, but I think it's important to remind everyone that the Penobscot Nation's sovereignty pre-exists the United States Constitution and the 1980 Settlement Acts. Prior to the Settlement Act, we had the same rights, privileges, powers, and immunities as any other federally recognized tribal nation in this country. So while the main purpose of the Settlement Acts were to resolve the land claims, the bulk of the State Settlement Act focused on restricting the civil, criminal, and regulatory authority of the tribes, and essentially sought to continue the paradigm of treating the tribes as wards of the state. However, law cannot restrict our rights. State law cannot restrict our rights, privileges, powers, and immunities. The federal government must ratify such restrictions and did so in the Federal Settlement Act of 1980. But the state and federal settlement acts also allow for a restoration of our rights and an elimination of some or all of the restrictions placed upon us in 1980. And that is the primary purpose of LD 1626, to restore back to the Wabanaki nations the bulk of our rights, privileges, powers, and immunities that we had prior to 1980. LD 1626 is born out of a legislative initiative, as has been mentioned, that created a task force in 2019 and presented an extensive report to this very committee in 2020. The provisions of LD 1626 are intended to implement the consensus recommendations of the task force report. Since originally enacted in 1980, and has been mentioned, there have been no significant changes to the Settlement Acts. This is the case even though the Maine Indian Tribal State Commission, an entity created by the State Settlement Act, has provided numerous recommendations to amend and approve the State Settlement Act. The state and federal settlement acts have undermined our ability to provide services to our people, prevented us from creating an economy that benefits not only our community, but those around us, and excluded us from many federal beneficial acts and laws that were meant to benefit tribal nations. Some of those include, as we well know from last session, the Federal Indian Game and Regulatory Act, the Federal Stafford Act, portions of the Violence Against Women Act, and portions of the Indian Healthcare Improvement Act, all very serious pieces of legislation, but only a small sample of what we've been denied over the years. The goal of the State Settlement Act was to eliminate the existence of a government within a government. However, we are tribal nations, and only the federal government can terminate us. Therefore, we absolutely live in a world of governments within governments, and that will not change anytime soon. The Wabanaki nations have spent the last 40 years being treated like second-class sovereigns. We have watched out-of-state corporations come in and thrive by doing the very things we should be able to do, but for the Settlement Acts. We have watched the other 570 tribal nations across the country fully access the more than 160 federal laws passed since 1980 that benefit tribal governments and their communities. The restrictions on our inherent powers and authorities have caused our communities to be stagnant, often stuck in 1980, and continue to struggle to reach our full potential. We did not fully understand the impacts of the restrictions in 1980. It's not my goal in this process to relitigate that era, to put anybody's integrity in question or what their intentions were. But the negative consequences have become evident to us over the past 40 years, as the federal government has taken an opposite approach to the rest of Indian country. Over the past 40 years, the federal government has embraced the concept of self-determination and encouraged tribal nations to fully exercise their governance with the goal of achieving self-sufficiency. The federal government has realized that when tribal nations thrive, so do the surrounding non-tribal communities. And that when they invest federal resources into tribal communities, the surrounding rural communities also benefit. In fact, many federal programs now prioritize grant applications that benefit more than one government. In addition, more and more federal funding programs require state governments to ensure they are including tribal governments within their implementation plans. The report of the Legislative Task Force is consistent with the actions of the federal government and most other states. The provisions of LD 1626 seek to restore back to the Wabanaki nations our inherent powers and authorities to govern our lands and the people on our lands. This includes criminal, civil, and regulatory authority. The word restoration here is important. Nothing in this bill is about granting special rights to Maine's Wabanaki people. It is about restoring rights. After time has shown that the restrictions in the 1980 Settlement Acts have been hampering the ability of tribal communities to reach their full potential of self-sufficiency. LD 1626 recognizes that modernizing the relationship between the state and tribal governments is in line with the rest of the country, and that the promise of self-determination and self-governance will bring benefits to all of Maine communities. My government invested a significant amount of resources into the legislative process that created LD 1626. Because of this, the Penobscot Nation asked that this committee and the full legislature commit to voting on LD 1626 this session. I believe after 3 years of work, the commitment of the tribes, the commitment both emotionally and financially and a whole host of other things to this bill over the last 3 years, the tribes deserve to understand where the legislature is and the people of Maine on these issues. That brings me to one of my last points, and that's the Legislative Task Force report in LD 1626 created an opportunity for some of the Wabanaki nations, state agencies, and the governor to engage in dialogue about some of these issues. While some of those conversations have not been discussing specific provisions of LD 1626 or potential amendments to the Settlement Act, I believe they have been productive about improving the communication between tribes and state agencies, finding mechanisms to promote economic development within and around our tribal communities, and allow certain forms of gaming to be conducted by the tribes under state law. 1626 is already bearing fruit. When we think about the high level of conversations that are taking place, some of the progress we are able to, that is able to be made, and conversations that were never entertained in the past. So we can imagine what this bill will do if it passes. So it is my hope that all those discussions will result in benefits for both tribal and non-tribal communities. And I will be in front of you supporting many of those efforts as we move forward. However, I want to be very clear to clear up any confusion that the Penobscot Nation does not view those discussions as a substitute or replacement for LD 1626. This bill seeks to create an outcome based on the legislative resolve that addresses the core issue of the Settlement Act, which is intended to modernize it and create those amendments to the State Settlement Act. So I just want to close by saying that I cannot tell you how appreciative our nation is of the many passionate leaders in the state legislature. Some of those we've heard eloquently from already, but also the general public and Maine citizens for the outpouring of support and partnership throughout this whole process. It's been uplifting to our communities. So I want to thank you for allowing me to testify in favor of LD 1626. I'm happy to answer any questions, and I hope we can support this bill, a very historic bill that I think ushers in a new day of tribal-state relationship, for the tribal-state relationship and for future generations to not understand what these contentions were even all about. So thank you all.
Thank you very much, Chief Francis. Committee members, are there any questions for Chief Francis? Representative Moriarty, go ahead with your question. We're not able to hear you, Representative.
I'm sorry, I had muted myself. Good morning. Thank you, Madam Chair. Good morning, Chief Francis. As we look back on just the last 50 years of tribal state relations here in Maine, it occurs to me that there was one key aspect of that history that has not perhaps been fully discussed or fully understood, and you alluded to that in your testimony. And to be specific, you made the point that prior to 1980, the Wabanaki people did enjoy full sovereignty and all of the attributes of sovereignty, but lost that in the 1980 acts. Can you just comment further upon that point in time in which the Wabanaki people were considered to be fully sovereign and with full capacity to self-govern?
Sure, and thank you for the question, Representative.
I think that's an important point here. We really worked really hard with the task force and with others to make people understand that this was not an ask for special rights. This was about really focusing on the inherent rights of the tribe, and then to back that up with the reality of the legal environment in the 1970s, when we were coming off, even in my lifetime, I remember Indian agents, if you wanted to go have your teeth cleaned or dealt with, you had to get a stipend from the state Indian agent. So I remember those things as a kid. My grandmother worked at the facility, and but as we get into the 1970s, after coming off a century of that condition, we have two very historic court cases that really solidified the fact that, which was the basis for the land claim, which basically acknowledged that the tribes of Maine had all the same rights, powers, and immunities as any other tribe in the country. So between that time of those court decisions and the 1980 Settlement Act, there's case history on law enforcement jurisdiction, for example, on the reservation. And with certain crimes, there was court cases about various other things that really solidified that we were truly a sovereign, independent nation that was free from outside interference. And many of the things that happened in 1980 are also evident that, when we talk about gaming, for example, obviously that's not the most important issue here, but it tends to be the most toxic. And the reason we fight for that so much is because of the economic tool that we built at Penobscot as one of the first and oldest gaming facilities in the country. We actually had those facilities on the reservation, and they were taken away right after 1980. And then, of course, had to get state legislation after that to just perform basic bingo. So that's one example. But I think to your question, the important thing to know here is this full sovereignty claim before 1980 is not something that or the ability to exercise that inherent sovereignty. We've never not recognized it. But I think before 1980, there is a bunch of legal cases that take place that solidify that for the Maine tribes.
Thanks for clarifying. I think that's an important point. I appreciate it.
Thank you.
Thank you both. Any other questions, committee members? I am not seeing any. Chief Francis, thank you very much for speaking to the committee today.
Thank you for having me. Thank you.
Next, we'll hear from Chief Clarissa Sabatis.
Can you hear me?
We can hear you very well, Chief Sabatis. Thank you very much for joining us. You can proceed whenever you're ready.
Good morning, Senator Carney, Representative Harnett, and distinguished members of the Committee on Judiciary. My name is Clarissa Sabatis, and I'm the chief of the Holton Band of Maliseet Indians. And I want to thank you for the opportunity to be here today in support of LD 1626. And I'd also like to thank the bill's sponsor, Representative Talbot Ross, and all of its co-sponsors. Today, I'm hopeful. This bill is a step towards recognizing our inherent rights as tribal nations. And nearly 3 years ago, the joint resolution that was adopted in the 129th legislature after we'd been asked to come here to meet with your leadership highlighted the results of the Settlement Act on our tribal nations. And I think it was the starting point for us in these conversations that have taken place. And I have to agree with Chief Francis. I think that I've really enjoyed the engagement. It's definitely been meaningful and so important to me to be part of everything that's been happening. And I think it's a great step forward. But this resolve really highlighted the diminishment of rights, powers, and our privileges and immunities, and the disenfranchisement of our tribes and citizens. And while our nations, we have understood for decades the impacts that this has had, I think this resolve was a historic step forward for the state of Maine and our tribes to address the inequities that it's created for us. From here, we were asked by the legislature to come to the table and take part in the task force to modernize the Settlement Act. Through many sessions together, we were able to come to a consensus on a set of recommendations. And this bill here today is the embodiment of that work. So many hours, so many conversations, different sessions so that everybody could be educated on federal Indian law. I for myself, I feel like I have poured everything I can into this. And I feel that everyone else around the table has done the same. So it is significant. I'm as dedicated to the passage of these recommendations in this bill put forth today as I was in the beginning. LD 1626 honors the government to government relationship. It honors our self-determination as tribal nations and the state's self-determination. LD 1626 places the tribes in Maine on equal ground with the rest of the tribes across the nation. While our tribe has seen growth over the past 4 decades, we continue to have barriers due in large part to this restrictive act that we've lived under. Over the years, we've been on the sidelines while other tribes across Indian country are able to pursue economic independence and support healthy communities and families through self-governance and self-determination. And as our tribal nations outside of Maine work to eliminate unemployment, our tribe has rates that exceed that of Maine and Aroostook County. Without a tax base and limited economic development opportunities, it's difficult to generate private and public funding to supplement already underfunded programs such as housing, health, and social services. Many times addressing those priorities of our people, like preservation of our language and culture, which are the foundation of who we are dependent upon competitive national funding. The Indian Self-Determination Act of 1975 was a turning point for the United States to move away from assimilation and restore sovereignty to tribal nations within their lands. Recognizing our inherent sovereignty and access to these laws allows us to flourish in an equitable environment. This act does not create special rights. Its provisions are not unique. Rather, it places us where over 550 tribes across the nation are and have been for nearly 5 decades. Recognizing these rights brings our tribal nations and Maine forward together. This bill honors our self-determination and inherent rights and is a matter of fairness, dignity, and respect. So please join me in support of LD 1626. Thank you.
Thank you, Chief Sabattis. Committee members, are there any questions for Chief Sabattis? I'm not seeing any. We appreciate you providing testimony today in support of this legislation. Thank you. Next, we will hear from Chief Maggie Dana. And I'm also going to bring Vice Chief Daryl Newell over to the panel. Chief Dana, thank you very much for being here today, and you can begin your testimony whenever you're ready.
Thank you, everybody. I appreciate all your time today. I know it's going to be a long day, so I'll start. Dear Senator Carney, Representative Harnett, and members of the Judiciary Committee, thank you for the opportunity to address this committee. My name is Elizabeth Dana, and I'm the chief of the Passamaquoddy tribe at Zibayig, and I support LD 1626. I'm a member of the Wabanaki Confederacy. This is the Wabanaki territory that we stand on, and we still recognize this as our homeland. We always will. Before becoming chief in November 2020, I was the vice chief of my tribe, and I sat through all of the task force meetings and experienced the goodwill that developed. Your committee collaborated closely with the task force and generated significant momentum to ensure that the Wabanaki tribes enjoy the same rights, privileges, powers, and immunities as other federally recognized Indian tribes within the United States. And then came COVID-19. In my community, the delays of passing this legislation means that brown water will still come out of the tap during certain times of the year. It means parents will not bathe their children in the water pumped to their homes by a state-regulated utility. We continue to deliver bottled water out of the fear the water is not safe to drink. LD 1626 would change that. In recognition of our responsibility to care for our people, this legislation makes clear that our tribe is a sovereign nation. It removes senseless barriers to the basic yet critical task of getting clean water to our children. LD 1626 is an immense step in the right direction and will further improve the relationships between the tribe and the state agencies we engage with. This legislation would also allow us to finally make headway on the major issues facing our communities, like the water supply. As you will know, the responsibilities of government are great, and it is deeply problematic to run into any barrier that prevents you from doing your job effectively. We are here today because the Settlement Act has severely hindered our ability to do our jobs and to take care of our people. The tribal governments within Maine have persevered amidst barriers that the 570 other federally recognized tribes do not have. For decades, we have encountered many of the same challenges, but have been handicapped in our ability to adequately respond. I'm very happy to say that LD 1626 addresses two major barriers. This legislation removes provisions imposing state law on the tribes and their lands and makes it clear that federal law enacted for the benefit of Indians apply to the Wabanaki people too. The removal of these barriers come at a critical juncture. On top of all the other daily challenges our communities face, we are dealing with the unimaginable economic and health impacts of the pandemic. We need the ability to govern our people and our territories in the same way that other federally recognized tribes governs theirs. Our treaties with the Crown, with the Americans, and through the land claim settlement were all intended to make peace and create better relations for everyone. We committed to working with the task force and to effectively engage in modern treaty making. While the bill before you is still a compromise, it is a critical step forward and represents our shared goals for a better future. I know that we will make it through these challenging times because the Wabanaki people are a resilient people. We have survived despite displacement, sickness, poverty, trauma, and war. We survived, but we have paid a severe price over many, many generations. We continue to pay that price. Our beliefs are rooted in the relationship we have with one another and in our connection to this earth. For centuries, the Wabanaki and other indigenous political confederacies have had agreements to live amongst each other, ensuring that we thrive as communities. But in recognition of our responsibilities to future generations and the earth, like our ancestors, we are always willing to engage in dialogue, to come forward to help, to share, and to be good neighbors. For these reasons, I appreciate that the governor's office has been engaged in discussions with tribal attorneys for several months in efforts to find common ground between our respective sovereigns. These have been hard conversations. Some progress has been made, but much, much more work lies ahead. Please understand that the task before us is even more important now than it has been in our lifetimes. We are here to make a brighter, safer future for our children and our grandchildren and our future generations to come. Thank you for your attention to these critical issues, and please support LD 1626. Thank you.
Thank you very much, Chief Dana. Committee members, are there any questions for Chief Dana? Representative Babbage, go ahead.
Thank you very much, Madam Chair, and thank you for being here, Chief Dana. I have been aware, although it's never been before my committee, but I've been aware of the water issue down at Scipioc, and I am amazed that we haven't resolved this issue at this point. But could you clarify for me how this act might help us to improve the water situation down at Pleasant Point? Thank you.
Well, I think we'll be touching more on that on LD 906 on Thursday. So if you could hold off of that, thank you.
Sure. Thank you very much.
Any additional questions, committee members? Representative Babbage, did you have a second question, or is that a residual hand up? Thank you so much, Chief Dana, for speaking with the committee today.
Thank you all.
Next, we'll hear from Vice Chief Daryl Newell.
Walewan, Kulasi Kopa, Wally Spuzzwell, Kamaj Nolazwaltum Gazeltamagi Klawas Twamlania. I'm honored to be before you and to share a few words of our language that has been spoken here for thousands of years. And committee chairs, Senator Carney, Representative Harnett, and honorable members of the Judiciary Committee. My name is Daryl Newell. I'm Vice Chief of the Passamaquoddy here at Madocmigoog Indian Township. I also have the honor of serving as a commissioner on the Permanent Commission on the status of racial, indigenous, and tribal populations. I also sit on the board of directors for the Wabanaki Alliance. Last but not least, I was fortunate enough to represent our Passamaquoddy tribe at Madocmigoog to the task force on changes to the Maine Indian Land Claim Settlement Act, Implementing Act, which labored over proposed changes to the Settlement Act for a 6-month period in 2019. I had the honor of being among true warriors in tribal state leadership. Respectfully, I consider myself a sensitive man, and many of you have tugged at my heart this morning already. So I want to thank you for the truth. Thank you for allowing me to address you this morning in support of LD 1626, an act implementing the recommendations of the task force on changes to the Maine Indian Land Claim Settlement Implementing Act. This bill, LD 1626, is of great importance to our tribe. This legislation has the potential of being the pivotal point in beginning to heal our broken tribal state relations. It's important to note that the Maine Indian Claim Settlement was initiated by our tribes having a legitimate legal claim to more than 2/3 of what is now the state of Maine. The tribes in the state of Maine were mutually motivated in resolving this dispute over illegal transfer, the illegal taking of Indian land in violation of Federal Non-Intercourse Act. I spent much of 2019 in Augusta. The common theme that I regularly heard there was these Indians want special status. From my view, it is the state of Maine that has special status. The Maine Indian Land Claim Settlement Implementing Act afforded the state of Maine special status in tribal state relations, unlike any other state in the country. The only special status we have is having access to less federal legal protections and opportunities that other federally recognized tribes in the country have. That's no special status that I want. I had the honor of sitting among tribal state leadership on the task force on changes to the Maine Indian Land Claim Settlement Implementing Act, to which this bill refers. We spent hours over the summer and fall of 2019 trying to learn and educate each other on what tribal sovereignty means and how the status quo in Maine creates challenges for the Wabanaki tribes. This was truly a collaborative process that the legislature asked the tribes to engage in. We fully engaged after great reluctance, and it was a very productive process. I experienced and witnessed the true exercise of equal government to government relations. I was honored to participate in the deliberations to amend the historic Maine Indian land claim settlement. Indeed, this is historic. It's used in law school curriculum, instructing future legal professionals in what tribes ought not to do in tribal, state, and federal government dealings. The settlement remains an example of a terrible negotiating error that resulted in the loss of sacred, inherent, and sovereign tribal status. This occurred as a result of a systemic state orchestrated conspiracy to regain an oppressive superior status once held during the wars of the state era that lasted until we gained our federal recognition in the 1970s. I'm old enough to remember our tribes being wards of the state and living in a substandard living conditions. Our tribe was federally recognized in 1975, and I remember the federal recognition affording us the ability to better provide suitable living conditions and the ability to establish infrastructure with federal and state tribal resources. We were able to provide housing, water and sewer, improved health services, a new school. To me, sovereignty means inherently sacred, inalienable rights, which should never have been put on the negotiations table for debate and compromise. Where sovereignty exists, there is an equal government to government relationship. Tribal sovereignty is the right to make decisions for our people without outside interference. Our communities thrive when we ourselves can lead the efforts to protect our lands and people. And I've uttered these words many times. It's only a sentence, but I've uttered it to my colleagues and state leadership. And what I often say is that bits and pieces of limited sovereignty, which is what we currently have, is not sovereignty at all. This legislation, LD 1626, makes an attempt at restoring our sacred tribal sovereignty. I've been personally insulted over the past 40 years to be a member of a federally recognized tribe, the Passamaquoddy tribe, and to have the Maine Indian Land Claim Settlement Implementing Act specifically exempt me from any federal Indian laws passed after 1980. It's a no-brainer. Federal Indian law should apply to any and every federally recognized tribe in the country. It's insulting to know that natives in this state have less rights than natives in other places just because the state of Maine insists that it be this way. We have lived with a 40-year mistake in negotiations and settlement. LD 1626 would undo this 40-year-old violation of our sacred sovereignty and is the end result of years of long, hard work between tribal leaders and state legislators to recognize Wabanaki sovereignty. I urge you to pass LD 1626 so we might undo harms of the Maine Indian Land Claim Settlement Act and begin to restore the sacred inherent sovereign rights of our tribes. Chiwaliwan, thank you.
Thank you. Committee members, any questions for Vice Chief Newell? I am not seeing any. We appreciate your testimony today. Next, we'll hear from Vice Chief Ernie Neptune, and then we will hear from Lee Francis, who will be joining us shortly. Vice Chief Neptune, welcome to the committee.
Thank you. Thank you very much. Good morning. My name is Ernest Neptune. I'm the Vice Chief of the Passamaquoddy Tribe at Sibayig, also known as Pleasant Point. Thank you, Senator Carney, Representative Harnett, and the members of the Judiciary Committee for the opportunity to address you today. I am proud to testify, excuse me, in support LD 1626, and I'd like to start by commending your committee for the work done dating back to the task force of 2019 to gain a deep understanding of the topics covered by the bill before you today. The task force recommendations are the product of more than 40 years of working under a framework that has failed the tribes and negatively impacted the state as a whole. Today, we face very different circumstances from 2019, when the legislative leaders invited Wabanaki leaders to engage in an effort to re-examine and propose changes to the Maine Indian Land Claim Settlement Act. Unfortunately, the global pandemic cut off our momentous work to amend the settlement. However, the pandemic did not cut off our desire to self-govern and to be sovereign tribal nation like our brothers and sisters across Indian country. LD 1626 embodies the legislation's recognition that the Wabanaki nations should enjoy the same rights, privileges, powers, and immunities as other federally recognized tribes in the United States. Without such rights, we will remain severely limited in our ability to respond to the needs of our community, whether in the midst of a pandemic or not. Make no mistake, the tribe has persevered through these last 2 years, relying on our strong communal bonds and support from the federal government. When the COVID-19 pandemic hit, our government shut down and we went into survival mode. We all took on new jobs, whether coordinating the overall emergency response on the reservation, delivering food, or manning COVID-19 emergency checkpoints erected by the tribe to protect public health and safety. We relied on the ability to hunt and gather and fish to fill freezers for families on the reservation. The bottom line is that we know how to take care of our people. Our tribal government actually became stronger over the past year despite the odds. There's a toughness and grit among our people. Can we handle civil and criminal jurisdiction? Of course we can. It did not take long after the ink had dried before we started to see how the lopsided nature of the Settlement Act would suppress more than support us. You as elected representatives have the power to help right past wrongs. Our sovereignty has been diminished over centuries of conflict, exploitation, and suppression, but make no mistake, we are still a sovereign entity. We are sovereign that exercises jurisdiction over more than 100,000 acres of trust or reservation land, all of which is under tribal control in one form or another. LD 1626 addresses one of the Settlement Act's major problems by making clear that the laws of the state of Maine do not apply to the tribes or their respective lands, except as agreed to by the state and tribes, or as provided by federal law. Removal of this barrier will better enable us to enter in agreements with our neighbors for the benefit of all. We are not strangers to working with state to find strong solutions to challenges as they arise. For an example, some years ago when I was tribal forestry supervisor, both sovereigns agreed to waive product fees or road dues to vehicles who needed to cross state or tribal lands for forest products. We worked together to achieve a common goal in support of the logging industry, which is a major part of both of our communities and economies. We also have a strong working relationship with the state's Department of Marine Resources to protect fisheries, including the Elver's population and recent fishery, and to restore the health of the St. Croix River watershed, which is critically important to the economy of Washington County and the long-term survival of the Passamaquoddy people. Our environmental teams are leading the way to restore the St. Croix River watershed to benefit habitat restoration and revitalization of the ecosystem. In this vein, the tribe looks forward to seating a member of the DMR Advisory Council so we can work cooperatively with the state on salt water issues. Excuse me. Through this implementation of the bill, we hope to be able to work with the Commissioner of DMR more comprehensively in other fisheries in the bay that bears our name. We want to build on all of these efforts. whether it's enforcing of fish and game ordinances, maintaining tribal government services across the land over 100,000 acres, or working to bring economic development to Passamaquoddy territory and the surrounding areas. We are a sovereign government that is always working to protect, preserve, and improve the quality of life within our territory. At Pleasant Point, we employ over 100 tribal government employees. Our tribal government employs tribal and non-tribal members alike. We employ our non-tribal members and provide direct support on non-tribal members who live in our community, and yet the Settlement Act prevents us from holding such individuals accountable if they break our laws. Inconsistency makes no sense. LD 1626 ensures that we are able to govern ourselves and our territories, a necessary aspect of a fully functioning government. As I have said to this committee before, we are not here to fight about the past. We are here to fight for the future of our people and our environment. To do so, we have asked for the rights, privileges, and benefits and immunities enjoyed by other federally recognized tribes across the nation. LD 1626 does just that. Importantly, this bill also ensures the federal legislation enacted for the benefit of Indians applies to the tribes within Maine as well. This key aspect means that the tribes within the Maine are just like tribes around the country who work hand in hand with states every single day to improve their relationships under a federal Indian law framework. We were here to welcome the Europeans when they arrived in Maine. We showed the settlers how to survive off the land and water. We're still the same proud Passamaquoddy people. We want nothing more than to live in harmony with our neighbors in a safe and clean environment. With that in mind, let's work together to resolve our mutual concerns and to find a better path forward that is built upon government-to-government respect and cooperation. Thank you.
Thank you, Vice Chief Neptune. Committee members, any questions? Not seeing any. Once again, thank you for your testimony. Next, we will hear from, Penobscot Tribal Council member Lee Francis. Welcome.
Senator Carney, Representative Harnett, and members of the Judiciary Committee, my name is Lee Francis, and I am from the Penobscot Nation and humbly serve my people on Tribal Council. I'm here to testify in support of LD 1626. In looking at the words in Maine's Constitution adopted by your predecessors, the message is very, very clear. All are born equally free with inherent inalienable rights. There are powerful phrases embedded throughout the document: establish justice, promote common welfare, securing the people and their posterity the blessings of liberty, afford opportunity, pursue and obtain safety and happiness. These are words to live by. However, in this state, these words do not apply to the Penobscot, Passamaquoddy, Micmac, or Maliseet people, and your Constitution should be amended to reflect that. The very fact that this bill sits in front of you, the very fact that tribal leaders and supporters of tribal sovereignty waiting in line to provide testimony proves this point. 80 years ago, Florence Nicola Shea, my great-grandmother, presented these words. The treaties are merely useless pieces of paper today, as all promises have been broken. We are a segregated, alienated people, and many of us are beginning to feel the weight of the heel that is crushing us to nothingness. We are still in slavery, we are dictated to, and we are made to feel that we do not own our own souls. That is still applicable today. I am dedicated to my people. The love I have for my people, our elders and children, is genuine, immense, and true. And I want to use my voice today to specifically speak on behalf of our youth. The children in my community are watching and listening to the testimony being given today. They will hear the words spoken in support of our inherent, inalienable sovereign rights. They will hear words supporting tribal sovereignty. They will also hear words spoken against them. They know of our experiences, genocidal acts, massacres, bounties, scalp proclamations, infectious diseases, removal of children, forced assimilation, cultural genocide, Indian agents, and territorial removals at the hands of colonizers and their descendants. This is your history as well. How you respond to this bill will help provide them clarity on whether they too are deserving of justice, opportunity, freedom, safety, and happiness. This outcome will impact the direction their lives will take. Will they be able to stand side by side other youth in Maine, working government to government without one body striving to exert control and influence over the other? Or will they have to be prepared to continue this fight? I thank the committee for affording me the opportunity to speak. There is only one ethical and moral stand to take on this issue: uphold, support, and respect tribal sovereignty and the Wabanaki peoples of Maine. Supporting this shows my children that they are human, valued, recognized, accepted, and equal to others. Opposition teaches them they are viewed as less than. And I know that life. I have lived that life, and that is not what I want for our children. So I ask that all who have a voice in this, what do you want your legacy to be? Do you want to be a part of the solution and make a difference for all people, including the tribal children listening today? Or would you prefer to be the heel of the boot crushing them? Chiwaliwini.
Thank you, Councilmember Francis. Committee members, any questions? Not seeing any. We appreciate your testimony today. And next we'll hear from Ambassador Molly and Dana.
Thank you so much. We've all been on quite a journey together here. It's great to be back before you, and I prepared 3 minutes, so that's likely what I will give. But thank you for giving the tribal leaders and citizens the courtesy of no time limit. Good morning, Senator Carney, Representative Harnett, and members of the Judiciary Committee. My name is Molly and Dana. I serve as a Penobscot Nation Tribal Ambassador, and aside from being a mother, it is absolutely the highest honor of my life. I want to thank you for the time and effort you've given this historic and critical piece of legislation. Last May, I appeared here to remind you all of the resolution from the legislature that outlined the historic struggles for the tribes in Maine, and more importantly, how we can work through those together. The resolution called for a task force, and we are here today to honor that meaningful collaboration that occurred during that work. In the eyes of tribal leaders and citizens, that group of our chiefs, bipartisan lawmakers, and state officials, and the resulting recommendations that serve as the basis for this bill was a great and resounding success. We are thankful for these results and the work and care that was put into them. We are also, and I cannot stress this enough, thankful for the steadfast leadership of Assistant Majority Leader Rachel Talbot Ross. Her presentation today gave chills, gave tears, and inspired a whole state. We thank you, Representative. We also thank the co-sponsors who have testified in support today, all of our friends and allies in the two lawmaking bodies, and the coalition that we have built throughout Maine. LD 1626 allows us to realize a dream of amending a deal that hasn't worked for us. Deals often don't work out the way they were intended to, and it is never too late to set things right. It is time to extend federal law provisions to the tribes in Maine. It is time to extend tribal jurisdiction and stewardship over tribal lands, resources, waters, and people. There is no reason to not work together to accomplish these things in this moment. It is time to restore everything the tribes lost in 1980 when our backs were up against the wall and the effects of generations of poverty, theft of our land, resources, and children, and all the resulting trauma, that none of which was our fault, forced us to agree to this settlement. The problematic language in the Settlement Act has been suffocating and unlike anything any other tribes in the country have to contend with. We are not wards of this state. We are sovereign tribal nations. We are not municipalities. We are Wabanaki people who have been living in our homelands for thousands of years before Maine existed. It is time to heal old wounds and lift up some of the most marginalized and oppressed people in Maine. I'm proud to say we are also some of the strongest and most spirited people. We have come back to your table in good faith because we were asked to. I testify today to ask you to hear what we are requesting, to know that it is not unreasonable, it is not unfair, it is good for the tribes, it is good for all of Maine, and it is exactly the process and the policy that we have been wanting and needing and waiting for over 40 years. I want to also mention the members of my family whose shoulders I stand on as I speak for our people today. My father, former Chief Barry Dana, my mother, Indian Island school teacher Julia Sock-Beeson, my grandmother, former tribal council member Elizabeth Sock-Beeson, my grandmother, former tribal clerk Lorraine Dana, and the Honorable Donna Loring, Penobscot and legislative legend and loving mentor to me. I'm so thankful. I did submit some longer written remarks. I want to note that Representative Talbot Ross talked about the 2001 Northern paper versus Penobscot Nation and Passamaquoddy tribe. My father was one of the chiefs involved in that case. I remember it as a teenager. I remember feeling gutted at a very young age, watching what our people were going through because sovereignty was being denied and really trampled upon. And I remember we lost that court case, and in the protests around turning over those internal tribal documents, they called it a march for sovereignty, from a site in Norridgewock, Maine, where our people were massacred, to the State House in Augusta. And I remember thinking, sovereignty sure feels a lot like losing if this is what we're marching for. But maybe it also means protecting what is sacred, even when you haven't won yet. I urge you all to vote to pass today or in committee, and to also support this bill in both chambers. And I'm happy to take any questions. And I want to extend my gratitude to you all and for all the tribal leaders and citizens and allies and friends supporting this bill today. Thank you.
Committee members, are there any questions for Ambassador Dana? I'm not seeing any. Thank you very much for speaking with us today, Ambassador.
Thank you.
And I think that we have covered all of the elected officials of the Wabanaki nations. And so now we are going to next ask those who are tribal elders or other elders who wish to speak in favor of LD 1626 to please raise your hand. And again, keep it raised while you are on the attendee space, and we will bring you in one at a time. And we will first hear from Jill Tompkins. And this is for tribal elders and other elders who wish to be heard in favor of LD 1626. We'll hear from Jill Tompkins and Cyrilla Francis. And just as a note, from here forward, we are asking those who speak to the committee to please keep your remarks to 3 minutes and be aware that you may be asked questions by committee members. And Jill Tompkins, you may begin.
Thank you for the opportunity to testify in support of LD 1626. I am Jill Tompkins, a Penobscot Nation citizen. I'm the first Native American woman admitted to the bar of the state of Maine and possibly the first American Indian to graduate from the University of Maine School of Law. During my 3 years at law school, never once were American Indians, sovereign tribal nations, or the entire field of Indian law mentioned. It's the historic lack of attention paid to federal Indian law in Maine that brings us to where we are today. I did get on-the-job training in federal Indian law, first as a tribal court judge, and then as a clinical professor of law and director of the University of Colorado's American Indian Law Clinic. It is curious that federal Indian law has been buried out of sight for much of Maine's history, given that Maine's own Henry Knox, the first Secretary of War under the U.S. Constitution, was a close advisor to President Washington. It was Knox who persuaded Washington to choose the course of treaty making with tribes instead of going to war with them. But in short order, federal principles were subsumed in Maine through the hiding of Article 10, Section 5 of the Maine Constitution, which contains the state's treaty obligations, a series of Maine Supreme Judicial Court decisions in the 1800s obviating the treaties, and the Maine legislature passing laws such as Title 22. And it was not until 1975 that federal court decisions established that the U.S. had not divested the tribes of their sovereignty and that the state had no legal authority over them. Any current state authority over tribes or tribal territory in Maine is due to the tribe's sacrifice of sovereignty. Early in my career, I had a conversation with Professor Robert N. Clinton, who's a preeminent Indian law scholar, during which I complained about the Settlement Act and the fact that I was only 17 when it was passed. To my surprise, however, Professor Clinton said that the land claims litigation and the subsequent unique settlement was considered a high point of Indian law, federal Indian law. Governor Mills, in her veto of LD 554, expressed her lack of faith in a process that would require revisiting a tribal state arrangement in the future. She wrote, quote, "A pass it now, fix it later mentality is not appropriate and invites many unintended consequences." End quote. The pass it now, fix it later mentality criticized by Governor Mills is exactly the kind of thinking at work at the time of the Settlement Act's passage. Unfortunately, the tribal nations are now enduring the dire unintended consequences. What was characterized as a high point of federal Indian law has instead resulted in 42 years of intransigence. This bill will restore primacy to general federal Indian law principles and bring the Penobscot Nation, Passamaquoddy tribe, and the Holton Band of Maliseets closer to parity with more than 570 federally recognized tribes. I strongly encourage the committee to be part of making this a new high point of Indian law by voting ought to pass. Woolly one.
Thank you very much, Jill Tompkins. And I'm sorry, I was letting people onto the panel when you began to speak. Did you let us know where you reside and whether you represent any organization?
I reside on the Penobscot Nation Reservation on Indian Island, and I'm not representing any organization today, just as a tribal citizen.
Thank you so much, and thank you for your testimony today. Committee members, any questions? Not seeing any. Again, we appreciate your testimony. Next, we will hear from Cyrilla Francis. Welcome, and you may begin when you're ready.
Only one. Greetings, Senator Carney, Representative Harnett, and honorable members of the Joint Standing Committee on Judiciary. Gliwisnil Cyril, Beskadmukadnil, Zibayig Nujayaw Nagachik Nakchukdil Navemuk. My name is Cyrilla Francis, and I live in Zibayig, also known as Pleasant Point. I am here to testify in support of LD 1626. When I was growing up in the 1960s in a little village of approximately 300 Passamaquoddies, my family and I were recipients of the state and/or federal food commodities distributed by the Indian agent, a representative of the state. This experience was the first of many that told me we as Passamaquoddy people had no control over what we received. Therefore, what we ate affected how we lived our lives. Thankfully, this part of my life is no more. However, the feeling of not being in control of my life as a Passamaquoddy tribal citizen persists because I feel the state of Maine continues to dictate how we live our lives in many aspects. Self-governance is an inherent right we should be recognized to exercise. The self-rule would give us freedom to determine our economic, social, and cultural growth without interference from the state of Maine perceived jurisdictional authority. Currently, there are approximately 570 federally recognized tribes in the United States who exercise self-governance. We want to be treated as equals to other federally recognized tribes and regain the sovereignty once held prior to the Maine Land Claim Settlement Act. Today and the days ahead, you and other members of this legislature are being called upon to change the Maine Implementing Act. I ask that you do so. When the Wabanaki nations advance, so do the residents of Maine. Whenever we are fortunate enough to advance financially, so do the residents of Maine. You might ask why. Well, we live here in Maine and we spend here in Maine. This adds to the state's economy and will continue to because we are not going anywhere. Tahoe. I will be happy to answer any questions the committee may have.
Many thanks. Committee members, are there any questions? I'm not seeing any. Once again, thank you for being here today and providing testimony.
Only one.
I'll turn once again to the attendee room and ask if there is anyone who is a tribal or other elder who wishes to speak in support of LD 1626, to please raise your hand. And I am not seeing any hands raised. And so at this point, we will hear from others who wish to speak in support of LD 1626. I think that this will be quite a large number of people, and we'll begin, we'll take supporting testimony until 11:15 and then take a brief break. And so again, please use the electronic raise hand function. Raise your hand and keep your hand raised until you've joined the panel. Representative Newell.
Thank you, Madam Chair. If I may.
Yes.
Although I had previously intended to sit and listen, as all of you have, I have decided that I would comment. I want to say thank you to the students at Penobscot that are watching today. I want to say thank you to the students at Medokmiguk that are watching today. There's some uncertainty. I didn't receive confirmation as to whether or not our students at Sabayag Elementary School are watching today. We are grateful for the support that's been received from the Maine Indian Education that has allowed them to listen in on the proceedings today. With the understanding some of the words that they're going to hear are hard, but it's for the purpose. It is because of them that we are here today. I want to, if I may, Madam Chair, re-enter prior testimony that I submitted during 2 years ago on February 19th, 2020. We are nearing that time again, once again. So if I may, I will reread the testimony because I feel it is appropriate.
Thank you, Representative. Go ahead.
I had previously mentioned that I would follow in the order of the chiefs. And I decided to wait a little bit. And I thank you, Madam Chair, Representative Harnett, to receive my request in allowing tribal and non-tribal elders to speak. And that is why I chose to follow, rather not just my tribal chiefs, but to follow tribal and non-tribal elders in giving my comments today. Greetings, Senator Carney, Representative Harnett, and honorable members of the Joint Standing Committee on Judiciary. I stand to speak once again in support of this important piece of legislation, LD 1626, an act implementing the recommendations of the Task Force on Changes to the Maine Indian Claims Settlement Implementing Act. I am Rena Newell, a tribal citizen of Sabayak, proudly serving the Passamaquoddy tribe as tribal representative of the 130th Maine State Legislature. I humbly ask each of you to receive and reflect upon my words and the words of those before me and the words that will come following me. I give tremendous thanks and gratitude to the words received from the tribal chiefs, from the tribal vice chiefs, from Ambassador Dana, our tribal elders, and our non-tribal elders that have spoken before me. Today and the days ahead, we will come full circle to what was presented during the 129th legislature, that when I came into this role, there was no representation. I had to ask my Joint Tribal Council to be seated in the House. I was welcomed, and I have seen the work and the direction that we are going. However, as I previously mentioned, I do feel that what I had previously stated is still applicable today. I ask if you would consider a conversation that you have participated in on a subject that warranted change, that you found lasted a bit longer than you had anticipated in reaching a mutual and beneficial understanding. Now, I then make a comparison of these proceedings as well as other discussions throughout the years, which would contribute to a 200-year-old dialogue, one that began with the Wabanaki tribes that occupied this territory and the recognition of Maine statehood. I honor the voices of my ancestors who have stood many times throughout the last 200 years, advocating on behalf of or in response to changes in state policies that have directly impacted Wabanaki tribal communities and, more importantly, our way of life. For it is from their everlasting strength in the face of adversity, and despite the acknowledged treatment to which they endured, all of which have contributed to the determination and resilience of the Wabanaki tribes throughout the years. that I am able to stand here today to offer these words. Chi Willie Wun. Throughout this legislative process, I am certain that these discussions will once again echo the words from those same honored voices of the past. I would also recognize the voices of elected officials that we heard from earlier, such as yourselves and others within leadership, communities and organizations who are willing to stand and speak in support of making positive changes to improving the lives of all the citizens of Maine, which also include the tribal citizens of the Wabanaki tribes. Chi Willie Wun. Throughout this process, you may hear the words from many that the time has come to make changes to the Maine Implementing Act. And you may also hear the words that suggest that things must remain the same. I think you would agree that words are powerful and are derived from our thinking. The expression of words can often then set a tone, enlist a response from which can either promote or hinder a process of communication resulting in mutual understanding. In the past 3 years, I have witnessed and welcomed the changes to the laws that reflect a change in a way of thinking towards the Wabanaki tribes and promote a positive way of life, a more positive way of life for the next generations. I believe that the Wabanaki tribal governments and the Maine government are heading in that direction. But we cannot let uncertainty about what may happen get in the way of progress. We must take this opportunity to recognize and honor and appreciate the words that you've heard today and the words that you will hear in the days ahead. As we deliberate on this important piece of legislation that will change the direction for not only the tribal citizens, but for all the citizens of Maine. I ask each and every one of you to take this opportunity to recognize that the Maine tribes should absolutely enjoy the same rights, privileges, powers, and immunities as all federally recognized tribes within this nation that we call the United States. I thank you, Madam Chair, Representative Harnett, and honorable members of this committee in allowing me to speak despite my own thinking of withholding my words for a later time. Chi Willie Wun.
Thank you so much, Representative Newell. Committee members, does anybody have questions for our colleague? Not seeing any. Thanks once again. And now we'll take a few members of the public who wish to speak in favor of this legislation prior to taking our break. And we'll start with Lakota Sanborn. And I would ask that Representative Harnett, I know that you're going to be our timer. Could you please keep your electronic hand raised so that you're always in the upper left-hand corner of the screen? I think that will help people know where to look for you. Thank you. Lakota Sanborn, welcome to the Joint Standing Committee on the Judiciary. You may begin your testimony whenever you're ready.
Senator Carney, Representative Harnett, and honorable members of the Committee on Judiciary. My name is Lakota Sanborn. I'm a Penobscot community organizer. I'm here to testify in support of 1626. These revisions to the Act seek to redress systemic violations of inherent tribal sovereignty that the state of Maine has violated since the Act's adoption 40 years ago. The Settlement Act of 1980 was agreed upon in a state of desperation by the tribes. It has regrettably been the cause of irreparable harm to our communities. The state of Maine has repeatedly upheld its stance that it does not recognize the Wabanaki tribes as sovereign peoples. Maine utilized the act as the justification to steal the Penobscot River from the Penobscot Reservation. Maine used the act as the basis for its decision to attempt to prevent the Passamaquoddy at Sabayak from digging a well to provide the school children clean drinking water free from neurotoxins which have plagued their community's water supply. Maine continues to hold a boot heel to our throats whenever we attempt to exert the most fundamental principles of our rights as the first peoples in these lands. We are not wards of the state, as Mullion said. We are not asking for any special treatment in seeking these revisions, nor are these revisions what Janet Mills has termed sweeping changes. These changes ensure that Maine recognizes us in the same way that all other tribes across the nation are recognized. When Maine became a state, it created a treaty with the Wabanaki in 1820, stating it would assume all obligations, responsibilities, and duties to the tribe that Massachusetts once held. However, since its inception, the state of Maine has taken a racially charged paternalistic stance against the tribes, viewing us not as equals, but as less than human. The tribes took that settlement 40 years ago in dire economic situation caused by the illegal theft of our lands. The settlement was made amid political turmoil and heightening racist tensions exacerbated by state officials, industry leaders, and media alike. The act was agreed upon with the stipulation that further negotiations would be made and the document would effectively be a living one. However, in the past 40 years, it has remained untouched and utilized almost exclusively as a tool to undermine our inherent rights. The way the land claims have been interpreted is a blight on Maine's historical record, a blight that you have the ability to cease from recurring. We stand on the precipice of a historical moment that will be looked back upon by all of our descendants 40 years from now. Are we going to look back with shame, begging us to answer for what we had the power to change and refuse to? Or will we look back with pride? Or will they look back with pride in their parents and grandparents who had a role in ending this injustice? I wish nothing more than to tell my future children that I did all I could to make their homeland a better place for them, a place where the land will always respect and recognize them, and the inhabitants of the land will do the same. I implore you to seize this moment in time and take a stance to do what is right. Thank you.
Thank you. Committee members, are there any questions for Lakota Sanborn? I'm not seeing any. We appreciate your testimony today. And committee members and members of the public, that brings us to 11:15. And I would like at this time to take a brief 5-minute break. I would ask that if your hand is raised, please take it down for now. When we return, we will ask those speaking in opposition and then neither for nor against to speak, and then we will resume with proponents. And so again, if you could please lower your electronic hand and be rest assured that I will be calling for you to raise it again shortly after the break. Thank you very much. And Representative Newell, did you wish to speak before we break?
Yes, thank you, Madam Chair. I just wanted to just comment quickly before we take this break that I did receive confirmation that our students at Sabayak Elementary School are tuned in and are listening to this process. Thank you.
That's great news. Thank you for sharing. All right, everyone, we'll see you at 11:20. And committee members, please turn off your audio and video during the break. Thanks. Committee members, if you've had a chance to complete your break, could you please return to the committee meeting? Oops, and I'll be right back. Excuse me. Thank you, everyone. I think we are ready to resume. And I just want to give people a little update on where we are. I am going to turn the virtual gavel over to co-chair Harnett, and we are going to turn now to those who wish to speak in opposition, and then neither for nor against, and then return to those in favor. This is something that we typically do to alternate the speakers. And so with that, I will ask Representative Harnett to take over the chair. Thank you.
Thank you, Senator Carney. Welcome back all. I would ask again for people who are testifying in support to please lower your electronic hand so I can identify those who will be testifying in opposition and neither for nor against. I will remind everyone when you are brought over to the panel, which my committee clerk, Susan Panett, will do at my direction. Please, when you begin your testimony, introduce yourself, your place of residence, and whether or not you are here on behalf of an organization. So we will do this until 1 o'clock, at which point we will break for 1/2 hour. So I will now turn to persons who want to testify in opposition to LD 1626 to please raise your electronic hand. And I would ask the committee clerk to please move over the Governor's Counsel, Jerry Reed, to become a panelist. And I would remind all those testifying, we will have the 3-minute limit, and my co-chair will hold up her phone when there's about 15 seconds left, and then again when your time has expired. So Mr. Reed, as soon as you can, if you could activate your video and your microphone.
Good morning. Can you hear me okay?
We can. It looks like you're bathed in a halo of some sort, but it's
I assure you that's not a Zoom effect that I've paid for. It's completely unintentional.
Well, welcome to the Judiciary Committee, Mr. Reed. Please begin your testimony when you're comfortable.
Thank you. Good morning, Senator Carney and Representative Harnett, members of the Judiciary Committee. My name is Jerry Reed. I'm Chief Counsel to Governor Mills, and I'm here today to present testimony on LD 1626, a bill that would repeal and amend substantial portions of the Maine Implementing Act. I'd like to begin by saying a few words about why legislation that would amend the Implementing Act presents unique considerations that call for particular attention to detail. When the legislature amends the Implementing Act and the tribes consent to those amendments, the legislature cannot unilaterally repeal or amend new language in the future, even if it becomes clear that those amendments contain mistakes or reflect misunderstandings, unless the tribes also consent to those amendments. Amending the Implementing Act is the only context in which a sitting legislature can effectively bind its successors. Against that background, any sitting legislature considering amendments to the Implementing Act should proceed carefully and only when it has confidence that the meaning and potential consequences of the amendments are thoroughly understood. For the same reason, and to avoid disputes over interpretation, the language in any such amendments must be explicitly clear. The best way to achieve that level of clarity is to identify a specific problem that needs to be addressed and then put in as much time as it takes to develop precise language to resolve the issue at hand. The governor is not necessarily opposed to amending the Implementing Act. And in fact, we recently did amend the Implementing Act to expand tribal court jurisdiction over domestic violence offenses. But when amendments are being considered, it's critical that we avoid ambiguous language that could lead to future conflict or litigation. While we are not able to support LD 1626 as drafted, I'm happy to report that the administration and the tribes, with assistance from the Attorney General's office, have made significant progress toward an agreement that would cover some of the issues addressed in this bill. Last summer, we began meeting with representatives from the Holton Band of Maliseet Indians, the Passamaquoddy Tribe, and the Penobscot Nation to talk about how we could make meaningful progress in improving tribal-state relations. We identified several issues from those addressed in LD 1626 that we believe could both form the basis of an agreement and deliver substantial benefits to tribal communities, including a formal tribal-state collaboration process on certain state agency decisions that stand to impact the tribes, and changes to our tax laws that would support tribal communities. Our negotiated legislation will be the subject of a public hearing before this committee later this week, and I look forward to discussing that with you in more detail at that time. Thank you very much.
Thank you very much, Mr. Reed, for being with us today and presenting your testimony. Are there questions from committee members for the Governor's Counsel, Jerry Reed? If so, please raise your electronic hand. And Senator Carney, I'm going to assume your hand is up as the timer. Is that correct? It will stay up.
That is correct. It's so people can find me on the screen.
If for some reason you have a question at some point, just raise your hand. Seeing no questions from committee members, thank you very much for your testimony today, Mr. Reed. We greatly appreciate your time.
Thank you.
And I am going to go back to the attendee room, and I see two hands up, but one is a Ms. Ann O'Sullivan, the other is a Michael Alpert and a Carol Wise, but they are all persons who are testifying in support. So I'm going to hold off on those. And I would ask if there are any other persons in the attendee room who want to testify in opposition to LD 1626 to please raise your electronic hand. And again, I see Ann O'Sullivan with a hand up, but are you here to testify in opposition? You registered to testify in support. Okay, that was just an error then. Seeing no other persons who wish to testify in opposition to LD 1626, I will now turn to persons who wish to testify neither for nor against. Neither for nor against LD 1626. And I do know that we had two persons who indicated that they were in that category, and I see Maliseet Tribal Rep. I don't know who that is. If that is either Henry Bear or Dwayne Soktoma, I would ask the committee clerk to please move them over to a panelist. Thank you. And is that Henry Bear?
I think I've unmuted.
You have unmuted.
Morning.
Welcome to the Judiciary Committee. When you are comfortable, sir, please begin your testimony by giving us your name, residence, and any organization you represent. And thank you for being here.
Thank you. My name is Henry John Bear, and I am with the Aristic Treaty Education Center up here in the Ballistic Territory, present-day Aristic County. And I'm so pleased to have this opportunity to join the conversation. And I intend to be helpful and constructive, hopefully. I just want to greet tribal chiefs and elders and of course, Chairman Senator Carney, Representative Harnett, and the other members of your esteemed Maine State Legislature Standing Committee on the Judiciary. I recognize a lot of friends, Representative Babbage and others who I enjoyed serving with over the years when I was a representative in the legislature. I just want to reach out and say hello initially to all of you, Jeff Evangelos and the many others. Again, I am just one of, I'm representing myself, and I am speaking for our oldest Wabanaki tribal member, who is 94, tribal elder, Joseph Bernard is not with us due to COVID-19 risk, so he has asked me to speak his perspective as being part of mine, and I'm pleased to do so. I realize I have a 3-minute time frame. Perhaps you'll allow me to have, since there's only 2 of us who are going to be speaking neither for nor against, that you grant me the entire time that those who were in favor got. So that would give me about 2 hours speaking time. Would that be all right?
No, that would not be, sir. We are on a 3-minute clock for all persons.
Just want to make sure. Therefore, I'll rely on the written submission that I chopped together just yesterday for everyone to refer to. It's been filed in the testimony section, but I'll just summarize by saying first that we are 15,000 members strong as a Maliseet nation. We span many jurisdictions that we consider foreign, including Quebec and New Brunswick, Canada, and what Maine is claiming, in the northern part of the state as part of our watershed homeland in the St. John River. We are the St. John River Indians, as we are described in the 1776 treaty with the United States, and with previous treaties with England in 1725, 26, 49, and then with Great Britain in 1760. All treaties still valid, still enforceable, still being relied upon as the go-to law, the framework from which my perspective today will be coming from. The Passamaquoddy and the Maliseet are, hardly distinguishable. Similar language, distinct regions, Passamaquoddy Bay over to Machias for the Zibayak and Medakmikbuk Passamaquoddy, and to the north of them is our 8 Maliseet tribal governments, tribal bands situated throughout the watershed, the 20 million acre watershed to the north of the Passamaquoddy. We are in every respect considered ourselves as cousins of each other. I say that because they too, and I have had the honor as a tribal lawyer representing the Passamaquoddy in legal forums, they are of the same view in my experience, that treaties are our guide and in relations, and they're also the mechanism by which disputes are to be resolved and jurisdictions determined. It is clear, history, the record is clear that there are separate sovereign jurisdictions that we've agreed to with these foreign governments, whether it be England, Great Britain, or the United States. And that was laid down in 1776 with the United States as encompassing everything north of everything within the St. John River watershed as being a separate jurisdiction, including present-day Aroostook County. The problem with this proposed legislation is it will perpetuate a misunderstanding that we are, as Maliseets, as Abenaki, within Maine or within the United States. And because that's not accurate, the proposed legislation will perpetuate the flawed 1980 Settlement Act process. Settlement acts that in fact never were validated. The Maine legislature did not revisit in 1980 changes Congress had made to their proposed settlement, and therefore Section 31, a poison pill, killed that legislation before the United States Congress could ratify it later in 1980, in October of 1980. We have no basis for Maine to assert jurisdiction in these proceedings.
Mr. Bear, I'm going to need you to wrap up.
I will wrap up by saying I agree with the previous speakers, many of them, including Lakota Sanborn, that says that we are not wards, but we do not want to be treated like other tribes in the country. We are a nation that has a relationship with the United States, unlike all the other Western tribes. Read it for yourself. Read the Treaty of 1776. I will conclude by saying that we must do all we can, Lakota, for our children and grandchildren. That's what's at stake. The students listening must know that we are wealthy people. We own all the land, $20 billion worth of land. We cannot accept LD 1626 as written, or if ever.
Thank you.
Thank you for hearing me and treating me good, Senator or Representative Harnett.
Thank you very much, sir. And I know it's the three difficult time is a challenge.
Read my submission, please.
I saw your submission is quite lengthy, and I will read it. I saw it this morning. It's 16 pages, and I appreciate the time that you put into that.
We're the Maliseets are long-winded, and historically we are speech makers, and I'm trying to live up to that tradition for our children and grandchildren's sake. Thank you so much, everybody.
I think you did a fine job, sir. Are there questions from committee members for?
Please ask questions. Keep me on here. This is too important to limit me to 3 minutes.
Yes, sir. Representative Babich.
Representative Bear, good to see you. And I do this with trepidation, as everyone does when they call on me. But I would ask, what would you have us do? I will examine closely your testimony, but please leave us with a path forward, if you could.
Fair enough. I'm not going to be a problem without suggesting a solution. The solution I would suggest is stop this process and refer the issue of the treaty validity, the 1776 treaty that I referred to in my writings and in my thesis that I was able to get an A on when I got my Master of Law degree from the University of Maine School of Law. Look at my thesis, and I'll send it to everyone. My email is bearlaw2, BEARLAW2 @yahoo.com. I will send you the supporting legal documents, especially Jerry Reed, if you're listening still. I need your email. But also the path forward is to stop and refer this to the courts, who we trust, both the federal United States court, because this is a state tribal issue. The state courts cannot be used because they're inherently conflicted, because they have an interest in the outcome being in their favor. We need it to go to both the U.S. federal court, and if we're not satisfied, then it can go to the International Court of Justice, the ICJ at The Hague. I learned this because I went to the Maine School of Law. I got a law degree because I was a ward of the state in 5 good Maine foster homes who taught me to be a helpful citizen. But I also realized that when they let me go home to my home reserve, finally, and that I was one of 15,000 other Maliseet Indians on 8 Indian reservations. I grew up on 22 years in those communities, in that community of Tobic, and we consider ourselves to be one nation. We are benefiting, even if we're in Maine, from land claim monies that are sent to us, because we are considered by our Canadian home communities as still tribal members. It is a hypocrisy not to involve them in what we're doing here. They have not been invited. They must be. They must consent. All of this will affect all of our people, our Maliseet people. The Mi'kmaq even more. 140,000 Mi'kmaq Nation members, will be affected because it affects the treaty. This bill is intent on killing our treaties, and it's doing so through trickery, much like hiding, as the judge from the Penobscot, as Jillian pointed out, much like hiding the Article 10, Section 5, subsections 1 through 5 of Maine's 1820 Constitution was intended to do, to basically educate people into tribal extinction. Indians are not being taught treaties and their rights because it's not in Maine's public interest. It's not in their curriculums. I'm working hard to expand curriculum to include this information so that we can think critically about how we are organizing it together. Maine's a great organization, but it has limits and it doesn't include our territory yet. We have never transferred our territory to Maine in any legal way or otherwise. So anyway, that's my response. Refer it to the courts to determine the treaty rights. And then once we know that that's what we're affecting, then let's get back into this process and get the specific language to deal with actual problems. But Maine has no jurisdiction. The treaty trumps Maine and federal jurisdiction because it's part of the highest law of the land in both the U.S. Constitution and the Maine state constitution. I'm so excited that this process exists, but I cannot support it because there's no legal basis. There's no legal jurisdiction for Maine to grant gaming or grant tax exemptions or any of these baubles and offerings that are short of what we already possess. Thank you.
Thank you, sir. Do you have an additional question, Representative Babich, or does that?
I do not, Mr. Chair. Thank you very much.
Thank you. And if you could put your electronic hand down, I've got a lot of electronic hands up around here today. Are there additional questions from committee members for Mr. Henry Bear? Seeing none, again, thank you very much for your time and for the extensive testimony that you submitted in writing. We greatly appreciate it.
Please forgive the typos. Thank you.
And I know that most of the hands that I see up are for those who are testifying in support. I still need to exhaust those who are testifying neither for nor against. There was one person who signed up to testify to speak neither for nor against, and I mispronounced his last name. It's Dwayne Toma. If Dwayne Toma is in the attendee room, if you could please raise your hand so that I can call on you to testify neither for nor against. And I am not seeing that hand. If Mr. Toma appears later in the day, I will get back to him and provide him with an opportunity to testify. So with that, I will turn back to persons testifying in support of LD 1626, and I'm going to go in the order in which I see hands raised. I will have the committee clerk bring over one person at a time, starting with William Altvader. Well, I'm sorry, Altvader. As I wait for him to be moved over.
Can you hear me?
I can hear you. Can you activate your video? Is that
I will
possible?
try. Let's see.
Thank you.
Looks kind of funny on the screen. First of all, my name is William Eric Altvader.
Altvader, I apologize.
I'm a member of the Passamaquoddy tribe from Pleasant Point. And I have, hopefully I can squeeze this in within 3 minutes. If I can't, I hope you give me a few more seconds. I have a written testimony that I prepared. I can tell you much, but does it matter? I can tell you that in the 1960s, my parents were wary of any land claim settlement, but who cares what they thought? I can tell you that my parents feared the commodification of our land and exploitation of other natural resources, but what does that matter? I can tell you that my parents feared the land claim settlement would breed greed and division amongst our people, but who cares? I can tell you the so-called great state of Maine, by the way of the justice system and in cahoots with the state police, planted, falsely accused, arrested, and charged attorney Don Jellers as a felon for possession of a few marijuana cigarettes. But so what? I can also tell you that the judicial system failed Peter Francis, who was murdered by 5 hunters from Massachusetts who came onto the res in Pleasant Point looking for girls, and in the process brutally beat my uncle, Christy Altfader. But this is of no consequence, is it? As a matter of fact, when the hunters went to trial and were found not guilty, everyone in the courtroom but tribal members stood up and cheered. After all, it's just another dead Indian, right? It is very surreal that the judiciary is holding these hearings. It is the judicial branch of the state of Maine that has failed us, the original inhabitants of this land. I can express that the final land claims document, as approved by the United States Congress in 1980, is a document that is blatantly racially discriminating as a result of language inserted by then Senator Bill Cohen. Senator Bill Cohen, who we refer to as the Terminator, added language in the United States Senate subcommittee insert in section 6204A. That section states, and I paraphrase, any legislation enacted from this day forward for the benefit of Indians in the rest of the USA will not apply in Maine. Of what consequence is it that the land claim settlement of 1980 is racially framed and codified? Does it even matter to this committee? If one part of the settlement is racially biased, then the entire settlement is racially biased, and in my opinion, should be thrown out. The land claims was agreed to as a result of fraud, duress, and undue influence. Fraud. If you don't settle now, you will never get a better deal. Duress. Carter, a Democrat, is now president. And if Reagan, a Republican, gets in, you'll get nothing. Undue influence. The promise of riches to those living in poverty while being racially discriminated against by whites.
Thank you, Mr. Altvader. I'm going to need you to wrap up your testimony. I've let you go a little beyond the 3 minutes.
I wanted to get to the heart of the matter, but okay.
Then you will be able to respond to questions from committee members. It's just that we have over 100 people who are going to be testifying, so I have to treat everyone
I was
equally.
hoping to let some of my passion shine through, but I guess that's not possible.
Are there questions from committee members for Mr. Altvader? And Representative Newell.
Thank you, Mr. Chair. Thank you, Mr. Altvader. Good morning, Eric. Is there an additional statement that you would like to provide to this committee in your closing?
Well, what I would like to say is that the land claim settlement of 1980 has extensive language regarding lakes, rivers, streams, ponds, forests, land, mountains, hills, and the like, but is silent on saltwater and saltwater fishing rights. Passamaquoddy means people who spear pollock. You can't spear pollock in fresh water. When I was lieutenant governor back in late 90s, I sat on the MITSIC, Maine Indian Tribal State Commission, with a gentleman by the name of Richard Cohen. Richard Cohen was the Attorney General in the negotiations during the land claim settlement. And I asked Mr. Cohen on several occasions, did the tribe give up rights to saltwater and saltwater fishing resources as a result of the 1980 land claim settlement? To which he responded on more than several occasions. Saltwater and saltwater resources were never discussed to any substantive degree in the negotiations leading up to the land claim settlement, which begs the question, how can you give up rights to something that was never discussed? In the normal world, you can't, and you don't. But Native Americans have never had the benefit of a normal world. Since the first day Catholicism espoused the doctrine of discovery by Pope Alexander VI, which includes all doctrines, policies, and practices based on advocating superiority of people or individuals on the basis of natural origin or racial, religious, ethnic, or cultural differences, we have never had the benefit of a normal world. Finally, I got more here. I'm gonna have a drink of water. Please bear with me. My mouth's getting dry. if I had one request to make of the committee at this point in time, would be to educate yourself on what Mr. Bear was just talking about, and that's the 1776 Treaty of Peace and Friendship. We are way more than municipalities. Thank you very much.
Thank you very much, Mr. Altivator. Do you have any additional questions, Representative Newell?
No, thank you, Mr. Chair. Thank you, Mr. Altivator. Thank you, Eric Wooley-One, for being here today.
Thank you very much, committee members, for listening to me. And I understand there's a lot of people, but thank you.
Then there is an additional question from Representative Babbage, I believe.
Mr. Chair, I merely wanted to give Mr. Altvader the chance to give his summary that he was looking forward to. So I have no questions. Thank you.
Thank you, Representative Babbage. Thank you very much, Mr. Altivator, for spending time with us this afternoon. We greatly appreciate it this morning.
Have a good day.
The next person in the queue is it was Jason Grunston Whitney. I hope I'm getting that name correct. When you are ready, please activate your microphone and begin your 3-minute testimony, and welcome to the Judiciary Committee.
Thank you, Madam Chair, and thank you, Representative Harnett. And yes, you did get my name correct. I'm a adopted son of Joanna Dana, and I'm here from Monmouth, Maine. So you can find this testimony on the site itself, but I would like to read as far as I can go. In the 1950s, my parents were not allowed admittance into Oklahoma bars or stores, as Indians and dogs were not permitted. It has been interesting and heartening to see the Supreme Court has recently honored treaties in Oklahoma. In the 1960s, as a child in Arizona, I remember hearing the children who were tending sheep on the Navajo Diné Reservation were abducted by the state and taken to schools far from their home. Sometimes a note was found from the state and parents were not allowed to say goodbye. My mother spent years in the 60s fighting as an advocate through schools for civil rights and fair and decent education for people of color. Being born of color in America is to be born into malignancy. The malicious nature of racism takes multiple forms in application by law and daily interaction of people. It is baffling, uncanny, and brutal in that it robs people of color from basic rights as human beings, as well as success in the vaunted nature of the so-called American dream. In 1980, the Maine Indian Claims Act was signed, which allowed for tribes' ownerships of property, but deprived the tribes of their full sovereignty. In effect, the Settlement Act treated tribes as municipalities and prevented the tribes from 40 years of benefits from federal laws designed to assist and support tribal sovereignty, safety, and health. In effect, it has created an adversarial relationship as the state treats the tribes as wards of the state. The same state that has not allowed gaming fought tribes over fishing rights and clean water, and the multitude of law over 40 years that has disempowered the original people of the state of Maine. This year, we have the opportunity to right the wrongs of the 1980 Settlement Act and allow sovereignty for the tribes through LD 1626, an act to implement the recommendations of the Task Force on Changes to the Maine Indian Claims Settlement Act. So as we would do with any advantageous disease, let us contain and treat it so that the better nature of our collective soul may shine by voting for this piece of legislation. Let us bring sovereignty back to the tribes of Maine. Across Turtle Island, research shows that when the tribes thrive economically, the surrounding areas do as well. The ability to make your own choices to develop such economies is paramount to the tribes of the state of Maine. We cannot afford not to pass this legislation, as it will affect the entire state. Most importantly, regaining sovereignty and losing the moniker of ward will help to cleanse the collective soul of Maine. Until we do this, the malignancy of racism will be legion in nature, finding new ways to choke and hold down cultures that thrive on identity and compassion to the world and all beings in it. Like my parents, I too have suffered ill will, having been arrested for no just cause, beaten, pepper sprayed, and in the presence of elders, I've seen them taunted and insulted for just being native. The state of Maine is in a defining point in its history. We can choose to do what's right and decent, working on expunging institutional and systemic racism, or we can
Jason, I need you to wrap up. I apologize. If you could wrap up in a sentence or two, please.
We have the opportunity to live to our reputation in Maine to do the right thing. I can think of no better time to exercise this expression. Please pass LD 1626.
Thank you very much for your time and your testimony today. Are there questions from committee members? Representative, you're okay, Representative Babbage?
I am. You can hear me, can't you?
Oh, we can hear you.
My computer requires multiple clicks in order for it to work for some reason, so I apologize.
Okay. Thank you very much. I'm sorry, Senator Carney.
I just wanted to suggest, and I know that you are the chair at this point, Representative Harnett, but I know that lots of people are running out of time, and we just encourage them to let us know that there is additional information in their written testimony, and we'll be sure to take a look at that. I know it's very hard. The 3 minutes is hard, particularly on this bill. Thank you.
I agree, and I thank you for that. And it is a challenge. I'm just trying to treat everyone the same so we can work our way through this testimony. But we greatly appreciate your time. And I would remind committee members that the written testimony is contained in the electronic file. So again, thank you for being here today. We greatly appreciate your time.
Fully one.
Fully one. And I will next call upon, it's going to be a tough day for me with names, Riley Gaetjens.
Gaetjens, yes, correct.
Oh, wow, 1 for 1. Thank you and welcome to the Judiciary Committee. Thank you for being here today. Please begin your 3-minute testimony when you are comfortable. And I want to remind everyone testifying, and I will have to do this on occasion, please let us know your town of residence and if you represent an organization. But go ahead, please.
Hello, committee members. Thank you for allowing me to speak today. And thank you to all the tribal leaders and representatives for allowing me to speak today. My name is Riley Gaetjens. I'm from Limerick, Maine. I'm a social work student at the University of Southern Maine and a direct support worker. I'll begin by saying that as a white person, it is my job to use my privilege when called to lift up and strengthen the voices of people of color, today specifically Maine Indigenous tribes. I'm here not only because I believe it is the right thing to do, but it is the least that I can do in the face of a white supremacist society. I come from a naive perspective, as I've only learned a small amount about the Indigenous tribes in Maine from the classes that I did not take until I was a junior in college. It took a documentary called Dawnland going behind the scenes of the Maine Wabanaki Truth and Reconciliation Committee to truly open my eyes to the outright racism and travesties committed against Indigenous tribes in Maine, a state I've called home for 23 years, and yet I do not truly understand and appreciate this land the way the Indigenous people being stewards of this land do. Indigenous tribes in Maine have missed out on benefiting from 150 federal laws that were passed in 1980. This bill would resolve this issue. We are wasting taxpayers' money by allowing Maine to fight back with tribes in court over current Maine laws that would be resolved with this bill. This would reallocate Maine's money to be spent elsewhere. Maine tribes have also been unable to purchase 33% of the land that they are permitted to buy. Why are we fighting over something that Indigenous people elsewhere already have the right to do? I urge you to pass this bill and recognize Indigenous tribes in Maine as the other 570 Indigenous tribes are federally recognized. I truly hope that you all go a step further to research and understand the crimes against Indigenous people, and I hope that your support for them does not end here. Thank you very much.
Thank you very much for your testimony today. We greatly appreciate your being here and taking the time. Are there questions from committee members for Riley? I am not seeing any. So again, thank you very much for your time and testimony. I will next call upon Davida Ammerman. And again, I apologize if I mispronounced the first name. As soon as you're ready, if you could activate your camera and microphone, and it's nice to see you again. Please begin your testimony when you're comfortable.
Thank you much. Thank you, Senator Carney and Representative Harnett, other members of the Joint Committee on Judicial. I appreciate the chance to talk here. I did submit some written testimony. I'm IT challenged, so I can't pull it up and read it. So I'll have to put up with some ad-libbing. I live in Down East Maine, South Addison. I grew up in Maine. I've been here most of my life. I've hunted, I've fished, I've enjoyed the beauty we have in Maine, the great resources we have. And I always feel kind of guilty because I know it's not mine. I know that I have ancestors that took land from the Indians, from the native tribes in Minnesota, Michigan. I walk beaches down east and I find shards of arrowheads and things. I see middens. I can feel the energy there. I understand what a carrying place is. When I look at the highways that were used for thousands of years before we came here, I look at the way we've treated the Native Americans, a genocide, cultural genocide, a total disrespect to their culture. People in the tribes that I have come to meet, know, talk with, I hear about things like how they view the nature, the relationships they have with every living being on Earth, the respect for nature, knowing that they need to keep that nature intact for their future generations, for our future generations, native or not. We need to learn the lessons that they are trying to teach us. And we can't do it unless we respect them as people and respect their knowledge. The knowledge of plants and medicines, it's incredible. And I have great respect for that. And I urge you, please, to pass 1626. I think it's very important. And I appreciate your time. Thank you very much.
Thank you very much for your time and testimony today. We greatly appreciate it. Are there questions from committee members? I am not seeing any. Again, thank you very much for your time and testimony. And I do note that it was filed in our electronic file, so we can pull it up even if you were unable to access it.
Thank you all very much. And I ask you again to please support this important bill. Thank you.
Thank you. I will next call upon Dana Colohan. Good morning, good afternoon now. As soon as you are comfortable, please begin your testimony with an introduction. Thank you.
Thank you. Senator Carney, Representative Harnett, and members of the Judiciary Committee. My name is Dana Colohan, and I'm the Maine State Director for Community Action Works campaigns, and I strongly support LD 1626. At Community Action Works campaigns, we believe that environmental threats are big, but the power of well-organized community groups is bigger. And that's why we work side by side with everyday people to confront those who are polluting and harming the health of our communities. All too often, Indigenous communities, Black communities, low-income communities bear the brunt of environmental pollution. Maine is no exception. We've seen this occur at the state-owned Juniper Ridge landfill. The landfill threatens drinking water for the region and discharges minimally treated toxic leachate containing PFAS into the Penobscot River. This is one of the many things contaminating the waters that Penobscot tribal members have used for fishing for thousands of years, contaminating a sacred relative. PFAS are also known as forever chemicals. They're a class of toxic man-made chemicals that have found their way into our drinking water, deer, milk, and environment through leaking landfills, leachate, as well as sludge spreading. PFAS have been linked to serious health effects across the board, like testicular and kidney cancer, among many other issues. And I'm sure all of you know that this continues to reveal itself to be a huge issue in Maine. Pollution like this is not only a threat to public health and the environment, but causes even more harm to Indigenous communities when it occurs on tribal lands. If tribes' inherent sovereignty had never been violated, we would not be in this mess. Because of the historic and continued injustice Maine tribes have experienced environmentally and beyond, the state must repair the harm that it's caused. The state needs to respect tribal sovereignty. Passing LD 1626 is a vital step in this direction. This act restores the rights of the Passamaquoddy tribe, the Penobscot Nation, the Houlton Band of Maliseet Indians to regulate natural resources, fishing, and hunting on tribal land. Who could better control these resources than their original stewards? Beyond the environmental recommendations, LD 1626 reestablishes tribal sovereignty over critical issues like criminal and civil jurisdiction, taxation, and education. It is unconscionable for the state to impede tribal authority any longer. I urge the committee to listen to the tribes, respect tribal sovereignty, and pass LD 1626. Thank you.
Thank you very much, Dana. We greatly appreciate your time and testimony today. Are there questions from committee members for Dana Callahan? I am not seeing any. So again, thank you very much for your time. And I am, I'm seeing the texts in the chat about trying to give people a heads up. We're moving a few people over at a time. What I will try to do every now and then is let the next 5 people know who will be moved over next. And that is Amy Eshu, Allison Bea, Sarah Brake, Adam Lee, and then Adam Zuckerman. And I will try to do that as often as I remember. And I will now call upon Barbara Acosta, who is our next person to testify. Welcome to the Judiciary Committee. Please begin your 3-minute testimony as soon as you are comfortable.
Good afternoon, Senator Carney, Representative Harnett, and the distinguished members of the Joint Standing Committee on the Judiciary. My name is Barbara Acosta. I'm a resident of Trenton, and I'm chair of the Peace and Social Action Ministry of the Unitarian Universalist Church of Ellsworth. Our ministry is unified in support of the passage of LD 1626. We acknowledge that the Wabanaki people occupied this land we call Maine for over 12,000 years, long before European settlers arrived. They cared for its rivers, lakes, and forests in ways that we would do well to honor and emulate. As Unitarian Universalists, we recognize that the ancestors of many of us, including my own, have committed grave atrocities against the Wabanaki people that continue to reverberate today. I've submitted a written testimony, but right now I'm going to speak from my heart. I am the mother of 2 daughters whose blood runs with the blood of Mayan Indians. And because my blood runs in them, they have enjoyed rights and privileges that the Wabanaki people of Maine do not. I sometimes imagine what would have happened if they were born as Wabanaki in Maine, what life would have been like for them, for my children, if they had had to endure what the Wabanaki still endure today. And this has taught me, having my 2 daughters with both cultural heritages, has taught me that the Wabanaki are our people. This separation is an illusion that has harmed all of us. It has harmed the Wabanaki deeply, and it has harmed we who have violated their rights. Their children are our children. We share a history which unfortunately is based on distrust, fear, and separation. We share a history that involves theft of land, separation of children from their families, genocide, and ongoing violations of their inherent sovereignty. The laws of Maine were created to embed these injustices and perpetuate this legacy based on a misconception that Wabanaki and Indigenous people are somehow less than European Americans. This is an injustice, and it is shameful if we don't address it. We do not have to live in shame. It is time for us to heal. It is time for us to right the wrongs. And therefore, I strongly support LD 1626. When one of us suffers injustice, we all suffer injustice. When our neighbors thrive, we all thrive. Thank you for your time.
Thank you very much, Barbara Acosta, for your testimony today. We greatly appreciate it. Are there questions from committee members for Barbara Acosta? If so, please raise your electronic hand. And not seeing any, again, I thank you very much for your time and testimony today. I will next turn to Abigail Bradford. Welcome, Abigail. As soon as you are comfortable, please begin your 3-minute testimony with an introduction to the committee.
Thank you. Good morning, Senator Carney, Representative Harnett, and members of the Judiciary Committee. My name is Abigail Bradford. I live in Hamden, Maine, and today I'm testifying in support of LD 1626, an act implementing the recommendations of the Task Force on Changes to the Maine Indian Claims Settlement Implementing Act. This is a lengthy bill, but I ask that you do not let that distract you. The decision before you is simple. Do you or do you not believe that the Wabanaki tribes have the right to self-govern? All 470 other federally recognized tribes in America do. Maine is alone in this. The state of Maine should not have sought to take away the Wabanaki tribe's inherent rights to self-govern during the 1980 land claim settlement and should not continue to uphold this singular and harmful arrangement now. That is why nearly 1,500 Maine people have submitted testimony in favor of LD 1626 today. Decision makers who oppose or are undecided on LD 1626 often cite that it is long and complicated or that we do not know what its consequences will be. To put this in perspective, does the state of Maine analyze every detail of how New Hampshire exercises its criminal jurisdiction within New Hampshire? Does the state of Maine worry about the consequences of how Quebec exercises its civil jurisdiction within Quebec? No, because though we share borders, the state of Maine has no authority over other states or countries. The Wabanaki tribes are sovereign nations whose territories happen to be largely surrounded by the state of Maine, but that gives the state of Maine no more right to dictate what happens on the lands of the tribes than of any other neighbor. I think this simple principle is enough to illustrate that the current legal relationship between the state of Maine and the Wabanaki tribes is unfair. But when you put this in the context of our history and the purpose of the 1980 land claim settlement, you see that what the Wabanaki tribes are asking for is minuscule in comparison to what has been taken from them. This is not ancient history, it is recent history, and it is ongoing. The Wabanaki people welcomed my direct ancestors, and perhaps some of yours, to these shores 400 years ago. If you lined up the lives of people who lived to be 100, that happened only 4 lifetimes ago. In the lifespan of just 4 people, European settlers and their descendants, some of whom are still alive today, directly and indirectly killed and removed 96% of Wabanaki people, outlawed and repressed their culture, separated children from families, kept tribal members in dire poverty, and stole almost all of their land. In 1975, the U.S. District Court ruled that the Passamaquoddy tribe and the Penobscot Indian Nation still had legal claim to 60% of the land in Maine. I'm now going to skip over a portion of my testimony because I see I'm running out of time, but you can find that in writing. But I'll end by saying, in the dark shadow of our history, this would be passing LD 1626 would be a relatively small step for the state of Maine to take. But the path of healing ahead of us is long, and we should not delay any longer in taking this first step. Thank you for your attention, and I'm happy to answer any questions.
Abigail, thank you very much for your time and testimony and for wrapping it up when you saw the clock. I know how difficult that can be. Are there questions from committee members for Abigail Bradford? I am not seeing any. So again, thank you very much for your time and testimony. And I'm just going to give a heads up to we have two people that have been moved over as panelists. After that, it will be Sarah Brake, Adam Lee, Adam Zuckerman, Lakota Sanborn, although I believe Lakota had testified earlier today. We'll deal with that when it comes time. And then Jeremy Kluge or Clucci. So with that, Amy Esho.
Thank you. Senator
Welcome.
Carney, Representative Harnett, members of the Committee on Judiciary, Tribal Chiefs and Elders. My name is Amy Eshu. I am residing on traditional Wabanaki land, now called North Yarmouth. I'm the program director of 350 Maine, a statewide grassroots climate justice organization of almost 3,000 members. As an organization, we fight for climate justice, and climate justice is environmental justice. The tribes in Maine have been stewards on the land and natural resources for millennia, living in relationship with the land and waters here, managing the natural resources so that future generations could thrive. But with colonialism came destruction to the environment, and now the climate crisis is accelerating at an alarming rate. To face this climate crisis, 350 Maine knows that we need to embrace contributions of both Indigenous and Western ways of knowing. We must fuse Indigenous and Western knowledge systems to find solutions and paths to a healthy future for our people and our planet. For us settlers to go forward with the Wabanaki tribes on an ongoing journey of learning together, we must do so as equals. With tribal sovereignty, we would restore the Wabanaki tribe's ability to manage tribal lands, waters, and resources. As equals, those of us using Western ways could work alongside those with Indigenous ways to together protect our world for our children and for future generations. Climate justice is social justice. We have an opportunity here to change a system of inequity. Equity and restorative justice must be centered going forward so that we can stand together and work together as equals. 350 Maine believes the state of Maine should recognize the Wabanaki tribe's inherent sovereignty. The Wabanaki tribes are not asking for special privileges. They are asking for fairness and equity to be treated like the other federally recognized tribes across the country. The Wabanaki tribe's sovereign rights should never have been revoked and urgently need to be restored. 350 Maine believes firmly that this is our issue too. Please vote ought to pass and support in LD 1626 in both chambers for climate justice. Thank you for your time.
Thank you very much, Amy Eshu. We greatly appreciate your time and taking that time to deliver your testimony today. Are there questions from committee members? I am not seeing any. So again, thank you very much for your time. Greatly appreciate it. I will next call upon Michael Cabetta. Nice to see you again, Mr. Cabetta. Please begin your testimony as soon as you feel comfortable.
Thank you, Representative Harnett. Great to see you and the rest of the committee as well. Senator Carney and members of the committee, good afternoon. I'm Michael Cabetta, Policy Counsel for the ACLU of Maine. I'm delivering this testimony on behalf of the ACLU of Maine's Executive Director, Allison B.A., and the ACLU Indigenous Justice Working Group. On behalf of our members, we support this bill, which will assure that the Passamaquoddy tribe, the Penobscot Nation, and the Houlton Band of Maliseet Indians enjoy the same rights, privileges, and immunities as other federally recognized Indian tribes across the country. Of all bills this session, this bill ought to pass. This bill aligns with the nationwide trend toward enhancing tribal sovereignty and arises out of a detailed and thorough task force process. For at least the past 25 years, the United States, numerous state and local governments, and countries around the world have dedicated themselves to protecting and promoting the rights of Indigenous peoples. This is reflected, for instance, in the signing by every member of the United Nations, including the United States, of the United Nations Declaration on the Rights of Indigenous Peoples. This commitment stems from a recognition that many Indigenous peoples were treated unjustly and unfairly, and that all states have an obligation and moral duty to promote Indigenous recovery and recognize Indigenous rights. In Alaska, for instance, as recently as 1988, the Alaska Supreme Court held that the Native villages in Alaska are, quote, not self-governing or in any meaningful sense sovereign. 11 years later, however, that same court reversed itself and held that the Native villages in the state possess the inherent powers of self-government. The tribal nations in Maine are among those who suffered mightily at the hands of the United States, and in some respects still do. The improvements provided by this bill are both reasonable and modest, and not a single one of them is different than the benefits the vast majority of other tribal nations already possess. Several concerns have been raised about certain provisions of this bill. Our written testimony attempts to rebut some of these objections, but I will not repeat the objections or rebuttals now. Suffice it for now to say that all land in what is currently the United States and all land in what is currently Maine is Indigenous land, upon which Indigenous people have been stewards since time immemorial. The United States was founded on the dispossession and genocide of Indigenous peoples, and Maine and institutions within Maine continue to benefit from those acts and from the attempted erasure of Indigenous peoples. This is a truth that must be acknowledged, and its acknowledgement carries with it the obligation to redress these wrongs. The recommendations of the task force are a laudable starting place to enhance tribal sovereignty for tribal nations. I urge you not to only vote ought to pass, but to remember that your work for tribal rights, our work as relative newcomers to this region of the world, neither started with this bill nor should end with it. Thank you for your time and attention, and I'm happy to try to answer questions.
Thank you very much, Michael. We appreciate your time and testimony. It's always good to see you in front of the committee. Are there questions from committee members for Michael Cabetta? And I am not seeing any. Again, thank you for your the testimony you presented and that you submitted as well.
Thank you, Representative.
Really appreciated. The next person to testify is Sarah, is it Brake?
Brake.
Brake. Okay.
Yes.
Welcome to the
Thank
Judiciary Committee. Please begin your testimony as soon as you feel comfortable.
Senator Carney, Representative Hartnett, and members of the Judiciary Committee. My name is Sarah Brake. I live in Portland, and I'm testifying on behalf of Citizens Climate Lobby Maine, which has 2,300 members across the state. CCL Maine supports the restoration of sovereignty to the Maine tribes because it is only fair that Maine's tribes are treated like the 570 other federally recognized tribes. Our mission is to create the political will for a livable world. And a livable world is one in which all people are treated fairly and have equal access to clean air, food, and water. Currently, tribes in Maine are unable to benefit from the more than 150 federal laws passed since 1980, missing out on opportunities for economic development, increased access to healthcare, to respond to natural disasters, and to expand environmental protections. LD 1626 would ensure that the Wabanaki tribes are treated like all other federally recognized tribes. The Wabanaki were responsible stewards of Maine lands and waters for over a millennium before the arrival of the Europeans. Although the land they own and the additional land that LD 1626 would grant them opportunity to purchase constitutes a minute fraction of Maine's total acreage, the tribes have demonstrated their ability and determination to continue responsibly managing their land. As Paul Jakes and Ray Bucky Owen attest in their February 13th Bangor Daily News op-ed, the Wabanaki have taught their children the importance of respect, moderation, and observation of nature, values we newcomers have not always honored or even espoused, values that we violate to our peril, as the climate crisis so clearly reminds us. Jakes and Owen credit tribal leader Lewis Mitchell for inspiring Senator Ed Muskie, who shepherded the Clean Water Act into law in 1972. Muskie understood that healthy Maine woods and waters were essential to Mainers' health, recreation, economy, and way of life. Owen worked with the Penobscot Nation to restore the Penobscot River and credits its success to the leadership of the Penobscot Nation's then Director of Natural Resources, John Banks, who instilled a sense of community within the divergent parties, who then, quote, began to think of themselves as part of the river system, not as the domineering force. We all still have much to learn from the Wabanakis' relationship with the earth. Thank you for accepting my testimony on behalf of Citizens Climate Lobby Maine. I have also provided written testimony with a few more details. We urge you to grant the tribes parity with other federally recognized tribes as a matter of fairness and environmental stewardship. When the Maine tribes prosper, we all prosper. Securing the tribe's future will help protect the environment, which is so important to our identity as Mainers. Thank you.
Thank you very much, Sarah. Are there questions from committee members for Sarah Brake? I am not seeing any. So again, thank you very much for your testimony as well as the written testimony that you submitted. We greatly appreciate it. Before turning to our next person to testify, I would ask the clerk to please move over Adam Zuckerman, Jeremy Kluke, and Sarah Freshly. And with that, I will turn to Adam Lee. Adam, welcome to the Judiciary Committee. Please begin your 3-minute testimony as soon as you are comfortable.
Thank you. My name's Adam Lee. I'm chairman of Lee Auto Malls. I am from Cumberland, Maine. I want to thank the chairs of the committee, Senator Ann Carney and Representative Tom Harnett, and the sponsor of this bill, Representative Rachel Talbot Ross, and all of the tribal representatives for hearing this bill and allowing us to testify today. I am testifying in support of this bill. My family has lived in Maine for over 100 years. My grandparents fled Eastern Europe to avoid being persecuted for being Jews. They ended up in Maine and prospered here. They came here to start a new life and for freedom. I'm a second-generation Mainer. My children are third, and I'm proud of that. The Seaside Inn in Kennebunkport, Maine has been in continuous operation by the same family since 1667. That's over 350 years. They're managed by the 12th generation of the Gooch family. I think it's safe to say no one from Maine would refer to them as being from away. And I'd ask all of you a simple question. Have you ever referred to someone not born in Maine as being from away? I certainly have. Far be it from me to put words in your mouth, but I'm guessing that every one of you has used that expression. Being from Maine means a lot to everyone from Maine. Now, I want you to think for a minute about how impressive a 12th generation business is and the fact that family has lived here for 350 years. Now think about the Wabanaki, the people of the Dawn, who've lived here not for 350 years, not 1,000 years, not even 5,000 years. Archaeologists believe they have lived here for over 13,000 years since the last ice age. The Wabanaki believe they have lived here since time immemorial, and I prefer to believe that too. Why should a group of people that once populated all of Maine since the beginning of time have to ask permission to do anything? Why should they have to ask permission to drill a well on their own land? Why should they even have to ask for tribal sovereignty? The Wabanaki are the only people in Maine who are not from away. Please pass this bill and make sure that should it get vetoed, you're bold enough to override that veto. Thank you.
Thank you very much, Adam Lee, for your time and testimony today. The committee greatly appreciates it. Are there questions from committee members for Adam Lee? If so, please raise your electronic hand. And I am not seeing any. So again, thank you very much for your time today. Greatly appreciate it. I will next turn to Adam Zuckerman. Welcome, Adam, to the Judiciary Committee. Please begin your 3-minute testimony as soon as you are comfortable.
Great. Thank you for having me today. And I appreciate you all taking so much time today for such an important issue. Senator Carney, Representative Harnett, and members of the Judiciary Committee. My name is Adam Zuckerman, and I'm the lobbyist for the Maine People's Alliance. Our 32,000 members stretch from Kittery to Fort Kent, and we are committed to creating a state of Maine where everyone has what they need, everyone contributes what they can, and no one is left behind. I'm glad to testify in support of LD 1626 in implementing the recommendations of the Task Force on Changes to the Maine Indian Claims Settlement Implementing Act. Before moving back to Maine, I spent 4 years supporting the struggles of Indigenous peoples in the Amazon rainforest. Over the course of 3 decades, Texaco, now owned by Chevron, deliberately dumped 18 billion gallons of toxic wastewater into unlined pits throughout the Ecuadorian Amazon, contaminating an area the size of Rhode Island and poisoning 30,000 people, many of them Indigenous. It created a legacy of cancer, cultural devastation, and trauma. The company had polluted their waterways, their rainforest, and the clearings where they grew their crops. With that, it devastated their culture, leading to a legacy of trauma and alcoholism. There I met Emergildo Criollo, the president of the COFAN. Walking through his territory, he told me how he lost 2 of his children to cancer. Then he bent down, reached into the soil, and pulled out a tiny ball of tar. 20 years after Chevron left, the impact of their operations were as real as ever. The 4 years I spent working with communities like Emergildo's showed me what happens when we trample on Indigenous rights. It showed me what happens when we deny Indigenous peoples their inherent sovereignty. Then I came home and I learned about Juniper Ridge. I learned how every year our state is allowing companies to dump 200,000 tons of waste, much of it toxic, into landfills right next to the Penobscot Reservation in Old Town. I learned about Maine tribes being denied water rights on their territory. I learned that as a state, we deny the Wabanaki tribes the right to even govern themselves, excluding it from the rights that tribes in every other state enjoy. When I heard Emergildo's story, I was devastated how his government had denied the COFAN their rights. I never imagined that it was also happening in my home state. I urge you to respect the sovereignty of Maine's tribes and follow the guidance of your former colleague, Congressman Jared Golden. As he noted in his op-ed in the Bangor Daily News, after 40 years, it's long past time for us to ask ourselves if this agreement could use an update. It is time to modernize tribal-state relations and fully recognize the sovereignty of Maine tribes. Thank you, and with that, I'll take any questions.
Thank you very much, Adam. We greatly appreciate your being here with us today and offering your testimony. Are there questions for Adam Zuckerman from committee members? Seeing none, thank you very much. We greatly appreciate your time. And before I turn to the next person to testify, I would ask the committee clerk to please move over Sarah Freshley and Charlene Virgilio. Welcome, Jeremy Kluge. I think I've pronounced your name 3 different ways already today. I'll let you tell me the correct one as soon as you're comfortable to begin your testimony.
Thank you very much, Senator Carney, Representative Harnett, and distinguished members of the Judiciary Committee. I appreciate the opportunity to testify in support of LD 1626 and recognition of the sovereignty of the Wabanaki tribes in Maine. My name is Jeremy Kluge. I live in the town of Bodenham, and I'm currently in my 6th year of service as a select person on the Bodenham Select Board. Our town is known for its rich agriculture, its wildlife from ducks to smelt, and its natural beauty. The people who live here love it for these reasons and many more. Before it was Bodenham, this area was part of the Wabanaki Confederacy. The Kennebec and the Androscoggin rivers meet here in Merrymeeting Bay. Like so many other things in Maine, these rivers inherited their names from the indigenous people who lived along them and cared for them for thousands of years. Abenaki, Arosaguntakuk, Nanrantsuak. Much of the history of how this land was taken from its original caretakers has not been widely shared. I certainly didn't learn it in school. But today that is starting to change. And as it does, we're all having to reckon with the atrocities of colonization, atrocities from which those of us who are non-native have all benefited. Understanding how the land on which we live, work, build, shop, and play was in many cases brutally wrested from indigenous people changes our relationship to it, as it should. The more I've learned about this history, the more strongly I've come to believe that recognizing the sovereignty of the Wabanaki tribes in Maine is absolutely necessary. In truth, I think it is actually the least we can do, but it would also be a very important step down a long and challenging path toward reconciliation. All of us in Maine stand to benefit from the state and the Wabanaki tribes partnering on things like protecting the environment, strengthening the economy, and building an equitable society. True partnership has to be built on a foundation of mutual respect and trust that can only come from the state of Maine's recognition of the Wabanaki tribe's inherent sovereignty. This bill is a momentous opportunity for the legislature and for all Mainers. I sincerely hope you will seize it and pass LD 1626. Thank you for your time, for your service to the state, and I'm happy to answer any questions.
Thank you very much, Jeremy Clucci, for your testimony today. Greatly appreciate it. And I think that's the fourth way I pronounced your name, but glad that I have it accurate.
You nailed it that time.
Okay. Are there questions from committee members for Jeremy Clucci? Seeing none, thank you very much for your time today. We greatly appreciate it. And I would next call upon Sarah Freshley. As soon as you are comfortable, please activate your video and your audio and begin your 3-minute testimony.
Hello all, my name is Sarah and I reside in Portland, Maine. Senator Carney, Representative Harnett, and honorable members of the Judiciary Committee. It is well past time to do your part. Since European contact with the Wabanaki tribes in the 1600s, the tribes have experienced a 96% depletion in population. Throughout this time, the state of Maine has been complicit in the oppression of tribal survival through the deprivation of resources, access to Maine economy, and the abduction of Indigenous children. The negotiations and litigation surrounding the Maine Implementing Act and the Maine Indian Land Claim Settlement Act in the 1970s were an opportunity for the state to engage in a meaningful, mutually beneficial relationship with the tribes. However, as we know, the state did not take this opportunity and has increasingly relied on narrow interpretations of the settlement, leaving no room for tribal growth. Because of this restricted relationship, Maine is considered one of the worst states for tribal-state relations. This is shameful. Although many of the decisions were not made by those in this meeting, they were made by the people in positions of power you are in now. You state leaders are faced with a choice. This history of how this state and this nation have treated tribes is abhorrent, and you have the decision today to start to reconcile and heal with past aggressions, racism, and oppression. This legislation does not even ask for the whole gamut of what the tribal nations in Maine should be entitled to. The tribes only ask to be treated the same as every other tribe under the United States federal government. To not even grant them that would be unjust and cruel. Despite the blatant racism and brutality that the federal government has forced onto tribal nations for generations, its trusteeship has recently been less detrimental. It is more beneficial to the tribal nations than Maine's current position. There is nothing to fear. There are countless stories of successful government-to-government relationships between tribal nations and states and other communities. It is not us versus them. When the tribal community thrives, the surrounding community does as well. The tribal nations of Maine have so much to offer. Please get out of their way of presence and sovereignty. This is step one in undoing generations of harm. I implore you to do what you know is right and pass LD 1626. Thank you for your time and leadership.
Thank you very much, Sarah Freshley, for your testimony today. We greatly appreciate you taking the time to deliver it. Are there questions from committee members for Sarah Freshley? I am not seeing any, so again, thank you very much for your time today. I will now turn to Charlene Virgilio. Please begin your 3-minute testimony as soon as you are comfortable.
Thank you. And thank you to the members of the committee for allowing me to testify in support of this legislation. I've also submitted written testimony. My name is Charlene Virgilio. I am a member of the Penobscot Nation and live in Old Town. I am here today as the Executive Director of Four Directions Development Corporation, which is a Native American community development financial institution located in Orono, Maine. Our mission is to improve the social and economic conditions of the Wabanaki tribes through education, investment in affordable housing, business ventures, and entrepreneurs. Over 20 years, we have closed $18 million in home, small business, community loans, and have delivered more than 3,500 hours of financial counseling and group and homebuyer education. Despite these results, along with efforts of the tribes, there still remains significant economic barriers. Our organization conducted a significant data gathering to learn more about the needs and challenges, and learned a lot of different facts, but I only present a few today. 75% of our tribal members are on housing waiting lists, and the lack of funding impedes our ability to address the housing shortfall. Dependency on federal funding ranges from 51 to 100%, while 75% of tribal business entities are not generating enough revenue to offset those dependencies. Unemployment ranges from 12 to 60%, while poverty ranges from 36 to 65%, far more drastic than the areas located near tribal communities. We also looked at the census data, which yielded similar results, basically showing our tribal areas experience far more economic distress than the surrounding counties and Maine as a whole. Local economies in the reservations and trust lands of all of our tribes showed a 4% decrease in median family income from 2010 to 2019, while Maine showed a 27% increase. In addition to the high poverty and unemployment rates, only 57% of our residents have access to broadband internet versus 87% enjoyed in the rest of Maine. These numbers represent significant inequities which must be remedied. For 20 years, Four Directions has been an advocate and partner with the tribes, but the needs are far greater than what we or the tribes can do alone. After 40 years of experiencing the adverse consequences resulting from the Implementation Act, combined with the data we see, it is clear foundational change is required. The economic playing field must be leveled. This change can start now through your support of LD 1626, which can lead to tribal self-determination, sovereignty, and prosperity. Thank you for allowing me to testify in support of LD 1626.
Thank you very much, Charlene. We greatly appreciate your testimony today. Are there questions from committee members for Charlene Virgilio? I am not seeing any. I'm sorry, Senator Carney.
Thank you very much. Thank you for your testimony. I'm assuming that Four Directions has a website, and could you please let us know what the web address is for Four Directions?
Yes, I'll put it in the chat, but it's Four Directions Development Corp.
Don't put it in the chat because we're having a hard time with the chat right now. But is it FOUR?
Yes, Directions. Four Directions.
Thank you so much, and thanks for your testimony.
Okay.
Thank you. And I need to address the chat a bit. The chat is really for technical assistance, and we're getting an awful lot of conversation in the chat, and it is very difficult to follow as we're trying to chair a meeting and getting people to testify when we have so many members of the public that want to speak. So to the extent you have a technical question, please feel free to use the chat. Otherwise, if you could refrain, that would be very helpful.
And in closing, I'll share the whole address then. It's 4directionsmaine.org. Thank you.
Thank you. Thank you very much. And before turning to our next person to testify, I would ask the clerk to please move over Karen Luthi, Carol Wise, and Glennon Friedman. And I will now turn to Molly Obumsawin Odanik. Hope I got that close to right. As soon as you are comfortable, could you please activate your video and audio and begin your testimony? Welcome to the Judiciary Committee.
Thank you. Quiet Deluisi Malio Bomswin. I'm from the Odanak Benaki First Nation. I live in Cornish, and I am representing just myself and my nation, who are the Wabanaki people that many of us were expelled from Western and Central Maine in the 1700s. I am speaking in support of LD 1626. The passage of LD 1626 is a matter of justice. It is a matter of restoring sovereignty for Wabanaki tribes so they are on equal footing with 570 recognized tribes in all other states. And I want to re-emphasize what Representative Collings stated earlier, that justice and sovereignty for Indigenous peoples has not destroyed any other state in the US, and it will not destroy Maine. Now, while none of the other federally recognized tribes who enjoy their guaranteed rights are in perfectly enviable positions, I think it speaks to how uniquely oppressive the relationship is between Maine and Wabanaki tribes, that they have fought so hard to be on equal footing with other recognized tribes. As Vice Chief Daryl Newell stated, Wabanaki people are not asking for special status. It is Maine that has given itself special status through the Implementing Act, which goes against all precedent in federal Indian law and among other tribes. The Commerce Clause, which refers to Article 1, Section 8, Clause 3 of the U.S. Constitution, gives Congress the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. So just as Maine and foreign nations deal with the federal government and with Congress in the government-to-government relations, so should the tribes, which includes the Wabanaki. This is a foundational and central tenet of U.S.-Indian relations as defined by the Constitution, and it is violated by the Implementing Act. It is not a metaphor, but a statement of historical fact that the Wabanaki governments are at least 12,800 years older than the Maine government, and it is a mockery that the state claims itself to be more fit to govern the Wabanaki people than the ancient governments. It is a clear fallacy considering how tribes are treated under the thumb of Maine. Wabanaki people are never going away. You have the power to kick the can down the road or give Wabanaki people justice now. Restore Wabanaki rights. You cannot steal Wabanaki sovereignty. You can deny that it exists and pretend it is not our inherent status, but Indigenous peoples will always be sovereign because our sovereignty comes from the land itself. One way or another, this will be recognized. And I don't believe that it is a good use of time to carry it on for another generation in legislature. I think based on Jerry Reed's testimony, we should be prepared for a veto from Mills, and as Mr. Lee stated, have the morality to override it. In the throes of war and the defense of our land throughout the 1700s, our ancestors said, as long as we have living descendants, they will fight to defend and protect our homelands, and we are here. Waiwani, thank you for having me.
Thank you very much, Molly, for your time and testimony today. We greatly appreciate your being here. Are there questions from committee members? I am not seeing any. So again, thank you very much for your time and testimony. I will now turn to Carol Wise. Carol, if you could activate your video and microphone. Welcome to the Judiciary Committee. Thank you for being here. Please begin your 3-minute testimony as soon as you're comfortable.
Thank you very much, everybody. Good morning and welcome Doorway to Doorway. My name is Carol Wise and I currently live in Brunswick, and I acknowledge it is Wabanaki territory. I'm in support of LD 1626. I don't represent any organization, but I am here to bear witness to this moral and ethical issue, long overdue. While I remain hopeful to trust the leadership of the state, I believe this is not time for politics. It is a time to do what's right, and I know that what's right and not to act is doubly wrong. As a born and raised Mainer, I am reminded of the saying, as Maine goes, so goes the nation. But in our treatment of and our relationship with Wabanaki tribes, we lag behind many states. If we look at failed legislation, promises unkept, we have to in this time make it right. I look at this not through governmental or political eyes, but my personal experience of living on both Hopi and Navajo tribal lands for 8 years of the 13 years I lived and worked in the Southwest. I went there to teach, but I soon realized I had much to learn. I learned the true meaning of community, not to be hurtful, to help one another, to leave no one behind, to listen well, to understand and to care for Mother Earth.
I learned to slow down and to live with purpose. I also observed and experienced that one is taken just as they are with no prejudice. If, as a people of Maine, we sat together at the table with openness and fairness, I can just imagine how much we would create and grow together. There is an authentic civility in Native culture that I learned, and we can learn much about genuine stewardship of the land and treatment of one another. Another example that I can speak to is a partnership that began in Washington County back in 1981 when I held a teaching position at the University of Maine in Machias. The program was developed in a partnership at Greenland Point, Passamaquoddy, and the University of Maine at Machias. Its purpose was to create programs for kids and communities, and the goal and benefit to support connections to the outdoors, stewardship of natural resources through leadership and mentoring. 40 years later, I hear it has become statewide. Moving forward, the conversation must be inclusive conversation. We as a people must honor and respect tribal governance. That I am a non-native invited to sit at the table today is a bit hypocritical in matters of what impacts tribal lives. The tribal communities must be at the table, they must be listened to, they must be heard, and the goal that I see today is a framework that benefits everybody. So here we are again, many times, the tribes reaching out in good faith and trust, knowing what they need, and we fail them. We're not listening well. This is not about shame or blame, but it's rather, let us take up this opportunity to make this right in supporting LD 1626. Let us not create any more excuses or detours. And in closing, if we continue to allow fear or any egregious behavior to become the go-to framework in how the leadership in the state makes decisions, I believe we will lose significant and authentic opportunities for partnerships, especially as we want to move forward together. The time is now and here. With gratitude, Wallawan. Thank you.
Thank you very much, Carol, for being here today and providing us with your testimony and insight. The committee greatly appreciates it. Are there questions from committee members for Carol Wise? If so, please raise your electronic hand. And I am not seeing any. So again, thank you very much for your time today. We greatly appreciate it.
Thank you.
Before turning to our next person to testify, I will let members of the public know we're having some difficulty with moving some people over into the panelist room. We are working on that. I am going to ask the committee clerk to please move over Margot Lukens. And then we will listen to two more testimonies and then break for a half an hour. So I will begin by welcoming Glennon Friedman to the Judiciary Committee. Please welcome, and please begin your 3-minute testimony as soon as you're comfortable, Glennon.
Thank you very much. I am adding my voice in speaking in support of LD 1626. My name is Glennon Friedman, and I live in Bar Harbor, Maine, and I speak for myself. Please follow the recommendations of the Task Force on Changes to the Maine Indian Claim Settlement Implementing Act, a bipartisan task force, which came after 6 months of research, hearings, and careful consideration. Acknowledge tribal sovereignty and put Maine tribes on an equal footing with 570 other federally recognized tribes in 49 states. This is one important step toward repairing the deep injustice of colonialism and its horrific impact on the lives of the first inhabitants of Maine. I, as a white woman, have a moral responsibility to acknowledge the damages my ancestors have wrought and continue to perpetuate on the land and on Indigenous communities, and to do everything I can to right these wrongs. Currently, we are facing a climate catastrophe. Evidence suggests that this challenge is tangled with the environmental injustice propagated by colonial attitudes toward Indigenous people. In the state of Maine, we can take the step of passing LD 1626 to start untangling the mess we have created, restore a measure of fairness, restore a people's rightful sovereignty over their land, and sleep better at night, knowing that we have just bent the arc of justice a little bit more toward peace. Thank you very much.
Thank you very much for your time today and presenting your testimony to the committee. We greatly appreciate it. Are there questions from committee members for Glennon Friedman? I am not seeing any, so again, thank you very much for your time. I will now turn to our final person testifying until we break. And I welcome to the Judiciary Committee, Margot Lukens. Margot, please begin your 3-minute testimony as soon as you're comfortable.
Thank you, Representative Harnett and members of the Judiciary Committee. My name is Margot Lukens, and I live in Orono, Maine. For the past 30 years, I've made my home and livelihood here as a professor at the University of Maine. And so since 1992, I've been learning about Wabanaki history and culture and doing my best to transmit what I learned to my students. Over these years, I've also developed many relationships with Wabanaki people who have been students in my classes, colleagues, collaborators, fellow thespians, or simply friends. I want to testify in support of LD 1626 because my relationships with Penobscot and other Wabanaki people are central to the work I do as a college professor, as a volunteer, and as a citizen of the state of Maine. My most recent publication project is a volume I worked on with Carol Dana, who's the language carrier of the Penobscot Nation. It's a volume called Still They Remember Me, Bilingual Transformer Tales. Carol Dana saw the need for a new publication of traditional stories in her language to bring young Penobscot people back to their birthright. A central story in this collection tells of the genesis of the Penobscot River, when Aglabemo, the giant frog, held back all the water, making people die of thirst. The hero Gluskabe made him release it. The water flowed out and became the Penobscot River and all its tributaries. Some of the thirsty people went in the water and never came out. They became river creatures, but their relatives on land never forgot their family relationships and even named their clans after river creatures. This is an ancient story of Penobscot people that connects them intimately and permanently with the river and its beings. Having worked closely with this story and others like it, I've seen the terrible irony of our state, where the government of Maine has worked for the past 2 centuries to disempower the tribes of Maine and to separate them from the land and waters of their traditional territory. LD 1626 will give the tribes of Maine the right to determine their community's futures. They should have that right on their native lands without obstruction from the state of Maine. When tribal communities finally have the right of self-determination, it will benefit all of us who live in Maine. For millennia, the tribes in Maine have been good stewards of the land and natural resources. The traditional literatures teach the value of conserving resources, specifically for the benefit of generations to come. Securing the future of Wabanaki tribes will help protect Maine's environment for everyone who lives here. I want to thank the committee for hearing our testimony on LD 1626, and I urge your support in the committee, in the House and Senate, and as others have stated, if in response to a veto. This bill gives us the opportunity to stand by our tribal neighbors, and when they prosper, Maine will prosper as well. Thank you very much.
Thank you very much, Margot Lukens. Greatly appreciate your time and testimony and spending your time with us this afternoon. Are there questions from committee members for Margot Lukens? And I am not seeing any, so again, thank you. And before we break, I have a question for Supi. I see Carol Wise is still in as a panelist, and I thought we heard from Carol Wise. Am I confused there?
No, I may have missed her with all the switching, so I will definitely move her back.
What? No, I see her. Okay, she said she did speak.
She did
Okay.
speak. Thank you so much. I missed that.
Thank you. We will be breaking for a half an hour. We will get together at, yes, Ms. Luthi, we're trying to figure out why we're having difficulty moving you over. We'll work on that during the break. We will break until 1:30. As a reminder to committee members, please shut off your camera and audio. The first 5 people that we will call when we come back will be Karen Luthi, hopefully, Catherine Harvey, Jean Conzel, John Diefenbacher Krall, and Ann O'Sullivan. See you all at 1:30. Thank you very much.
Good afternoon, committee members. If you have returned to your desks, could you please activate your video so that we know who is back? Thank you, everyone.
Two, three, four, six. Do you want me to start up, Ann, or you want to give it a couple minutes? We're just at 7. We're just at.
I think we do have a quorum, and I know that others will begin other committee members will return briefly.
Sure.
I'm assuming that members of the public have returned as well, so I think it's okay to get going.
All right. Welcome back to the Judiciary Committee for our continuation of the public hearing on LD 1626. I want to give you an outline for the afternoon and address some just sort of issues that we're dealing with. First of all, thank everybody for their patience today. To say that Zoom hearings present challenges on a regular basis would be an understatement. To say that they present challenges when there are 100 people who want to testify is a fact. A couple of things for the members of the public. Everybody who wants to testify will be heard, period. Don't worry about that. To that end, please keep your electronic hands up so we can get through the entire list of people that need to testify. We don't want to miss anyone. And the third thing is the chat function is not helpful to those who are trying to run the meeting. The chat function is really for technical questions. It can be confusing when people are asking more than that. Asking where they're going to be in the testimony line, et cetera. We're going through the testimony as people are listed in the attendee room. And again, we will get to everyone. So please refrain from using the chat unless it's a technical question that you need answered immediately in terms of dealing with not being able to get into a room or something, not being able to get from attendee status to panelist status. I do see somebody who we had trouble getting over. We do have over Karen Luthi, which is great. So keep that in mind for the afternoon. The way we're going to run this is I'm going to turn the virtual gavel back over to my Senate co-chair, Senator Carney. She will run more public testimony, and we're dealing just with proponents at this point until 3 o'clock. We will then take a break at 3. We'll give you the length of that break at 3 o'clock. It'll probably be 15 to 30 minutes, and then we will finish up any testimony that we have not heard. So with that, I thank you all for your patience, and we'll turn it back over to Senator Carney.
Thank you very much. And I just wanted to also express appreciation for everybody's patience today. I know that there are many people in line, and everybody is eager to provide their testimony. And rest assured, we will get to you. We will update you when we take our 3 o'clock break, how long that break will be. So let's begin with, and now I've lost her on the screen. Karen Luthi. Welcome to the Judiciary Committee, and you may begin your testimony. And just a note that Co-Chair Harnett will be keeping time, and he's in the upper right-hand corner of the screen.
And I will put my phone up first when it's 20 seconds left, and then you will see a yellow, you're out of time, when you're out of time. So.
Okay, thank you so much. And I also want to thank everyone who has testified and spoken already. It's been a really enlightening conversation. Senator Carney, Representative Harnett, and honorable members of the Committee on Judiciary. My name is Karen Luthi, and I live in Camden. I'm the founder of Suit Up Maine, an independent all-volunteer constituent action group representing more than 5,000 Mainers in all 16 counties. I offer this testimony in support of LD 1626. Maine's government has a long history of breaking promises to the Wabanaki people, resulting in deeply ingrained generational trauma that remains to this day. We applaud the efforts of Maine legislators and Governor Mills for acknowledging that harm and for remaining open to remedies that restore good faith and trust between parties. The Bipartisan Task Force on Changes to the Indian Claims Settlement Implementing Act performed a critical role in this effort by highlighting longstanding causes of friction and making recommendations to address them based on mutual agreement and benefit. For 4 decades, the state and the courts have used language in the settlement to treat tribes as municipalities, depriving them of sovereignty they never ceded to the state. Under the settlement, tribes in Maine have been unable to benefit from more than 150 federal laws passed since 1980, missing out on opportunities for economic development, increased access to healthcare, expanded environmental protections, enhanced K-12 education, and legislation that fostered job creation, ensured safe drinking water, and strengthened laws regarding prevention and prosecution of sexual assault and domestic violence. We agree with tribal leaders who argue that the act is a failed experiment, and with the 2012 report from the Maine Indian Tribal State Commission, which found that the settlement created structural inequities that have resulted in conditions that have risen to the level of human rights violations. The importance of the task force's work cannot be understated. Their recommended changes to the implementing act are essential to demonstrating in good faith that Maine recognizes the Passamaquoddy tribe, Penobscot Nation, and Holton Band of Maliseet Indians as sovereign nations. The Wabanaki people have waited long enough. We urge you to vote ought to pass on LD 1626. Thank you so much.
Thank you. Committee members, any questions for Karen Luthi? I am not seeing any. We appreciate your testimony today. And next, we'll bring over to the panel Catherine Harvey, Jean Consul, John Diffenbacher-Krall, and Ann O'Sullivan. That will be the next group to testify. I did want to mention too, if you happen to have to step away for a moment and come back, we will circle back and get people who were inadvertently skipped over because they weren't right at their computers. And so we've been joined by Catherine Harvey, and Catherine Harvey, you may begin your testimony.
Hi, my name is Kate Harvey. I'm here from Lewiston, Maine, to testify in favor of LD 1626. I struggled to write this testimony because when this issue was brought to my attention, I was absolutely enraged. How is it 2022 and Maine tribes do not have the same rights as the other 570 tribes in the continental USA? And why does our government think this is okay? As a teacher, I have been part of the national conversation about the historical revisionism and manipulation happening as an intentional act and moral failure of the ruling class and older generations. They aim to both cover up and justify the atrocities we've committed as a nation. And it is through this lens I am seeing the machinations of ongoing Indigenous genocide in our great state of Maine. I think we don't use that word enough when we are talking about our majority white legislatures intentionally oppressing Indigenous peoples. And I have read statements by Janet Mills patting herself on the back for changing mascots and appointing Native representation, while boldly declaring her concerns about possible revenue being gained through gaming. This comes after the upper class in Maine doubled its wealth through this pandemic. And I'm nauseated at the whinging over the implementation of federally legislated Native rights when our own government knows full well that there are Native children going to bed hungry at night, Native seniors without fuel to keep them warm, and Native families going without clean water. Do you recognize that Native people have equal rights now? And do you care? Because they're literally telling you what they need. The truth is that our government is concerned about Maine tribes having true autonomy, being out from under the thumb of our settler government. And I find this particularly audacious, considering what settlers have already done to this land. How are any of us able to say with a straight face that we are concerned with what Indigenous people are going to do on their land when we are seeing a Maine farming crisis due to the forever chemicals that our own government has polluted the land with? Have we collectively forgotten what we let the mill industry do to our waterways? And do we have amnesia about what the logging industry has done to natural habitats here in Maine? But if human rights and clean water and air and land aren't of this government's primary concerns, perhaps more compelling is the inevitable lawsuit by our federal government, again, for ongoing violation of federal law. And I wonder how expensive that will be and who will pay for it. I, as a Maine taxpayer, do not condone our Maine legislature's human rights violations on Indigenous people and delay of Native rights. And I am demanding the implementation of LD 1626 to rightfully restore the sovereignty of our Maine tribes, just as the rest of the country has done. Thank you.
Thank you for your testimony. Kate Harvey, committee members, any questions? I am not seeing any. We appreciate you being here today. And next we will hear from Jean Conzel. Welcome. You may begin when you're ready.
Senator Carney, Representative Harnett, and honorable members of the Judiciary Committee. My name is Jean Conzel, and I live in Brunswick, where I am a founder and member of the Thornton Oaks Retirement Community Social Justice Committee. I am here to support LD 1626 and to keep a pledge I made many years ago while doing freelance consulting work in Tucson, Arizona, where I worked for the National Indian Health Service. I worked closely with many Indigenous people who lived and worked on the Indian reservations in Arizona. One day during lunch, in conversation with a group of tribal members, after telling me about their history, discussion turned to the Indian Removal Act of 1830 and the subsequent Trail of Tears, which resulted in the death of thousands of Indigenous people forcibly removed from their lands and marched to Oklahoma. How could I have graduated from high school and college, taught American history to my 5th grade classes from textbooks that, by the way, never mentioned this, and never heard of this blemish on our history? I promised those telling this story that I would never forget it, and that I would make sure that I would always speak out about injustices directed at Indigenous people, no matter where I was living. Little did I know then that I would be reminded of that pledge here in Maine. The irony of this is that all of the tribes that were so brutally impacted by that history are now recognized as sovereign nations in Oklahoma. So too are all the other over 500 federally recognized tribes in all the states, with the exception of Maine, where the Wabanaki tribe's inherent sovereignty has been ignored by state law. We live in the only state in the Union that does not recognize the sovereignty of its tribal nations. This must be rectified. LD 1626 must be passed into law so that Maine's Wabanaki tribe's sovereignty is recognized and they will be eligible for all of the federal rights and resources available to tribes in all other states. It's a moral imperative. Thank you for your time.
Thank you for your testimony. Committee members, any questions for Jean Consul? Not seeing any. We appreciate you being here today. And next we'll hear from John Diefenbacher-Krall. You may begin when you're ready.
Good afternoon. I'm Senator Carney, Representative Harnett, and distinguished members of the Judiciary Committee. My name is John Diefenbacher-Krall. I live in Old Town. I appear before you in my capacity as Executive Director of the Wabanaki Alliance. I've submitted written testimony that's more extensive. I practiced a lot to try to stay within 3 minutes, but I do hope that you will read my full testimony. There's a growing awareness among many people and organizations of the unjust relationship between the Wabanaki and the state of Maine, witnessed by over 1,500 written testimonies in this proceeding, what I think may be a record in Maine legislative history. And I want to bring to your attention, we will hear many things about the bill today, but the cost to the relationship between the Wabanaki and the state of Maine. Maine Attorney General Richard Cohen, who's been referred to earlier today, who served in that role during the last 2 years of negotiations around the Maine Indian Claims Settlement Act and accompanying Maine Implementing Act, testified before the Senate Select Committee on Indian Affairs in July 1980. I cannot promise you that the adoption of this settlement will usher in a period of uninterrupted harmony between Indians and non-Indians in Maine. I can also tell you that if the matter is litigated over a period of years, the atmosphere in Maine certainly will be quite different. I cannot put a price tag on human relationships, nor am I suggesting that this factor alone justifies enactment of the legislation before you. I am asking only that you give appropriate consideration to the historical significance, not only of the settlement itself, but also of the manner in which it was reached. Attorney General Cohen's testimony was highly prophetic. He was correct to identify how the sovereigns treat each other is significant and a potential resource to buttress goodwill, collaboration, and trust, or to contribute to an atmosphere of suspicion, antagonism, and distrust. When Wabanaki and Maine governmental officials should have been cooperating to leverage the opportunities available to the 5 Wabanaki tribal governments as federally recognized tribes, time and resources have been misdirected to the state retaining its control of Wabanaki peoples. Passamaquoddy citizen Margaret Dana offers one of the most powerful descriptions I have ever encountered, emphasizing the importance of Passamaquoddy and Wabanaki sovereignty. This is an excerpt to the prologue of At Loggerheads, a State of Maine and the Wabanaki. I am Passamaquoddy, and I am distinctly different. I view the Settlement Act as a way to push out of existence as Passamaquoddy people. It has to do with jurisdiction over our lives and who has the right to determine how we govern our people and take care of our lands and resources. It has to do with being sovereign. I urge you to pass LD 1626, ought to pass.
Thank you very much. Committee members, are there any questions for John Diefenbacher-Krall? I'm not seeing any. We appreciate your testimony today. And next we'll hear from Ann O'Sullivan.
Thank you so much, honorable committee members, for listening to us today. I am a member of the Episcopal Maine Committee on Indian Relations and the Subcommittee on Tribal Relations. Our home, not the committee's home, but my personal home is in the middle of the Penobscot River on Verona Island. I am so delighted that the children are listening to us today, because I think there's something very important. We have to talk about what's right and what's wrong. We have to admit if we have made mistakes and try to remedy those. And I think it's become very obvious that the Implementing Act of 1980 included many mistakes. The primary one was to let Maine assume that they had sovereign rights over the indigenous people in the state. They never had sovereign rights. Maine didn't have sovereign rights over them. The peoples themselves have and had and continue to have sovereign rights. They just have not been able to exercise them because of the Implementing Act of 1980. It's time for us to stand up, admit we made a mistake, and try to rectify it. LD 1626 would go a long way towards that. It would allow people to take charge of their health care, to allow them to be able to get some economic relief. They need the same access to all these programs as the other 570 tribes. The only right thing to do is to recognize their sovereignty and to change the law. So thank you very much. I hope that the children see that there are a lot of people who are Native and not Native who are trying to help out. Thank you.
Thank you. Committee members, any questions for Ann O'Sullivan? Not seeing any. We appreciate your testimony. And the next group that will come onto the panel is Whitney Parrish, Michael Schaub, Sheldon Neal, and Sergio Kahekwa. I'm sorry if I'm mispronouncing your name. They'll be joining us in just a moment. And Whitney Parrish, welcome to the Judiciary Committee. You can begin your testimony when you're ready.
Thank you, Senator Carney. Good afternoon now, Senator Carney, Representative Harnett, and honorable members of the committee. My name is Whitney Parrish, and I am the Acting Executive Director of the Permanent Commission on the Status of Racial, Indigenous, and Tribal Populations. And I am talking to you from Augusta, from unceded cannabis land. It's my deepest honor to offer testimony in support of LD 1626. We extend our deepest gratitude to Representative Talbot Ross for her work on this bill and issue, as well as our co-chair, Ambassador Molly Dana of the Penobscot Nation, and Commissioner Vice Chief Daryl Newell, Passamaquoddy, Indian Township, as well as Commissioner Vice Chief Richard Sillaboy of the Aroostook Band of Micmacs for their steady and unfaltering leadership on issues of equity and justice spanning the entirety of the Dawnland. In December of 2021, the Permanent Commission surveyed Maine residents who signed up to attend our first community forum. 228 engaged the survey questions offered. These individuals are asked to, 1, identify issue topic areas most important to address in Maine, and you will see those in my written testimony. And 2, identify their top 3 priorities out of what they ranked. Out of 228 respondents for the first question, 181 identified tribal sovereignty as a priority. Out of 85 respondents who engaged the second question, 57 respondents identified tribal sovereignty as their top priority. While this survey sample is small, we find it striking and telling. People in Maine are acutely aware that we are better off when we are free to make the choices that are best for us. Our communities thrive when we have the ability to choose our own self-determined paths. The Wabanaki tribes, the first people to call this land home, know this too, and yet they persist even in the face of present day and generational harms, injustices, and deep disparities in the name of the Settlement Act spoken about today. I'm skipping around a bit, so I invite you to look at my testimony in full. I do go on to talk a bit about Don Geller's pardoning, and what we have yet to acknowledge despite his pardoning is that the subsequent Settlement Act was negotiated in bad faith by many of the same politicians responsible for the miscarriage of justice acknowledged by Geller's pardon. The intent of those politicians was to keep Wabanaki people in a state of paternal oppression by the state of Maine, and it is time that we put an end to their influence over our lives. Time and again, recognizing the strain in tribal state relations resulting from the Settlement Act, Wabanaki tribal leaders have answered the state's call to return to the negotiating table to develop amendments that are clearly needed. But time and again, the state has failed to follow through on these meaningful changes, and we must respect the process the legislature initiated in 2019 task force on the changes to the Settlement Act. Doing otherwise amounts to forcing the tribes to perform political theater with no results, but the further erosion of trust and continued harm to our Wabanaki family and friends. I see time. Reinhold Niebuhr once said, "Love is the motive and justice is the instrument." For the love we hold for the place we now call Maine and the people in it, we must seek justice for the Wabanaki nations. We must recognize that we are not giving anything. We are affirming what is self-evident. Self-governance and self-determination are the very instruments that will not only support the tribes, but everyone on this land. It is time for Maine to right the wrongs of the past and for us to work together for a better future for all of us. Thank you for your time and consideration of our testimony and this bill. We urge you to support LD 1626.
Thank you very much. Committee members, any questions for Whitney Parrish? I am not seeing any. We appreciate your testimony today. And next we'll hear from Michael Schaub. Welcome. You can begin when you're ready.
Thank you very much. You can hear me okay?
We can.
Awesome. Michael Schaub from Monroe, Maine, member of the Mid-Coast Justice Coalition. Good afternoon. Thank you, Senator Carney, Representative Harnett, members of the Judiciary Committee for allowing me to speak, and thank you for your work. This is important work that you do. All the details of this bill have been described by Representative Talbot Ross and Representative Angelos, bill sponsors and tribal leaders, far better than I can. And I know I have just 3 minutes, so I'll skip all that. I've been moved and encouraged by the testimony I heard all morning, supporting this bill, especially those from the tribal members. This testimony, my testimony in support of LD 1626, centers solely on the moral aspects of this bill. It reaches far into the past and well into the future. You all understand this. I know that. The Wabanaki Nation are people that have been wronged by the past through conquest, and even more importantly, by deceit and broken promises. You now have the opportunity, we have the opportunity to address some of those wrongs by formally recognizing the sovereignty that has been theirs all along. The 1980 Maine Indian Claims Settlement Act purported to do just that, but it clearly did not, by design. By using the municipality model, Maine continued to exercise control over the tribes, not allowing them to determine their destiny, but keeping them tethered to the criminal and civil jurisdiction of the state. This is in direct contradiction to how all of the other 570 federally recognized tribes are treated. We must ask the question, why does the state of Maine continue to deny the recognition of the Wabanaki Nation as sovereign people and treat these neighbors, our neighbors, differently than other indigenous peoples in the United States? Consider this for a moment. How would you feel if a foreign group came here, took away your lands, your livelihood, denounced your culture, and told you they would decide what rights you had? Would you think that right and just? I ask when you vote on this bill here in committee and hopefully later in the legislative chambers that you put economic considerations aside, that you put political aspirations and considerations aside, and that you focus solely on its moral aspects. It is my sincere hope that you believe the Wabanaki Nation should be a sovereign people and vote ought to pass. Please don't vote out of fear of losing control. Don't vote and perpetuate this harm. Vote to right this historical wrong. Vote to return stewardship of their lands to those who will protect them. We, all of us, everybody in Maine, we need moral leadership, not calculated votes. I ask you to do the right thing for the Wabanaki people and for all of us here in Maine. Passage of this bill will begin a legacy of mutual respect and unification. That's what we need. That's what we want. Please let this be the bright beginning. Thank you very much for listening, and I'd be happy to answer any questions you might have.
Thank you. Committee members, any questions for Michael Schaub? Not seeing any. We appreciate you being here this afternoon.
Thank you very much, Senator Carney, and the rest of you. Have a great day.
And next we will hear from Sergio. And Sergio, if you could introduce yourself, and I really appreciate your patience with me mispronouncing your name.
No worries, Senator Carney. It's Kaweke. Good afternoon, Senator Carney, Representative Harnett, and members of the Judiciary Committee. My name is Sergio Kaweke. I am an organizer and work around access to safe drinking water issues across the state, and I am here as a Portland resident to testify in support of LD 1626. I believe that the issue of Wabanaki tribal sovereignty is one of the great injustices of our time. Restoring sovereignty to the Wabanaki tribes will change a system of oppression that has impacted the Wabanaki people for over 40 years. The Wabanaki people have been stewards of this land for thousands of years before white settlers arrived. They have lived in harmony with the land and water, managing natural resources so that future generations can thrive. Since the arrival of European settlers, the Wabanaki people have lost 98% of their population, as well as access to most of their land and water. The Maine Indian Claim Settlement Act that was signed in 1980 has kept the tribes from benefiting from over 100 federal laws, which all other tribal nations have benefited from in the US, and has allowed the state of Maine to treat the tribes like municipalities instead of sovereign nations. There are 570 federally recognized tribes that have more rights than the Wabanaki tribes here in Maine. One particular area of concern is access to clean drinking water. Because of the Indian Land Claim Settlement Act of 1980, the tribes are not afforded the same protections under the Safe Drinking Water Act as other tribal communities. Nowhere is this more apparent than for the Passamaquoddy tribe near Pleasant Point. The tribal community has been dealing with drinking water issues for decades. Reports from the community have stated that the water is brown, smells like rotten eggs, and is generally unpleasant to drink. Additionally, the byproduct of the chemicals that are used to treat the water, called trihalomethanes, can cause serious health issues. There have been reports in the community of these chemicals and their byproducts burning the skin of those using the water. This is unacceptable. The Passamaquoddy have put forth options for dealing with this issue, including drilling a well on tribal land to provide safe water to the community. But because of issues with their sovereignty, the nearby town was able to pass an ordinance that made it so they couldn't use their own lands for a well. Access to clean water is a human right. The tribal communities in Maine should be allowed the same rights under the Safe Drinking Water Act as other tribes across the US. Granting tribal sovereignty will allow the tribes in Maine to work to make sure that their communities have access to safe drinking water. In 2020, a bipartisan task force created by the legislature in 2019 recommended 22 changes to the act to avoid and help settle future disputes between the state and tribes, to remove some of the barriers preventing the tribes from purchasing land, and to restore the tribes' inherent rights. The state needs to restore the sovereign rights of all tribal nations in Maine so that we can begin to heal the deep wounds that our tribal neighbors have suffered at the hands of both European settlers and the state itself. The Wabanaki tribes are asking to be treated like every other federally recognized sovereign tribal nation in the US. It is time for the state to step up and do the right thing by passing this bill to restore sovereignty to our tribal neighbors. Therefore, I urge you to take the first step to start to right the wrongs that have been done to the Wabanaki tribes and vote unanimously or to pass on LD 1626. Thank you for your time.
Many thanks. Committee members, any questions? I'm not seeing any. We really appreciate you provide testimony today. Before we move on to our next, the next person who will testify, I'm just going to alert those who are being moved over to the panel, and that's John Glowa, Phil Warden, Paul Kelly, and Sean Donnelly. And with that, we will hear from Sheldon Neal.
There we go. Hi.
Welcome.
Hi, thank you. Members of the Wabanaki tribes and members of the Judiciary Committee, my name is Sheldon Grace Neal, and I come from Surrey, Maine. Well, obviously Maine. And I thank you for hearing my testimony. I wish to express my support of LD 1626. It is my opinion that the Wabanaki have a right to update the original terms expressed in MICSA, or I don't know if you prefer MICSA or MICSA. Moving forward, I will speak only on matters pertaining to the environment without addressing the rights of reservation citizens to separate tribal legislature. This is not to imply that I do not respect full Wabanaki sovereignty, simply that I have no experience with the current Wabanaki reservations or with the tribe's policies on such matters, and it is my wish only to give testimony on that which I feel informed. I question my government's abilities when it comes to our environment, and I am further disconcerted by its lack of respect towards the Wabanaki tribes, whose treatment of what little land they have reflects a group far better suited to care not just for their own, but for this environment as a whole. I have listened to members and representatives of the Penobscot tribe speak of their ancestral duty to the Penobscot River, detailing their care and respect for the land itself, aware that the relationship provided therein is made and upheld by that respect. In this, there exists a body of government meant to interact between its citizens and its land for the benefit of both. Yet the tribe's sovereign rights are not respected or seen as an ancestral stewardship. I would ask the committee what logic lies in denying the Wabanaki request to revisit MICSA. When many states across America have set precedents for tribes and reservations to treat their environment as their culture dictates, I would put forward to the committee that the people best qualified to uphold the lands mentioned in LD 1626 are those who live alongside it, who take it upon themselves to continue a stewardship that has existed long before any of my ancestors set foot in the state of Maine. The Wabanaki's care of their surroundings mirrors my own, and I am inclined to view us as one on this matter. Therefore, the day my government cannot respect the Wabanaki's connection to this land is the day that it no longer respects me. Thank you.
Thank you for your testimony. Committee members, any questions for Sheldon Neal? I am not seeing any. We appreciate your testimony today.
Thank you.
And next we'll hear from Phil Warden. You may go ahead when you're ready.
My name is Phil Warden, and I live in Bar Harbor. I graduated from law school in the spring of 1980 and was sworn into the Maine Bar in the fall of 1980. During that interval, the National Lawyers Guild asked me to provide legal help to tribal members known as the dissidents who opposed the proposed settlement. The Guild sent me a packet of materials critical of the negotiations. Our principal claim was that the proposed settlement would be the first time in history where one people asked another people to democratically vote themselves out of legal existence by ceding their tribal sovereignty and becoming the equivalent of a municipality instead. At that time, the terms of the settlement were not well known. The exact wording was not available because it was still being negotiated in secret. Maine widely debated the merits of the settlement, but the debate always concentrated on whether the settlement was too generous to the Indians. White opposition claimed that the settlement was a huge giveaway to the Indians. They claimed that if the settlement went through, Indians would be driving around in Cadillacs while we might lose our homes. Tragically, some tribal members believe these wide publicized claims that the settlement would make them wealthy, which drowned out the dissidents' opposition to the settlement. The Dover-Foxcroft District Court, Briggs J., ruled that federal case law about the Indian claims raised a legal cloud on the real estate titles to all the land in their area. This insecurity about titles to our home created an emotional backlash. Proponents of the settlement persuaded a majority of Mainers that the settlement would solve this title problem and was not a great giveaway to the Indians. The settlement was adopted shortly after I was sworn into the Maine bar. As a new, inexperienced attorney, I did nothing. I regret to this day that I made no contribution to avoiding what I knew would be a disaster. One need only look at the concrete circumstances of the tribe today to see that the settlement failed to resolve legitimate tribal claims fairly. I credit you with having the courage and integrity to rectify this sad history so we can take another step toward justice. I encourage you to pass LD 1626. Thank you.
Thank you very much, Phil Worden. Committee members, any questions? I'm not seeing any. We appreciate your testimony today. And next we'll hear from John Glowa.
Good afternoon, Senator Carney, Representative Harnett, and members of the Joint Standing Committee on the Judiciary. My name is John Glowa Sr. I live in China, Maine. I'm testifying today in strong support of LD 1626 as a private citizen and as a Democratic candidate for governor of Maine. It's time to shift the political paradigm here in Maine away from government of, by, and for the money to a government of, by, and for the people. We must also shift the paradigm away from 400 years of institutional racism against Maine's Indigenous and First Nations people to a new paradigm of co-equality sovereignty for Maine's Indigenous people. It's past time for Maine's government to stop treating Wabanaki people as subservient and instead start treating them as co-equals. It's wrong to put pocketbooks and politics before people, but this is what has been done in Maine for centuries. And this is what must end, or we will collapse under the weight of our own greed. Change is often difficult and usually must come from the outside. Special interests that benefit from a broken system such as that which exists in Maine government don't want change and want to continue with business as usual. Well, it's time for business as usual to end. I am proud to be here today to speak out against 400 years of racial and social injustice. We must end this subservient relationship between the state of Maine and the Wabanaki tribes. We must work together because doing so can only make us all better. Working together, the possibilities for growth economically, socially, and spiritually are practically endless. It's time to approve LD 1626, sign it into law, and to begin the process of healing. Thank you.
Committee members, any questions for John Glowa? Not seeing any. We appreciate your testimony today.
Thank you.
And before we get to Sean Donnelly, I just want to alert the next group that will join us, and that is Ellen Tabasky, Roxanne Kai Petrovich, and Paul Tebow. And with that, Sean Donnelly, you may proceed.
Hi, good afternoon. Senator Carney, Representative Harnett, and honorable members of the Judiciary Committee. My name is Sean Donnelly, and I'm here today to testify in favor of LD 1626. I'm a resident of Rundle, just miles south of the Saco River headwaters, an ancestral home of the Wabanaki people for thousands of years. I grew up attending schools across our vast state, from Rockwood to Kennebunk. Not once in those dozen years did I learn anything about the proud history of the Wabanaki or of their love for this land that we all share. Instead, I studied history like the Clean Water Act, landmark legislation that was critical to reversing the destruction caused by unchecked industrialization. On the school bus, I saw hundreds of acres of clear-cut Maine forests scarred by uprooted stumps and skidder ruts that had long since been abandoned. And I was taught how we were continuing to dump carbon by the ton into the air, irreparably changing our climate and endangering all life on this planet. When we talk about what it means to be good stewards of our state, I think of all the ways that we have failed to live up to the example set by the Wabanaki. When the first Europeans arrived, they found a Gulf of Maine teeming with cod and rivers thick with salmon. Now tribal representatives are forced to submit emergency legislation so that their people can have access to clean drinking water. And when I hear concerns from some that this bill might have unintended consequences, I am flummoxed. How is it that after all this time, anyone can still believe that we know better than the people who have cared for this place long before it had an English name? A people whose language is filled with beautiful words for places that describe and honor the land, instead of the people who conquered it for profit. I urge you, honorable representatives, to listen to what our Native neighbors have been asking you to do, to honor their history and to respect their knowledge and love for this place we call Maine, and to please vote ought to pass on LD 1626. Thank you for your time and for your commitment to serving all of our people.
Thank you, Sean Donnelly. Committee members, any questions? We appreciate you being here today. And next, we will hear from Ella Tabaski, and I apologize if I'm mispronouncing your name.
You're very close. Can you hear me okay?
We can.
Fantastic. Senator Carney, Representative Harnett, and members of the Judiciary Committee, my name is Ella Tabaski. I reside in Brunswick. And I join you today as the environmental coordinator for the Patagonia Freeport store. I am testifying on behalf of Patagonia, and I appreciate the opportunity to be with you today to testify in support of LD 1626, an act implementing the recommendations of the Task Force on changes to the Maine Indian Claims Settlement Implementing Act. What a mouthful. At Patagonia, we recognize as a white-led outdoor company, we are reliant on recreation on stolen native lands. I'm going to sit with that for a second. In recent months, our company has acknowledged that we have a lot of work to do to live up to our values as an activist company. We have a long ways to go. But one of the ways we can do this work locally here in Maine is to uplift the voices of the Wabanaki people. And this is the first time that as a store, we are submitting testimony. And I believe you will see more of us doing that in the future to engage in this process. As has already been said, tribes in Maine have not benefited from more than 150 federal laws passed since 1980. And LD 1626 works to help fix this issue. We know that tribal sovereignty will ensure that any decisions about the tribes with regards to their property and their citizens are made with their participation and consent. Patagonia joins Wabanaki tribes and the Wabanaki Alliance to call on the legislature to recognize their tribal sovereignty as a matter of dignity and respect, and in honor of their inherent rights. Patagonia as a company is in business to save our home planet, but we know for a millennium the tribes here in Maine have been good stewards of the land and natural resources, and securing their future will help protect the environment. The time is now to stand with our Wabanaki neighbors, because when they prosper, everyone does. I really thank you for the time and opportunity to prevent these comments. I yield the rest of my time.
Thank you. Any questions, committee members, for Ella Tabaski? Not seeing any. We appreciate you being here today.
Thank you for having me.
Next, we'll hear from Roxanne Kai Petrovich.
Hi, Senator Carney, Representative Harnett, and members of the Judiciary Committee. My name is Roxanne Kai Petrovich. I live in Woodstock, and I am here to testify in support of LD 1626. I'm not a member of the tribes, so I'm not here today with any personal story. I'm here today as a Mainer who wants to help lift up the voices of the tribal communities in Maine, because it is their voice that matters most. Their voice that has been fought in expensive court case for years because of the injustices that Maine as a state has wronged them on. Quite frankly, I'm embarrassed by Maine. The tribes in Maine are asking to be treated like the other 570 federally recognized tribes. That's all, nothing more and nothing less. Maine made a bad deal, and because of that, for the last 40 years, the tribes have watched and lost out on law after law after law that benefits the other 570 tribes in the country, and that is wrong. LD 1626 is a start to fix that. The US Constitution recognizes 3 sovereign entities in the United States. 1, the federal government. 2, Indian tribes, and 3, the states. The Supreme Court acknowledges that tribal governments are the oldest sovereigns on the continent. So why is Maine still fighting the tribes in court while all 49 other states recognize the other 570 federal tribes? The time to listen to the tribes in Maine isn't now, and it wasn't 40 years ago either. It was when we as colonizers first settled here. We can't go back to the past to correct our bad deals, but we can start today. When the tribes prosper, Maine prospers. I urge you to vote ought to pass for LD 1626 for the tribes of Maine. Thank you.
Thank you very much for your testimony. Committee members, are there any questions? I'm not seeing any. We appreciate you being here this afternoon. And next we will hear from Paul Tebow, but before we do that, I'm going to alert the next group that they'll be moved to the panel, and that is Luca, Hamina, Dale Shields, Merritt Bainbridge, and Tyler DuBois. And Paul Tebow, welcome to the Joint Standing Committee on the Judiciary, and please begin your testimony when you're ready.
Good afternoon, Senator Carney, Representative Harnett, and distinguished members of the committee. My name is Paul Tebow, and I appear today in my capacity as the Managing Director of the Maine Indian Tribal State Commission. I have submitted written testimony, and I refer you to that for the totality of my comments. I would mention that many of the same issues that you've heard about today are addressed in those comments from the standpoint of MITSIC's experience and observations it's made about those issues. For 41 years, the Commission has been the only intergovernmental entity that has regularly reviewed fundamental questions relating to the overall effectiveness of the settlement. From the outset, MITSIC has respected the work of the task force and the resulting legislative proposals as a government-to-government process, as it should be. MITSIC did respond to a request to offer recommendations concerning effective tribal state consultation, dispute resolution, the creation of a bicentennial accord, and periodic tribal state assemblies. Some of that work product is currently included in the text of LD 1626. I would note that the statutory responsibilities of MITSIC are directly impacted by the proposed language of LD 1626. June of last year, at a MITSIC meeting, a motion was made for a vote endorsing the task force recommendations, and LD 1626. The vote was 7-0 in the affirmative, and the motion was passed, with 2 members who were present abstaining from the vote. At that time, it was understood that the governments would continue to address areas of disagreement and unanswered questions, and it was assumed that the bill would continue to evolve. On numerous occasions in the past, including during the task force process, MITSIC has submitted assessments and raised questions regarding the jurisdictional structure and overall effectiveness of the settlement. We've done that in reports, testimony, presentations, and other public statements. Some of those observations have been as follows. From the beginning, the tribes and the state did not have the same understandings and assumptions regarding the nature of the unusual jurisdictional experiment, as it was called, embodied in the 1980 settlement. They had different understandings of critical terms and concepts, such as tribal sovereignty, home rule, internal tribal matters, sustenance, and culture. That basic disconnect has continued through numerous disputes and still exists today, as many state and tribal leaders and others maintain very different views of the history, intent, and effectiveness of the settlement. It's important to note that the settlement authorized extensive state jurisdiction, including civil regulatory jurisdiction, over the tribes and their members on their existing reservations, rather than focusing only on jurisdictional arrangements that would apply on lands that would be reacquired by the tribes pursuant to the settlement. Most of the legal disputes that have risen about that expansion of state civil regulatory jurisdiction onto the reservations, rather than being about jurisdiction on the reacquired territorial lands.
Mr. Tebow?
Yes.
Sorry to interrupt. The 3 minutes has expired, and I know that because of your experience and involvement in issues related to tribal sovereignty, that you have a wealth of knowledge, and we will invite you to the work session. But if you could finish up in a couple of sentences, and then we'll see if committee members have questions.
Yes, thank you. And I was going to ask that we participate in the work session. So I can conclude by saying that Maine has not developed a flexible and responsive Indian policy. And that has impaired the evolution of positive and mutually productive tribal-state relationships. The task force recommendations and the current legislative proposals provide a new opportunity for the state to work with the tribes to adjust policy to fit the current circumstances. In conclusion, MITSIC encourages the committee and the legislature to consider MITSIC's input as you review the specific proposals. Bearing in mind that MITSIC is directly impacted by some of the provisions in 1626, MITSIC remains available to provide assistance in work sessions and otherwise as the process moves forward. That concludes my testimony.
Many thanks. Committee members, are there any questions for Paul Tebow or MITSIC? Not at this time. We appreciate you providing testimony today. And next we'll hear from Luca. You may proceed.
Yes, hello. My name is Luca Hamina, and I'm a resident of Orono and here today to speak in support of LD 1626. As a resident in the Orono and Old Town area, I'm very concerned about the fate of this bill, as it affects people within and around my community. This act would work to treat the Wabanaki as all other federally recognized tribes, honor land agreements made between the state of Maine and the Wabanaki, and even reduce state costs that are spent on many administrative fees. Currently, the Wabanaki tribes are excluded from over 150 federal laws, including legislation that would promote the self-governance of Wabanaki tribes. All other 571 federally recognized tribes are protected by this legislation. Why aren't the Wabanaki? This act would also allow the purchasing of roughly 100,000 acres of land by the Wabanaki. This 100,000 acres is part of 300,000 acres that the Maine state government had already allowed them to purchase in the 1980 Settlement Act, but has since denied or withheld from these tribes. And finally, due to the many legal battles that have occurred due to this act, passing LD 1626 would potentially save thousands of taxpayer dollars, having it be directed to other state programs or administrations. But most of all, as somebody who's come from outside of Maine, it's been extremely shocking and disappointing to see how the indigenous peoples of this land have been treated by the state government. Wabanaki right to self-government is not only important because it's a right afforded to all other federally recognized tribes, but the Wabanaki are also our neighbors on this land, and we should treat them well by helping to restore and honor the agreements made by us as both Mainers and Americans. Thank you so much. I yield the rest of my time.
Thank you. Committee members, any questions for Luca Hamina? Representative Moriarty, you may go ahead with your question. We're not able to hear you, Representative.
Thank you, Madam Chair. Mr. Hammond, I just need to clarify, you made a reference to Maine's being excluded from 170 laws. As I understand it, you're probably referring to the number of laws enacted since 1980 and not to the entire body of federal Indian law.
Yes, excluded from 150 federal laws since 1980. Yes, that's a detail.
Okay.
Thank you
Good.
so much.
Thank you. Thank you.
Any other questions, committee members? I'm not seeing any. We appreciate you providing testimony this afternoon. And next we will hear from Tyler Dubois. I hope I am pronouncing your name correctly. You could go ahead when you're ready.
You are. Thank you. Good morning, Senator Carney, Representative Harnett, and members of the Judiciary Committee. My name is Tyler, and I live in Orono. I am a senior at the School of Social Work at the University of Maine, and I am here to testify in support of LD 1626. When my daughter was in second grade, she came home from school one day with a grave and unsettled look on her face. I asked her what was wrong, of course, and she told me that her class had talked about the history of the Penobscot Nation and the land that she calls home. It made me feel like I don't belong here, she said with tears in her eyes. You see, my daughter was born and raised in Maine and considers herself a native Mainer. When she walks outside, the land knows her feet and welcomes her home. I think that many of us can identify with her. When we step outside, Maine knows that we belong. Here, we know that the land listens to us and we feel safe. Across the country, other states are not so lucky. California, as we are all aware, has been battling increasingly terrifying wildfires that have been devastating, both socially and financially. In 2018, more than 5 million acres burned in uncontrolled fires across the West. Wildfires were not normal before 1910. For 8,000 years, indigenous populations had been using a form of gardening called controlled burning, where land is managed with fire as a form of protection. Fires were not dangerous until after indigenous communities were forcibly removed from their home. Fighting fire with fire may feel scary to us, but it is only so because we are a very young culture. Though the land may listen to us, we do not yet know how to hear the land when it speaks. Our indigenous populations know how to have that conversation. There is no doubt in my mind that the Wabanaki Alliance has the same relationship with the earth that Karuk and Pomo tribes do in the West. Maine has faced unintended consequences from the Settlement Act of 1980. And I wonder how much greater we could be if we prioritized a strong alliance with the Wabanaki. What could they teach us that we don't know? We are not giving up our relationship with our home when we honor and respect their federal rights. I will tell you what I told my daughter. It is true that the Wabanaki were here first, but being here first or having the right to autonomy and independence does not mean that you don't belong here too. The Wabanaki and non-Indigenous Maine communities are not enemies. They are brothers and sisters, and they just want their space to be respected. By honoring federal law, we are simply acknowledging that we all belong. Passing LD 1626 is only the first step. I hope that Maine will extend a warm hand towards the Indigenous tribes and welcome their voice in government so that we can learn from them. We have nothing to fear from this move and everything to gain. We hope you will grant us the opportunity to grow together. Thank you for your time.
Many thanks for your testimony. Committee members, any questions for Tyler Dubois? I am not seeing any. Once again, thank you for being here this afternoon. Next, we will hear from Merritt Bainbridge.
Good afternoon. Can you hear me?
We can.
Good afternoon, Senator Carney, Representative Harnett, and members of the Joint Standing Committee on Judiciary. Thank you for the opportunity to testify today in support of LD 1626. My name is Merritt Bainbridge and I live in Saco. I am here to speak on behalf of the Maine Unitarian Universalist State Advocacy Network. MUSAN links Maine's 26 Unitarian Universalist congregations in active legislative ministry. Our faith tradition is dedicated to justice, equity, and compassion in all human relations. Justice and equity have been denied to the Wabanaki tribes since the Settlement Acts have favored the state of Maine, making the tribes subject to state laws and regulations, denying them self-governance on their own lands, treating them like municipalities rather than the sovereign nations they are and have always been. Maine likes to consider itself as an exemplary leader among the states, but when it comes to tribal sovereignty, the subordinate status of Maine's tribes makes a shameful example of the state of Maine. We believe that churches and faith-based organizations have a particular responsibility to be allies to the tribes. Colonial conquest of newfound lands owned by non-Christian brown-skinned people was justified with the doctrine of discovery that considered white Christian colonizers superior to them. It justifies the atrocities that followed: land theft, genocide, hunting, killing, and scalping of Native people, child theft, and forced assimilation. There was never a formal apology issued by the state of Maine. We owe a huge moral debt to the tribes, and we are just beginning to face a reckoning with this history. The task force took steps to listen to the experiences and grievances of tribal people and made recommendations to begin to right these wrongs. We should heed their guidance. We owe a huge debt to the tribes. LD 1626 would begin to restore self-governance to the Wabanaki tribes. It doesn't even come close to cover the debt owed, but it would be an acceptable down payment. In the name of justice and equality, I urge you to vote in favor of passing LD 1626 in its full language, without cherry picking, without amendments, in committee, on the floor, and when it comes to a veto override, if it comes to that. Thank you for allowing me to speak and for listening.
Thank you. Committee members, any questions for Merritt Bainbridge? Not seeing any. We appreciate your testimony this afternoon.
Thank you.
And we'll hear from Dale Shields in just a moment. I did want to alert the next group who will come over onto the panel, and that will be Jim Hatch, Alex Diamond Stanek, Michael Alpert, and Izzy Ostrowski. And welcome, Dale, to the Judiciary Committee. You can begin when you're ready.
Thank you. Can you hear me okay?
We can.
Senator Carney, Representative Harnett, and members of the Judiciary Committee, thank you for this opportunity to testify today in support of LD 1626, an act to implement the recommendations of the Task Force on Changes to the Maine Indian Claims Settlement Implementing Act. My name is Dale Shields, and I live in Yarmouth. And I speak to you today on behalf of the members of the Yarmouth Community Alliance for Racial Equity, or YCARE, a grassroots community organization of We're compelled to examine and act against the multifaceted nature of racism in our community and beyond. We are learning together and working toward racial justice and equity in our criminal justice, education, and healthcare systems, among others. Our support for LD 1626 is guided by what we've learned from our Wabanaki neighbors about the historical and ongoing injustices they face. It's rooted in our understanding that tribes in this land we call Maine are seeking justice from systemic racism. Since the Maine Indian Claims Settlement Act of 1980, the Maine tribes have not had the same rights, privileges, benefits, and immunities as every other federally recognized tribe in the US. The 1980 Act has stifled the Wabanaki tribe's rights to self-determination, causing cultural and economic hardships. We must not continue to prevent the Wabanaki nations from punishing crimes that occur on tribal territory, having access to clean water, emergency relief funds, and healthcare providers, and deciding how to use their own tax dollars to meet their self-determined needs. The tribes deserve to have their sovereignty respected with all the rights and powers ascribed to the other 570 federally recognized tribes. We also want to acknowledge how much positive restorative work has built up to this historical moment. We know how much time and effort was invested by the tribal legal teams, the Maine Indian Lands Claims Task Force, the Permanent Commission on the Status of Racial, Indigenous, and Maine tribal populations, and the State Attorney General's Office in crafting this legislation. There's been honest dialogue, active listening, trust building that's led to a better understanding of each other and what it'll take for Maine tribal communities to reach their full potential. So let us now take the next step as a community and take this action for racial equity and pass this bill out of committee with an ought to pass. A just and equitable world for Indigenous individuals and communities enriches us all. Thank you.
Thank you, Dale Shields. Committee members, are there any questions? Not seeing any. We appreciate your testimony this afternoon. Next, we'll hear from Michael Alpert. You may begin when you're ready.
My name is Michael Alpert. I live in Bangor, and I serve as the president of the Greater Bangor Area Branch NAACP. I thank Senator Carney, Representative Harnett, and the other members of the Judiciary Committee for allowing me to represent the NAACP at this hearing. The NAACP fully supports this bill as beautifully presented this morning by the bill's sponsors and by tribal leaders and elders. We see LD 1626 as the remedy to a moral failing, an issue of basic civil rights, in that the bill recognizes the historical standing of this region's tribal nations. I'm now going to read a revised last paragraph of the written statement that I submitted. For too long, the state of Maine has held an outlier position in its relation to its native people. Our history is and should be a source of shame. From the earliest European settlement, the region has withheld full legal rights from an important constituency of qualified citizens. Maine legislators need to recognize that they have the power to change a pattern of governance that has been dysfunctional for the entire history of the state, and especially for the last 40 years. LD 1626 presents a viable opportunity for the state of Maine to put in place an honorable relationship with its native people in accordance with our shared values of freedom and justice. The change presented in this bill is in accord with what has been deemed acceptable in every other state. There is no rational argument to deny Maine's native tribal nations the same rights as other similar native populations. There is no rational argument to vote against this bill or to veto it. As a matter of fairness under law, the NAACP fully supports the enactment of LD 1626. Thank you.
Many thanks, Michael Alpert. Committee members, any questions? No, not seeing any. Thank you so much.
Thank you.
Jim Hatch, you can begin your testimony when you're ready.
Good afternoon, Senator Carney, Representative Hartnett, members of the Joint Judiciary Committee, as well as the tribal chiefs and elders. My name is Jim Hatch, and I'm a resident of Bristol on the land of the Penobscot Nation. I am here to testify on behalf of LD 1626. Although I don't have much to say that hasn't been said very well and better than I can say it earlier in these proceedings, I still feel a duty as someone who benefits from white male privilege to testify on behalf of this bill. I believe the passage of LD 1626 is a matter of basic fairness and racial justice. Since the time of European colonization, the indigenous peoples of Maine have been treated with racism and subjected to genocide. Despite the attempts to destroy indigenous culture, the native Maine tribes are still here and are deserving of better treatment than they have historically received from the state of Maine. Maine tribes deserve to have the same rights as all 570 other federally recognized tribes. They deserve to benefit from the numerous federal laws passed since the 1980 claim settlement. As sovereign nations who never ceded their historic lands, they deserve the right of self-governance, to be able to legislate and settle their own community matters without interference from Maine, state, and local governments. The centuries of colonization of Native peoples present a horrific history of genocide. After more than 400 years of colonization, we need to decolonize our relationship with indigenous peoples of our region. We owe them the respect and basic fairness with which every human should be treated. LD 1626 would restore some equity and fairness to our treatment of Maine tribes. The state of Maine cannot continue to be their colonial overlords for another century. It is time to fix this injustice now. LD 1626 will provide the Wabanaki nations the self-governance they need to prosper and thrive, while allowing them to maintain their cultural identity. None of us can truly prosper and thrive until we all prosper and thrive. Passage of LD 1626 will be good for all the people of Maine. Thank you, Senator Carney, Representative Hartnett, members of the Joint Committee for this opportunity to present testimony on behalf of LD 1626. I believe the passage of LD 1626 is a matter of basic fairness and equity, and I urge you to recommend its passage to the full legislature. Thank you.
Thank you. Committee members, any questions? Not seeing any. Thank you for your testimony this afternoon, Jim Hatch. And next we'll hear from Izzy Ostrowski. You may begin when you're ready.
Thank you. Dear Senator Carney, Representative Harnett, and esteemed members of the Committee on Judiciary. My name is Izzy Ostrowski, and I'm the social change advocate at Preble Street, a human services anti-poverty agency with over 15 programs and services provided across the state. I'm here today to testify in support of LD 1626. At Preble Street, we know that we cannot be doing anti-poverty work if we are not also engaged in anti-racism work. Housing insecurity and homelessness exist today in part due to our country's legacy of racist housing policies. Additionally, oppressive state and federal policies regarding tribal sovereignty have played a harmful role in the extreme levels of homelessness, hunger, and poverty within and among Indigenous communities. Maine is not exempt from the disproportionate racial impacts of homelessness and hunger. 2020 racial demographic data from 10 Preble Street programs corroborate this inequity and show that a high percentage of people of color access Preble Street services. On average, 22% of individuals accessing Preble Street programs are Black, Indigenous, or people of color. 38% of people who use the Preble Street quarantine shelter are Black, Indigenous, or people of color. I'm sharing these statistics because they're one example of why tribal sovereignty is so vitally important. Oppressive state and federal regulation of Native tribes, as well as a lack of sovereignty for those tribes, has resulted in worse health and economic outcomes for Indigenous communities in Maine. Exercising control over Indigenous people and land while simultaneously not investing in equitable resources for those communities is the sordid history of Maine's systemic oppression of tribal communities. The 22 consensus recommendations released in January of 2020 by the Task Force on Changes to the Maine Indian Claims Settlement Implementing Act would increase the ability for tribes to determine their communities' futures. According to the Wabanaki Alliance, since the 1980 Settlement Act, 151 federal laws have been passed to benefit the over 500 federally recognized tribes across the country. In contrast, as you've heard today, the state of Maine has still not recognized the sovereignty of the Wabanaki tribes. Federal legislation ensures tribes' inherent rights to govern themselves, but under state law, the tribes of Maine are still excluded from that, as well as other rights and protections guaranteed by federal Indian law. Maine has a long-standing history of inflicting trauma upon Indigenous communities. This does not have to be and cannot be the future, and this bill would be a step toward prioritizing a future of equity, sovereignty, and healing for Maine's Indigenous tribes. For this reason, Preble Street urgently asks you to vote in support of LD 1626. Thank you for your time.
Thank you. Committee members, are there any questions for Izzy Ostrowski? I'm not seeing any. I did want to acknowledge and thank you for bringing to us the information that Preble Street gathered through its survey. The data is helpful in helping us think about these issues in an additional way. We appreciate that.
Thank you.
And we're going to hear from Alex in just a moment, but I did want to bring over 3 more people who will provide testimony before our break. And that's going to be Kevin Ritchie, Jim Lyson, and Victoria Kavanaugh. And Alex, you may begin when you're ready.
Thank you, Senator Carney. Thank you also, Representative Harnett. Thank you to all the members of the Judiciary Committee, to the tribal officials and representatives and elders, and to the sponsors and co-sponsors of this bill. My name is Alex Diamond Stanek. I live in Lewiston. I am part of an organization called Showing Up for Racial Justice, but I'm speaking on behalf of myself. So I wish to speak in favor of LD 1626. I am the father of 3 children, and I'm grateful for the opportunity to live and work and raise my family here in Maine, in the Dawnland, the land of the Wabanaki people. I'm not affiliated with the Passamaquoddy tribe or the Penobscot Nation or the Holton Band of Maliseet Indians who are named in this bill, but I extend my respect to all Wabanaki citizens and to their ancestors who have lived here for hundreds of generations. Addressing everyone who is attending this hearing and anyone who may be following the testimony, including Governor Mills, my message is this: I am both concerned and hopeful about the future we are creating for our children and grandchildren. And I think it's important to realize how our futures are tied together, particularly as we think about the health of the environment, the land and the water in the face of climate change. Working to ensure that the Wabanaki nations are thriving is in everyone's interest. In addition to being the right thing to do, implementing the bipartisan task force recommendations in this bill is good policy and good politics. I think the senators and representatives on this committee share a desire to do what they think is best for the state of Maine. And in that context, I can understand some instincts to defend the status quo in political and legal debates. I think we heard some of those arguments from Jerry Reed, the chief counsel to Governor Mills. But I would just ask us to be curious and ask, where did the status quo come from and who is it serving? The Maine Indian Land Claim Settlement Act of 1980 is older than I am. I don't think I'm that old, and I'm happy if you disagree with my kids, but they tell me that I'm old. One of them just reminded me that I'm entering my 5th decade on this planet. But regardless, it's long overdue that we find a way to do better. The policy changes in this bill are very reasonable, and the process has been careful, deliberate, precise to use some of the language that was used earlier. This is a positive step forward for everyone. And if the governor's office disagrees, I'm going to echo what others have said, please be bold enough to override any veto. So thank you for your time and attention. I hope that the members of this committee can support the bill, that your colleagues in the entire state Senate and state House can pass it, and then we can collectively send a message to the governor that it's both the right thing to do and a good policy to sign this bill. Thank you.
Thank you, Alex. Committee members, any questions for Alex Diamond-Stanek? I'm not seeing any. We appreciate your testimony. Next, we will hear from Jim Lysa. Jim, you may proceed.
Thank you. Senator Carney, Representative Harnett, and honorable members of the Judiciary Committee. It's been a long day already. My name is Jim Lyson, and I live in Lewiston for the past 40 years, and I'm here to testify in support of LD 1626. The tribes in Maine are seeking to be treated like the other 570 federally recognized tribes. They're asking to be able to determine the future of their communities. As a professional planner, and I was for over 30 years in Maine, I've observed many times how important local control is to even municipalities like Lewiston and communities throughout Maine. The tribes should have the right on their native lands without the state of Maine obstructing them to exert that local control. For thousands of years, the tribes in Maine have been good stewards of the land and natural resources. Conservation is part of their heritage. Their history of hunting and fishing is well documented. Passing LD 1626 will help protect the environment, especially important to Maine and the US in these climate changing days. Since the Maine Indian Settlement Act of 1980 was passed, tribes in Maine have not benefited from more than 150 federal laws passed to help Indian lands. That is not right. LD 1626 can begin to fix this issue. As members know, the legislature implements 22 consensus recommendations released in January 2020 by the Bipartisan Task Force on Changes to the Maine Indian Claims Settlement Implementing Act. It is fair and just to do so. The time is now to stand by our tribal neighbors. It is time to change a system of oppression that has held the tribes back. When they prosper, like other Mainers have, Maine prospers. Thank you for the opportunity to present this testimony. I think this is a moral imperative, as was mentioned earlier, and I would yield my time to others. Thank you.
Thank you for your testimony, Jim Lyson. Committee members, are there any questions? Not seeing any. We appreciate you being here this afternoon.
Thank you so much for having me.
And next we'll hear from Kevin Ritchie.
Greetings, Senator Carney, Representative Harnett, and members of the committee. My name is Kevin Ritchie and I live in Lee, Maine. I'm speaking for myself today to express my heartfelt support for LD 1626. I'm a lifelong resident of Maine and a lifelong educator. I feel lucky and blessed to have worked with Native youth in various capacities since 1980. I've stayed in touch with many former students from the Passamaquoddy tribe and now have the pleasure of seeing them in their work as adults. In the late 70s and early 80s, I watched the land claims case unfold in real time through the eyes of young tribal members, and I saw some of the excitement and anxiety that the process produced in the tribes. The Settlement Act was a wonderful but flawed move toward justice. I believe that now is the time to bring to further fruition the best ideals that were in front of us with the Settlement Act. As is often the case with major legislation, many agendas were represented during negotiations of the original Land Claims Act. Some of the intentions within those agendas were not in the best interest of the tribes, and some of the flaws in the act were unintended. Regardless, passage of LD 1626 will make so many of the best ideals and intentions more whole and far better refined, and will free up the will, perspective, and energy of the tribes to further act as the sovereign nations which they are. The tribes of Maine need and deserve the benefits that they would access through the dozens of federal laws that they are now unjustly denied. Increased autonomy, greater tribal health and well-being, greater safety and internal responsibility, and greater self-determination. These are outcomes that most interested Mainers of goodwill and most tribal leaders and members anticipated with the original act. These can now be delivered through passage of LD 1626, making the status of Maine's tribes on equal footing with the 500 plus other federally recognized tribes. A last word, because of the existential reality of climate change and ecological damage across Maine and the world, I believe we need the knowledge of and relationship to the natural world that comes from Indigenous communities. Through the increased access to sovereignty that LD 1626 will allow, all of us will be better able to work together to address this mammoth crisis of our time. Thank you for the good work you all are doing and will continue to do, and thank you for your stamina today.
Thank you. And I see that we have a question for you, Kevin Ritchie. Just one moment. Representative Evangelos, go ahead.
Hi, Kevin. Thank you for your testimony. It was very, very moving. You must have worked at Lee Academy then.
I did.
Right.
35 years, retired a couple of years ago.
So you experienced quite a bit of contact with the Native American population.
Yes, I did. I actually started in 1975 with the Upward Bound program at the university. A lot of Penobscot kids were involved in that, where I met a very young Barry Dana, Jim Perdilla, Cookie Francis, people with some real insight, even as high schoolers. And then I worked for the Job Corps Center in Bangor, and it was at Husson for 2 years. Knew several Native kids then, and then 35 years of experience with Native youth, the families, and the communities at Lee Academy. And a heck of a career.
Thank you for your testimony.
Thank you.
Committee members, any additional questions? Representative Newell, go ahead.
Thank you, Madam Chair. Willie-Wood, Mr. Ritchie, for being here today and offering testimony to this committee. Nagachibuan, my instructor.
Thank you, Rena. It's been wonderful to be
38 years ago.
Oh, wow, we're getting old.
And contributing to where I am today.
That's awesome. Thank you for saying that.
Willie-Wood.
Willie-Wood.
Anything else, committee members? Thank you all, and thank you very much, Kevin Ritchie, for your testimony.
Thank you.
The last speaker before we'll take a brief break is Victoria Kavanaugh, and you can begin when you're ready, please.
Thank you. Thank you, Senator Carney, Representative Harnett, and members of the Judiciary Committee. My name is Victoria Kavanaugh, and I live in Scarborough. I'm here to testify in support of LD 1626. Thank you for giving me time to speak today. I am a student at the University of New England working on my Master's of Social Work, and I was born and raised here in Maine. I want to begin my testimony by recognizing that as a white person, my role here is to support and lift up the voices of the Indigenous tribes in Maine. Despite growing up in Maine, I learned very little about the Indigenous tribes here while I was in school and have only learned about this inequity in recent years. The lack of education and the discussion around the tribe's fight for self-governance is embarrassing and shameful, and we need to do better. To paraphrase from the Wabanaki Alliance website, LD 1626 is about fairness and equity. There are 570 tribes across the United States that are federally recognized and benefit from tribal sovereignty, and the tribes in Maine are only asking to be treated the same as their counterparts. They're not asking for special treatment or anything more than these other tribes. I urge you to support the Indigenous tribes in Maine and their inherent right to self-govern by passing LD 1626. Thank you.
Thank you, Victoria. Committee members, are there any questions for Victoria Kavanaugh? I am not seeing any. We really appreciate your testimony, and good luck with your studies at UNE. Committee members, I think we are at the time for our afternoon break. We are going to take a 15-minute break. It looks like we have 21 persons who wish to be heard on LD 1626. And so we'll take a 15-minute break, returning at 3:20 promptly. And then we will continue with the remaining 21 speakers and complete our work for the day. And with that, we are in recess until 3:20. Thank you, everyone.
He got the world or something. He has a magic touch.
Representative Harnett, I didn't know if you were aware that your microphone is activated.
So you heard me talking to Soupy. Okay.
No, I just heard a big sigh. But I've got to log off I've got to attend to something for one moment. Thanks.
Sure, I'll mute my size. Thanks. Bye.
Tom, who would have guessed that on the day of the most important Zoom of the year, there will be a town-wide, if not wider, system failure?
Wow. And so you had to jump in your car and drive up here?
Yeah, so I had to race up here. Peggy found me a room in the Cross Building. I've had no lunch.
I'm sure that was an anxious period of time too. You're
Yes, it
trying
was.
to
Yes,
get
it
up here
was.
as quick as you can.
Gosh.
Al, I'm glad you made it safely and I'm sorry that happened.
Yeah, thanks. Yeah. It was not a bad day for a drive. It's just I hadn't quite planned on it.
Committee members, as you return, if you could activate your mics and video.
I know you didn't mean it about the mic, Tom.
That's right.
But you did it anyway.
Don't take me literally. One, two. Well, we have 7. I'm going to give it 1 minute, but I am going to try to start up as quickly. Oh, but did you need to formally hand me the gavel, Co-Chair Carney, or you okay with?
Yes, because you can't do anything until you get the virtual gavel.
Then I will wait to be empowered.
There you go. I also wanted to let you and others know that we are going to have one person who is going to call in to provide testimony probably relatively soon. And so we're going to try to take that call-in testimony when the person calls. And Representative Harnett, I will let you know.
Thank you.
When I see that number coming in.
Okay, and you will go back to timekeeping role as well?
I will.
With your hand up? Thank you.
Thank you.
Welcome back to the Judiciary Committee meeting. At this point, it appears we have 20 persons in the attendee room signed up to testify. We are also, as Senator Carney just explained, expecting a call from an elderly constituent of one of our colleagues who wishes to weigh in on this important matter, and we're going to try to make that happen. And Senator Carney will be on the lookout for a phone number appearing in the attendee room. At this point, I would ask the committee clerk, Supi Panett, if you could please move over Jared Sachs, Dean Steffiari, Johnny Sanchez, and Christopher Kayer. And thank you. It looks like we have all of those persons, so that's great. I will begin by welcoming Jared Sachs to the Judiciary Committee as we pick up our public hearing on LD 1626. Rabbi Sachs, if you could activate your camera and microphone, it appears you have done so. Welcome to the Judiciary Committee. We appreciate you being here today. Please begin your 3-minute testimony as soon as you are comfortable.
Good afternoon and thank you. My name is Rabbi Jared H. Sachs. I live in Portland and serve as the rabbi of Congregation Bet Ha'am in South Portland, Maine's largest synagogue, the spiritual home to over 350 member families who join us from Harpswell to Kittery and Freiburg to the coast. Senator Carney, Representative Harnett, and members of the Judiciary Committee, thank you for the opportunity to be here this morning to offer testimony in support of LD 1626. This past week, my congregation partnered with Wabanaki Reach to offer a program on Wabanaki Maine history. In spite of my living in Maine for the past decade, prior to this program, I knew very little about the Native people of Maine. During the program, I learned about the centuries-long oppression of the Wabanaki. We heard stories of children separated from parents, forced conversion, cultural erasure, illness and death, and people being driven from their land. As I learned the history of Maine's Native people, I couldn't help but be reminded of Jewish history. The Wabanaki story is one of survival against all odds. The same is true of the Jewish story. For 2,000 years, Jews lived in exile from our land, and over those 2 millennia, we were subject to the will of others as well. Often our families were torn apart. We were forced to convert. Our culture was erased, and we suffered illness and death as well. Today, the Wabanaki live in exile from their own land, despite living right outside the door. Our learning wasn't only about history, but about the present as well. I learned that unlike all of the other 570 federally recognized tribes in the other 49 states in this nation, the Passamaquoddy tribe, the Penobscot Nation, and the Holton Band of Maliseet Indians lack the inherent right of self-governance within their respective territories. LD 1626 would right this wrong by implementing the recommendations of a bipartisan task force. The tribes would have greater ability to steward the land and protect Maine's environment. Since 1980, tribes in Maine have not benefited from the more than 150 federal laws that the other 570 federally recognized tribes have. The tribes in Maine lack the right to execute justice on tribal lands. They lack the right to levy and collect taxes to support their community. They lack the basic right of self-governance and self-determination, which are cornerstones of a free society. Israel's national anthem includes the prayerful lyrics, Od lo avda tikvatenu, hatikva bat shnot alpaim, lihiot am chofshi be'artzenu. Our hope is not yet lost, the hope of 2,000 years, to be a free nation in our land. Our hope became reality almost 3/4 of a century ago, but the tribes of Maine continue to be outsiders in their own land. The central lesson of Judaism is the story of our exodus from Egypt and the obligation to remember what it was like to be an outsider and to ensure that others do not suffer the same fate. It is in this spirit that I ask you to support LD 1626, which will help to restore dignity to our Native siblings by providing their right to self-governance and self-determination. Thank you for your time and thank you for this opportunity.
Thank you very much, Rabbi Sachs, for your testimony this afternoon. The committee greatly appreciates getting your input on this important matter. I would ask if there are any committee members with a question for Rabbi Sachs. If so, please raise your electronic hand. And again, I am not seeing any. So again, much thanks from the committee to you. We greatly appreciate your spending time with us today. I would now invite Dean Staffieri to present his 3-minute testimony. You can begin as soon as you are comfortable, Dean.
Well, thank you. Good afternoon, Senator Carney, Representative Harnett, members of the Committee on Judiciary. My name is Dean Staffieri. I live in Naples, and I'm the president of the Maine Service Employees Association, Local 1989 of the Service Employees International Union. Maine Service Employees Association represents over 13,000 workers across the state. The elected members of the MSEA-SEIU Board of Directors have voted to support LD 1626, which would address longstanding issues with the Maine Indian Claims Settlement Act. We stand in solidarity with the tribes asking to be treated like all other 570 federally recognized tribes in the United States. LD 1626 is necessary for the tribes to address issues like healthcare, criminal jurisdiction on tribal lands, education, and the rights to enact and enforce environmental quality controls. So I'd ask you to please support LD 1626. The members of the MSEA-SEIU board discussed LD 1626 in the spring of 2021 and again in the winter of 2022. As part of the discussion, members shared firsthand examples of experiences that directly highlighted reasons why the state must move towards equal footing for the tribes in the state. In my previous work as a supervisor for the Maine Office of Child and Family Services, I personally witnessed a judge rule against the state, the guardian ad litem, both sets of parents' attorneys, and the attorneys representing the tribe, because the judge did not agree with the tribe's inherent right to manage the affairs of its children. The judge made it clear that he did not respect the Indian Child Welfare Act and ordered the children into a foster home that was not tribal. And he also indicated that he had no interest in the decisions of the tribal court. This is but one example of the lack of respect for the sovereign right of tribes to determine what is in the best interests of their families. The history of the labor movement is a history of collective struggle and solidarity, of workers banding together to fight for justice, even when the odds are stacked against them. This history has led to many of the rights we have as workers today. But solidarity means fighting for justice and equity, not only within our workplaces, but within our communities too. For our members, this means standing in solidarity with Maine's tribes as they ask for the ability to determine their communities' futures on their native lands. I thank you and would be glad to answer any questions.
Thank you very much, Dean, and the committee greatly appreciates and gives you thanks for coming to provide testimony this afternoon.
My pleasure.
Are there questions from committee members for Dean Staffieri? Seeing none, again, thank you very much for sitting through what's been a pretty lengthy day. We appreciate hearing from you. I would now call upon Johnny Sanchez. I'm sorry, Senator Carney.
I just wanted to let you know that after Johnny Sanchez, we could do the take the testimony from the person who had to call in. She is ready when we are.
I will do Mr. Sanchez, and then we will make that happen. What name would I be looking for?
I will move Representative Collings over to the panel. He's not going to activate his video, but he'll activate the audio.
Okay. Thank you very much, Senator. Johnny Sanchez, welcome to the Judiciary Committee. It's a pleasure to see you. Please begin your 3-minute testimony as soon as you're comfortable.
Sure. Thank you very much. Good afternoon, Senator Carney, Representative Harnett, and members of the Judiciary Committee. As you said, my name is Johnny Sanchez. I'm originally from Okewinga, New Mexico, one of the 19 Pueblo tribes and one of the 570 other federally recognized tribes in the US. But I now reside in Orono, where I work for a nonprofit called Food and Medicine. And in my time here in Maine, I've seen the stark differences between how these two states that I've lived in treat the indigenous people on whose land they exist. And I'm here today to urge this committee to support LD 1626 and to further commit to supporting it through a possible veto override. The concept of tribal sovereignty is one that most citizens of the US often struggle to grasp, and I'll admit that I am no expert. However, because it is a concept that influences policies, which in turn influence tangible laws and regulations that directly affect the lives of Indigenous people, it really is important for us all to try. Maine tribes attained federal recognition in the 1970s, 80s, and 90s after decades of work. It is acknowledged by the US that federally recognized tribes have, and I quote, the immunities and privileges available to them by virtue of their government-to-government relationship with the United States. Incredibly important issues hinge on the sovereignty inherent in federal recognition, such as the provisions that support healthcare for tribal members, improved economic opportunities, education, expanded environmental protections, increased job creation, and protection against the epidemic of violence against Native women. While the provisions of over 150 federal laws since 1980 have granted these and other absolute necessities to the other 570 federally recognized tribes around the country, the Maine Indian Claims Settlement Act has denied tribes in Maine these benefits and have prevented them from exercising their rights to act as self-governing sovereign nations. At its core, this bill is truly about equity. Equity for Maine tribes to be treated as tribes elsewhere are treated, but also equity for Indigenous peoples to be treated fairly and with respect in general. LD 1626 would make necessary changes to this antiquated piece of legislation. This is a complex issue, but it is one that I challenge you to wrestle with. And I really hope that you will, because Indigenous peoples have been wrestling with it for generations. And with that, thank you, and I cede the rest of my time.
Thank you very much, Johnny Sanchez. We appreciate your being with us this afternoon and sharing your insight. Are there questions from committee members for Johnny Sanchez? If so, please raise your electronic hand. And I am not seeing any. So again, thank you very much for presenting your testimony and also submitting it to us in writing. We appreciate the time that you took. Thank you. We're going to skip out of order now to bring in our colleague, Representative Ben Collings. Representative Collings, if you could activate your microphone and explain to the committee how we are going to hear from your constituent.
Oh, good afternoon. Can you hear me?
Yes, we can.
Okay, yes. I have a constituent who contacted me who can't access a computer or internet, but very much wanted to speak. And the only way I could do so was getting her on the phone and then getting on the computer myself. So she can introduce herself, but her name is Marilyn Clark from Portland, and she's ready to speak, I believe, if you
Thank
can
you, and
hear.
welcome Marilyn Clark to the Judiciary Committee. Please begin your testimony as soon as you are comfortable.
Thank you. This is Marilyn Clark from Portland, and I am very, very glad to have the opportunity to speak in favor of 1626 and giving our Native Americans what they have had to do without since the 1700s. In the West, 570 tribes have been able to have what most tribes should have. The Wabanakis apparently do not have the total for the hunting responsibilities and the fishing for within their tribal land. They also have problems with not having work for their tribes or having the education that they should have. Back in 1820, when Maine left, when Massachusetts let Maine to be a state on its own, the tribes lost much of their land at that point, and it became ruled by the state of Maine. That is not right. Recently, there has been talk about the gambling in order to have money for their tribe. If you look down at Connecticut, they have their tribes down there take in a lot of money for their gambling. This is one of the ways that the state could have money for the medical needs that they need for their families, the education that they need, and we have not been fair to these tribes in any way, shape, or form. They've lost out almost every single time, and I just believe that if we can pass 1626 and give these Wabanaki people what it is that they should have, that we took away from them from the time we came to the United States, and now let us show what we owe them and give it back to our friends and neighbors, the Wabanaki tribes that are here at the state of Maine, but should not be a part of the state of Maine. They are separate and should be separate, controlled by the United States, and not by the state, and by their own rules. And when I go to church on Sunday, our church is on Wabanaki land, and we remember that every Sunday and wish for them to have their property and to be able to control their tribes as they see fit, not as the state of Maine sees fit. That's all I have to say.
Thank you very much, Marilyn Clark. And I personally truly appreciate the effort you made to get in front of our committee this afternoon and the persistence of my colleague, Representative Collins, to making this happen. Thank you very much for taking the time to provide us your thoughts on this important matter. I'm going to check to see if there are any questions from committee members for you. Committee members, are there any questions for Marilyn Clark that you would like to pose? I am not seeing any. So again, thank you very much for making this effort to be before us today. Very much appreciated.
Thank you for giving me the opportunity to express my feelings on this issue.
You are very welcome, ma'am. I will now turn to Christopher Kayer. Please activate your microphone. Welcome to the Judiciary Committee. Please begin your 3-minute testimony when you're comfortable.
Thank you. Senator Carney, Representative Harnett, distinguished members of the Judiciary Committee. My name is Chris Kayer and I reside in Stratton, Maine. I'm honored to be here today to present my testimony for LD 1626. In 2019, the Maine legislature created the Task Force on Changes to the Maine Indian Claims Settlement Implementing Act to look at the structural inequities that have been created as a result of the Settlement Act of 1980. The task force issued a report in January 2020 with 22 recommendations to restore tribal self-governance. LD 1626 would implement most of these recommendations. Growing up in Maine, I learned about the importance of community and taking care of each other, and I was taught to treat others how I would like to be treated. Passing LD 1626 is about fairness and equity. For the last 40 years, tribes in Maine have been fighting for the same basic recognition and resources that the other 570 federally recognized tribes receive. Maine tribes are governed as entities of the state, and as a result, these tribes have been unable to benefit from 150 federal laws passed since 1980. This federal support would have provided opportunities for economic development, increased access to healthcare, provided resources to deal with natural disasters, and expanded environmental protections. Why would we block our Indigenous neighbors from having access to these basic human needs? Indigenous peoples in this country are some of the most marginalized and disenfranchised people in the world. They have been stripped of their land and their right to self-governance. They suffer higher rates of poverty, homelessness, and malnutrition. They have been disproportionately affected by COVID-19, whether through infection, fatality, economic losses, or changes to social interactions. Passing LD 1626 is not only the right thing to do, it is urgent and necessary. Members of the Judiciary Committee, thank you for listening to my testimony today. I'm urging you to please consider the many benefits that this bill would provide to our Indigenous brothers and sisters here in Maine. Thank you.
Thank you very much, Christopher, for being with us today and presenting your testimony to us orally. And also I see that it's been submitted in writing. I thank you for that. Are there questions from committee members for Christopher Kayer? Seeing none, again, we extend our thanks to you for weighing in on this important issue.
Thank you.
And Soupy, I would ask you to please move over Luke Sakara Flanders, Sharon Klein, Eliza Townsend, and Adam Good. As we wait for those to move over, just give me a minute. And Luke, you will be the first one up. So if you could activate your camera and unmute your microphone so that we can see and hear you. Thank you very much, Luke, for being here with us this afternoon. Please begin your 3-minute testimony as soon as you are comfortable.
Yes, thank you. Senator Carney, Representative Harnett, members of the committee, thank you for hearing me today. My name is Luke Sakara Flanders. I am here today speaking on behalf of Community Water Justice. We are a statewide network of community organizers who are fighting water injustices across the state. And I'm also here as a Changemakers Fellow with the Maine Environmental Education Association. I'm also a Maine Seed with Seeds of Peace. I grew up in ancestral Abenaki territory that many of you may know as Fryeburg, Maine. All my life, I've been a passionate student of local history, which in large part is what brings me here today. While I was in middle school, I began to learn the Indigenous history of my hometown. The Pequawket people of the Abenaki tribe lived in what we refer to as Fryeburg for millennia. The rich history of that region was violently uprooted with the Battle of Lovewell's Pond in 1725, perpetrated by a group of scalp hunters seeking to murder Indigenous men, women, and children, remove their scalps, and turn them in for a bounty. The result was the extirpation of Indigenous people from that region, and Fryeburg was named for the leader of that expedition. Though a violent, intense chapter of our local history, it is not unique in the sense that this story was repeated across Maine and the United States for the following 2 centuries. Though the last acts of warfare against Indigenous peoples in Maine have ended, the violence continued in dispossession, disenfranchisement, and other forms of economic, political, and cultural oppression. Today, my generation is looking for examples to learn from as we step into our own leadership roles. And this is an atrocious legacy that we must correct. We cannot emulate this violent history in our decisions for the future. Maintaining the state's hegemonic authority over Indigenous people is a barrier to building successful relations and is depriving people in Indigenous communities of basic necessities, as we are seeing to this moment with the water crisis in the Passamaquoddy tribe at Sabayak and the inherent fishing rights of the Penobscot tribe. The state of Maine today has an opportunity to build new, dignified relations with the tribes and respect their inherent sovereignty. The people of Maine have everything to gain from recognizing Indigenous self-determination, as lifting each other up will always generate more opportunity. It's time to live up to our state motto and lead with integrity in tribal state relations. I therefore urge you to vote ought to pass on LD 1626 and take this opportunity to both acknowledge the injustices of the past and act toward a more equitable future. Thank you for your time.
Thank you very much, Luke, for being with us this afternoon and offering your testimony to the Judiciary Committee. We greatly appreciate it and offer our thanks. Committee members, are there questions for Luke Sequeira Flanders? If so, please raise your electronic hand. And I am seeing none. So again, thank you again on behalf of the committee. We appreciate your time. Next up, I have Sharon Klein. Sharon, as soon as you can, just activate your microphone and begin your 3-minute testimony as soon as you're comfortable and ready to go.
Thank you. Senator Carney, Representative Harnett, and members of the Judiciary Committee. My name is Sharon Klein, and I live in Bangor, Maine. I'm an associate professor in the School of Economics at the University of Maine in Orono, and I'm here to testify in support of LD 1626. I support LD 1626 for personal and professional reasons. On the personal side, I am a white American of European descent who can trace her ancestors back to the Mayflower. The more I learn about history, the more I'm appalled at what people who share similar ancestry to me and potentially my own ancestors have done to the original inhabitants of this land in order to make it their own. It sickens me that my very existence, family, and life are built on the genocide and mistreatment of others. The Maine Indian Claims Settlement Act of 1980 was another in a long line of mistreatments that stripped the included tribes of the soul of tribal sovereignty, or at least tried to. Understanding now the conditions under which tribes agreed to the act makes it clear that at the time they felt there was no better choice. It was the responsibility of the people in power at the time to not use that position to strip the tribes of their rights. The Maine government abused that power in 1980 when they sought to essentially reduce the tribes to the status of municipalities. As a citizen of the state of Maine, I am sickened by this history, and at a minimum, I urgently want tribal sovereignty restored and any other reparations recommended by the task force implemented. Going forward, I think the state still has much work to do toward reparations with the tribes. From a professional standpoint, as a University of Maine professor, I work at a place located on Penobscot Nation ancestral lands. Part of the land acknowledgement statement adopted by the university reads, "The university also recognizes that the Penobscot Nation and the other Wabanaki tribal nations are distinct, sovereign, legal, and political entities with their own powers of self-governance and self-determination." In my opinion, supporting LD 1626 is a natural progression from this land acknowledgement. Furthermore, the University of Maine is a land grant institution and is thereby dedicated to serving the residents of Maine, the nation, and the world. Part of the university's mission is through integrated teaching, research, and outreach to improve the quality of life for people in Maine and around the world and promote responsible stewardship of human, natural, and financial resources. It serves all Maine residents for the tribes that have managed to survive the atrocities of the past within the geographic bounds of our current state to be able to self-govern. They were here before us. They have a unique relationship to the land and waters that should be respected, protected, and learned from. My own research on energy equity and justice highlights how energy and climate issues cannot truly be solved until social justice is addressed as an integrated part of sustainability action. Championing tribal sovereignty is a key step toward achieving the social justice needed to address our state and nation's growing climate and energy problems. Thank you for your time and consideration. I hope you will support LD 1626 and tribal sovereignty.
Thank you very much, Sharon Klein, for taking the time out to present your testimony to us this afternoon. We greatly appreciate it. Committee members, are there questions for Sharon Klein? If so, please raise your electronic hand. I am not seeing any, so again, thank you very much for taking the time to present today. And before I turn to our next person presenting testimony, I see we've been joined by our colleague, Representative David Hagan. I would like to give Representative Hagan the opportunity to introduce himself.
Thank you, Mr. Chair. I appreciate that. I'm David Hagan. I represent House District 101, Hamden and Newburgh. And once again, thank you very much.
Thank you for joining us this afternoon. It's good to see you. Next up on our list of persons to testify is Eliza Townsend. Welcome, Eliza. As soon as you are comfortable and ready to proceed, just begin your 3-minute testimony. Thank you and welcome to the Judiciary Committee.
Thank you. Good afternoon, Senator Carney, Representative Harnett, and distinguished members of the Joint Standing Committee on the Judiciary. I am Eliza Townsend, Maine Conservation Policy Director for the Appalachian Mountain Club. AMC is the nation's oldest conservation, recreation, and education organization with the mission to foster the protection, enjoyment, and understanding of the outdoors. We have more than 6,500 members in Maine and own 75,000 acres of forest land in the 100-mile wilderness region of Piscataquis County, managed for multiple use, including sustainable forestry, backcountry recreation, and environmental education. AMC supports LD 1626 to establish that the Passamaquoddy tribe, the Penobscot Nation, and the Holton Band of Maliseets enjoy the same rights, privileges, powers, duties, and immunities as all 570 other federally recognized tribes in the United States. We recognize that the status of the Maine tribes under the 1980 settlement has led to significant conflict in the past 4 decades, particularly over issues of environmental protection. The Wabanaki make clear that their identity and culture is inseparable from the lands and waters that have sustained them for 10,000 years. We are confident that they can steward those resources as well as the state of Maine has done. Further, by ensuring that the tribes can benefit from the 151 federal laws passed since the 1980 settlement, LD 1626 has the potential to bring much needed resources to our state. The 1980 settlement created a process for the tribes to expand their land holdings in Maine and set aside federal funds for that purpose, but the tribes have not acquired the agreed upon acreage. This bill removes 2 critical obstacles: time limits on the tribe's acquisition of trust land and the ability of both state and local governments to veto potential acquisitions. No document is perfect. The United States Constitution, which has been amended more than 24 times, is just one example. In the year 2022, as we are more aware of issues of justice, it is appropriate to recognize the shortcomings of the 1980 land claims settlement and to improve upon it. We ask that you support LD 1626. Thank you.
Thank you very much, Eliza Townsend, for providing testimony this afternoon to the Judiciary Committee. We appreciate your input. Are there questions from committee members for Eliza Townsend? And I am not seeing any. So again, thank you very much for your time and sticking with us through a pretty lengthy day. Appreciate it. Next on my list is Adam Good. Adam, it's nice to see you again. Welcome back to the Judiciary Committee. Please begin your testimony as soon as you're comfortable.
Senator Carney, Representative Harnett, and members of the Joint Standing Committee on Judiciary, my name is Adam Good. I'm the Legislative and Political Director at the Maine AFL-CIO. We represent 40,000 working people in the state of Maine. We work to improve the lives and working conditions of our members and all working people, and we testify in support of LD 1626. As with the many other non-native organizations testifying in support of this bill, our primary support of the tribal sovereignty effort comes from a shared value of social justice, equity, and fairness. We join with indigenous tribes who lived in this region for thousands of years prior to European colonization in their fight for rights as sovereign nations to be recognized. For too long, indigenous tribes in Maine have lived under an unfair contract that has prevented them from accessing the same benefits the federal government provides to the other 570 federal recognized tribes across the country. Our organization, a federation of labor unions, is committed to supporting policies that build worker power and dismantle structural and institutional racism. We are working to integrate anti-racism education and racial justice within our organization because racism harms union members of color day in and day out. Time and time again, we have seen that the way to win big improvements in working conditions is to tackle issues that divide us. Race has divided the working class in Maine since European colonization. Our executive board strongly endorsed this bill upon learning the many facts that you have heard over and over again today. The exclusions based on this lack of access to these rights stifles the voice of our neighbors and negatively impacts the life that they live. A union is a way for working people to negotiate and enforce a contract at their workplace. Such contracts, known as collective bargaining agreements, are regularly updated to reflect the ways that the workplace and society change. Thanks to collective bargaining agreements, workers have a document that is regularly negotiated, protects workers from discrimination, and provides a pathway to a fair and equitable workplace for thousands of Mainers, especially veterans, workers in rural Maine, and Black and brown workers. We view the need to update the Maine Indian Claims Settlement Act of 1980 as similar to the need to update a contract between a group of workers and their employer. All working people benefit when we stand by our coworkers. We stand by our tribal neighbors because we know that Maine tribes do not enjoy the same rights, privileges, powers, and immunities as other federally recognized Indian tribes. When our neighbors prosper, we all prosper. We do not stand by when a fellow brother or sister is left out of the fruits of their labor. We join in supporting this bill because we cannot stand by while our neighbors are left out of benefits that tribes in 49 other states enjoy. Union members enjoy true democracy in the workplace where every worker has a voice. Our support for this bill is based on extending that principle so that all of our neighbors can enjoy the right to have their voice heard. For those reasons, we ask that you support this bill. Thank you.
Thank you very much, Adam, and thank you for being here this afternoon to present your testimony to us on this important bill. Are there questions from committee members for Adam Good? If so, please raise your electronic hand. I am not seeing any, so again, thank you very much for being with us today. Supi, I ask you to move over Mary Ellen Quinn, James Mayle, Sonia Berthasell, and Andrew Bradley. And I see that Mary Ellen is with us. Welcome to the Judiciary Committee, Mary Ellen Quinn. Please feel free to begin your testimony, your 3-minute testimony, as soon as you're comfortable.
Thank you very much. Senator Carney, Representative Harnett, and members of the Joint Standing Committee on Judiciary, tribal leaders and elders. I am Mary Ellen Quinn, a resident of Winterport, a town located on the shores of the Penobscot River, speaking today as co-coordinator of Pax Christi, Maine, in support of LD 1626. Pax Christi, Maine is part of a national and international movement working for peace, justice, and environmental sustainability. Pax Christi, meaning peace of Christ, is rooted in gospel nonviolence and Catholic social teaching which includes principles of human dignity, care for God's creation, and solidarity. Support of right relationship with our Wabanaki neighbors exemplifies these principles. It is clearly unjust that tribes in Maine are held back by a 40-year-old agreement with the state. As sovereign nations, the other 570 tribes across the US are moving ahead, supported by federal laws, rights, and responsibilities that the Wabanaki tribes are not able to access. It is time and past time to bring the Maine tribes into an equitable position with other tribes. Tribal leadership engaged earnestly with the state representatives on the task force to make changes to the Maine Indian Settlement Implementing Act. The passage of LD 1626 will implement 22 consensus recommendations released through that process. It is not reasonable to allow old ideas and unfounded fears to block this advancement. Wabanaki people have cared for and protected the land and the water that we now call Maine for millennia. In recognizing the sovereignty of the tribes, we acknowledge the depth of their relationship with this territory. The Catholic Church, along with other Christian churches and organizations, are responsible for so much of the violence and suffering suffered and endured by Indigenous people in North America. Standing in solidarity with the Wabanaki people is a practice of nonviolence, restoration, and justice. Recognizing their inherent sovereignty does not undo the generational damage, but we can, as people of faith and conscience, work together to move in a new direction. Our members urge you to vote in favor of 1626. Thank you for your time and thoughtful consideration.
Thank you very much, Mary Ellen, for presenting your testimony this afternoon. We appreciate you taking the time out of your day to be with us. Committee members, are there any questions for Mary Ellen Quinn? I am not seeing any. Again, thank you very much. Was that a hand up, Representative Newell? No.
No, Mr. Chair, I was just turning a lamp on. Thank you.
Oh, okay. Thank you very much for being with us today, Mary Ellen Quinn. And next on my list is Sonia, is it Berthasell?
It is, yes. My name is Dr. Sonia Berthasell. I grew up here in Maine and have lived and worked in Orono since 2011. In recent years, I've been blessed with deep friendships with Indigenous people, including members of the Penobscot Nation. My interest in tribal sovereignty is informed by these friendships, which have allowed me to learn, grow, and appreciate that support for LD 1626 is indeed a pressing issue of equity and justice. I serve as director of the Wilson Center for Spiritual Exploration and Multi-Faith Dialogue at the University of Maine. The Wilson Center is an independent nonprofit located in Orono. As a community, our most central value is equality of all people, and we do take this seriously. The Wilson Center's 16-member board has voted unanimously to support LD 1626, and I have submitted written testimony to you on their behalf and with their blessing. Upholding the inherent sovereignty of our Wabanaki neighbors through support of LD 1626 is a moral imperative. The staff and board of the Wilson Center stand united with conviction in favor of adopting the 22 consensus recommendations of the task force, as has been detailed by so many others testifying today. In solidarity with the Indigenous people I hold dear, and with eternal optimism for a just and equitable future, I urge you to vote in support of LD 1626. Peace and blessings to you this day and always.
Thank you very much, Dr. Berthasell. We appreciate your being with us this afternoon and presenting testimony. Committee members, are there questions for Dr. Berthasell? I am not seeing any. Again, I express on behalf of the committee our thanks for your testimony. Next person to provide testimony on my list is Andrew Bradley. Andrew, welcome to the Judiciary Committee. Please begin your testimony by activating your mic and beginning speaking as soon as you're comfortable.
Good afternoon. Is the audio working okay?
It's working just fine. Thank you. Go ahead.
Good. Senator Carney, Representative Harnett, and members of the Joint Standing Committee on Judiciary. My name is Andrew Bradley, and I live in Old Town, Maine. I'm a social work student at the University of Maine in Orono. And I am here to testify in support of LD 1626. This topic is particularly near and dear to my heart, as I recently completed a practicum at Wabanaki Health and Wellness in Bangor as part of my graduate social work program at the university. Instead of being viewed as someone who represents the oppressor, I was warmly welcomed and embraced as a white Anglo-Saxon male. And I'm eternally grateful for the friendships made during this inspirational experience. It was when I was invited and welcomed into Wellbriety healing circles that I learned about interconnectivity and that the hurt and pain of one is the hurt and pain of all. This important piece of civil rights legislation is more
I believe we have lost Mr. Bradley. As I wait for him to rejoin us, I will call over, ask the SUPI to please call over the next 4 persons signed up to testify: Laura Corlew, Kelly Whitlock Burton, Mike Tipping, and Phyllis Shinlund. And if Mr. Bradley returns, we will allow him to finish his testimony. So I will begin with Laura Katie Corlew. As soon as you are comfortable, please activate your mic and begin your 3-minute testimony. Welcome to the Judiciary Committee.
Thank you. Representative Harnett, Senator Carney, and members of the Judiciary Committee. I'm Dr. Laura Katie Corlew, and I live in Hamden, Maine. Hello, Representative Hagan. I'm here to testify in support of LD 1626. I'm a social scientist, a climate change researcher, and an active citizen in the state of Maine. I'm an associate professor of psychology and the coordinator for the Trauma-Informed Emergency Management Graduate Program at the University of Maine at Augusta. I'm also on the board of Food and Medicine, which endorses this piece of legislation. Personally, I have a number of reasons for supporting LD 1626. The first is just basic equity. Since 1980, the tribes in Maine have not benefited from more than 150 federal laws. One case that particularly stood out to me at the time was the reauthorization of the Violence Against Women Act, as Maine tribal women experience the same vulnerabilities to violence as other Indigenous women across this land we now call the United States. This is an unethical blight on our state. LD 1626 would also put an end to the costly legal battles that the state has fought with taxpayer dollars and will provide the tribes the right to determine their communities' futures on their native lands without facing hurdles that none of the other federally recognized tribes must face. One of my areas of expertise is the interaction between society and climate change. The tribes of Maine belong to this land and have been stewards of these lands and waters and flora and fauna for millennia and will continue to be so. Our state has benefited from their good stewardship of these natural resources. We're an outdoor state. This place is beautiful, in large part thanks to the heritage of the Wabanaki tribes. Their continued stewardship will benefit everyone here, not just with the long-term impacts of climate change, but with our near-term conservation efforts and our recreation in this beautiful state. In closing, thank you to the committee members. I strongly urge you to support LD 1626 for Maine. The sovereign tribal nations of Maine deserve at least this. There have been too many bad treaties in our nation's history. Let's take this step. Thank you.
Thank you very much, Laura Curlew, for your testimony this afternoon. Greatly appreciate you being here. Are there questions from committee members? Seeing none, again, I express the appreciation of the committee for your taking the time out of your day to provide testimony. And I see we have been rejoined by Andrew Bradley. Andrew, we lost you there for a while, but I want to welcome you back. If you could just sort of give us the conclusion of your testimony in a paragraph or two, please.
Yes, absolutely. So again, this is Andrew Bradley. And as I was saying, it was when I was invited and welcomed into the Wellbriety healing circles that I learned about interconnectivity and that the hurt and pain of one is the hurt and pain of all. And this important piece of civil rights legislation is more than the right decision in the interest of making amends and making whole again the many people within the Wabanaki tribes. It's a moral imperative. Do not tell the oppressed how to seek justice is a quote from my friend that particularly resonates with me. Passing this bill is a necessary step towards achieving decolonization. The intergenerational trauma that has negatively affected so many people is a deleterious cycle of oppression that we as a community have the power to break. As it stands, I believe the Wabanaki people are being treated as less than. They have fewer rights due to an archaic law from 1980. And the absence of implementing this bill seems to leave us with a society willing to stall justice while perpetuating neocolonialism. It is important that we all look in the mirror and critically examine our fears. Thank you, everyone, for taking the time to listen to my presentation. And I urge the committee to please support LD 1626. Thank you.
Thank you very much, Andrew Bradley. The committee greatly appreciates your being here with us this afternoon to present your testimony. Are there questions from committee members for Andrew Bradley? I am not seeing any. Again, thank you, sir, for being with us this afternoon. I will now turn to Kelly Whitlock Burton. Kelly, as soon as you are comfortable, please begin your 3-minute testimony, and welcome to the Judiciary Committee.
Thank you. And thank you to all of you for your attention today. It's been a long one and you've been hanging in. I'm very grateful for that. Senator Carney, Representative Harnett, and members of the Joint Standing Committee on the Judiciary. My name is Kelly Whitlock Burton. I live on unceded Wabanaki land in Waldeboro, and I'm here today in support of LD 1626. I offered this testimony on my own behalf, but I want to note that I'm also a leader of a group called Suit Up Maine. You heard earlier today from our founder and my co-leader, Karen Luthi, who presented testimony on behalf of our 5,000 members who live in all of Maine's 16 counties. But as I said, today's testimony is just for me. Much has been said about the complexity of the bill before you today, but the issue itself is simple. It's about fairness and equity. Under our federal constitution, Indian tribes are recognized as sovereign, having many of the same powers as federal and state governments with respect to the regulation of affairs on tribal lands. These rights are held by every federally recognized tribe except the 4 Wabanaki tribes in Maine. The recommendation to amend the Maine Implementing Act came after months of consideration by a bipartisan task force that could just as easily have recommended a different course. They arrived at this decision after a long and exhaustive process, and their work shouldn't be dismissed because the steps needed to correct this wrong are complicated. And it is a wrong that we must correct. The time to correct it is now. Maine has taken great strides in recent times to confront racial inequity and injustice. It makes us uncomfortable. It challenges us. But in that challenge and discomfort, there is light and strength, and there is fairness. And that's what LD 1626 is about at its core, fairness. The Wabanaki have waited long enough. It's time to put them on full and equal footing with all other federally recognized tribes. I urge you to pass LD 1626. And on a personal note, I would just like to recognize and offer my gratitude to my representative, Jeff Evangelos. You've served your constituents well. Thank you.
Thank you, Kelly, and thank you for recognizing our colleague and the work that he does every day. Thank you very much for presenting your testimony this afternoon. We greatly appreciate you taking the time. Are there questions from committee members for Kelly Whitlock Burton? I am not seeing any. Again, thank you very much for sticking out a good part of the day with us. I don't know if you were in the background or you were watching the whole shebang.
In the background. Thank you very much.
Thank you. Next on my list is Phyllis Chinland, just as she walked away from her chair. Sorry about that. As soon as you are ready to go, please activate your microphone and begin your 3-minute testimony. Welcome to the Judiciary Committee.
Thank you. Senator Carney, Representative Hartnett, and members of the Judiciary Committee. My name is Phyllis Chinland. I live in Brunswick. I'm a member of the Thornton Oaks Retirement Community Social Justice Group. Our group members are not always adept at navigating our way into Zoom meetings, but we know what's right. We've had the privilege of meeting with Rachel Talbot Ross, as well as our state representative, Poppy Offord. We're playing a modest role in educating others of the 180 residents of Thornton Oaks, and we are still eager to learn. When I was born in 1939, 83 years ago, the Indian Reorganization Act of 1934 was 5 years old, but I never heard of it or the much earlier Federal Non-Intercourse Act until a few months ago. Instead, I learned about Indians from listening to radio stories about the Lone Ranger and his faithful Indian companion, Tonto. And watching cowboys in white hats racing across the screen in pursuit of bad guys at the Saturday matinee. Since then, I've learned a lot about the richness, diversity, and environmental stewardship of the native cultures that were being threatened with extinction. Now I know that the 2 federal acts I referred to were about the rights of Indigenous people over their land, resources, and culture. Sorry about that. And that here in Maine, those federal guarantees have been so widely ignored that in 1975, a lawsuit by the Passamaquoddy tribe was needed to affirm tribal sovereignty, which in turn led the federal government to notice how much tribal land had been lost and to sue the state of Maine, which, as you know, led to the 1980 Settlements Act and the subsequent disappearance of tribal sovereignty. Even the Lone Ranger would have his head spinning. I strongly endorse LD 1626 to put a stop to this roller coaster of gains and losses and restore to the Wabanaki people the rights they need to thrive. It's only fair and will surely benefit the economy and environment for all of us. I thank the committee for this opportunity to speak about such an important issue.
Thank you very much, Phyllis, for joining us this afternoon. The committee appreciates you taking the time and presenting testimony to us on this bill. Committee members, are there questions for Phyllis Chinland? I am not seeing any. Again, thank you very much for taking time out of your day to be with us. I see that I had asked for James Mile to be brought over before, then we lost him. So I'm going to ask Soupy, if you could please move over James Mile, Mike Tipping, Julius St. Clair Voyers, and Kelly Merrill. And it looks like James has joined us. So James, if you could activate your video and turn on your microphone. so that we can see and hear you. And it doesn't look like James. That looks like Joby.
Yeah, I don't mean to do a bait and switch on you, but I'm covering for Mr. Mile, testifying on behalf of the Coalition on Racial Equity. Mr. Mile was covering for Megan Sway from ACLU, and now I'm covering Takes a Village. But I wanted to testify on behalf of CORE, which is short for the Maine Coalition on Racial Equity. Good afternoon. Thank you for the long day you're putting in here today. It's appreciated by so many people. The Maine Coalition on Racial Equity is made up of Maine-based advocacy groups working together to advance racial equity in our state through legislative education, training, advocacy, and government accountability. The members of our coalition, which is listed at the bottom of our written testimony, each work in specific areas of law and policy and have committed individually to work toward racial equity in our areas of focus. As a group, we come together to support legislation that cuts across all the policy areas we work in and that has a structural impact on racial equity. It's in this context that we all emphatically support LD 1626. If passed, this bill would ensure that the Passamaquoddy tribe, the Penobscot Nation, the Halton Band of Maliseet Indians enjoy a degree of sovereignty comparable to that of other federally recognized Indian tribes across the country. I'm going to skip a bit because I know you heard a lot of this throughout the day. And I will skip down to Maine is an outlier in its approach to tribal state relations. In 2015, the United Nations investigation found that the Maine Indian Claims Settlement Act and Maine Implementing Act create structural inequalities that limit the self-determination of Maine tribes. The investigation also found that structural inequalities contribute to Maine tribal members experiencing extreme poverty, high unemployment, short life expectancy, poor health, limited education opportunities, and diminished economic development. In order to address these inequities, the state of Maine must do its part. It must remove the barriers to the tribe's self-determination. This bill will help align Maine with the overwhelming majority of states which follow federal Indian law. It will help end and heal decades of acrimony. It will help Maine be a good neighbor rather than an imperious one. It will facilitate Indigenous prosperity, spurring a rising economic tide that will lift the tribal nations and their non-tribal neighbors. It will subordinate power to justice. For these reasons, we urge you to vote ought to pass on this bill. Thank you again for all the time you're putting into this and your consideration going forward in the legislative process. Thank you.
Thank you very much for being with us this afternoon and standing in for so many others during the course of the day. Committee members, are there questions? Seeing none, again, thank you very much for taking the time out of your busy day to be with us. Greatly appreciated. Next on my list is Mike Tipping. Mike, as soon as you are, first of all, welcome to the Judiciary Committee. As soon as you're comfortable, please begin your 3-minute testimony.
Thank you, Representative Harnett. Thank you, Senator Carney and members of the committee. My name is Mike Tipping. I live in Orono, and I'm senior strategist for the Maine People's Alliance. I recently read in former Representative Donna Loring's book about how she was glad exactly 20 years ago to have the support of MPA for her bills on sovereignty and education. And these issues have been a core part of our advocacy for 40 years, and I'm proud to be part of that legacy today. Unfortunately, we're still having some of the same arguments. The bill before you today represents a simple idea, as you all know, that tribes in Maine should have the same rights and abilities as others throughout the rest of the country. The unique abuses of our state's past shouldn't continue to be magnified today. The question isn't just one of high-minded ideals, however. As we've heard today, the decision you make will have real consequences in people's lives. I've seen the dirty yellow water flowing from faucets at Sabayak, a problem that's caused just as much by a lack of rights as it is by a lack of infrastructure. And I've seen the difference that tribal courts, health and wellness projects, environmental programs, and recently vaccine distribution systems can make. With greater sovereignty, they can save more lives. So recognizing the sovereignty of Maine's tribal nations will help to right a wrong from our past, and it'll help to strengthen our communities today. Thank you all for your time and your attention.
Thank you very much, Mike, for joining us this afternoon and presenting your testimony. Committee members, are there any questions for Mike Tipping? I am not seeing any. Again, thank you very much for your time today. It's greatly appreciated. Next person on my list is Kelly Merrill. Kelly, if you could activate your camera and turn on your sound, and please begin your 3-minute, welcome to the Judiciary Committee, and please begin your 3-minute testimony when you are comfortable.
Thank you. I'd like to open by expressing my gratitude to the Wabanaki people upon whose land I sit today. Good afternoon, Chair Senator Carney and Representative Harnett, tribal representatives and members of the Judiciary Committee. Thank you for the opportunity to provide testimony today in support of LD 1626. My name is Kelly Merrill. I reside in Abenaki territory in what is now known as Skowhegan. I'm not with any organization. I am an activist, community organizer, journalist, and Buddhist spiritual practitioner. I offer respect and gratitude to all my relations, and especially to those Indigenous friends and representatives who testified today. My hope is that this legislature will support LD 1626 and that the policymakers who support the bill make a sustained commitment to furthering issues of sovereignty, continue the conversations you've begun, and prepare to meet the opposition and decisively override any veto. We are in a phase of unveiling and understanding the intensely violent force colonization has been and continues to be upon peaceful people who have been of this land for over 12,000 years. We are in a phase of understanding the systemic forces that continue the erasure and genocide of Indigenous people, whether we're talking about residential schools, extraction of natural resources, hydroelectric projects, poisonous leachates being dumped into the Penobscot at Juniper Ridge, or the intergenerational and ongoing traumas that manifest in high impact health consequences. The harms of colonization upon Wabanaki people are beyond measure or expression. Passing this bill is a small, long overdue step to affirming the inherent rights of Wabanaki people and cultivating a fair and sustainable relationship with our neighbors, one that is based upon some idea of equal footing, though it should be noted that the system is one that has been historically designed to oppress them. Passing this bill is also in keeping with the 2007 UN Declaration on the Rights of Indigenous People. Sovereignty that is inherent to the Wabanaki people must be restored on paper so they, like the 575 federally recognized tribes, can benefit from the 151 laws that have been passed since the Indian Land Claims Settlement Act. Sovereignty must be recognized so that we can be better neighbors to the sovereign people upon whose land we sit. It is important to work to be in authentic relationship with the survivors of genocide, who we consider friends and neighbors. We cannot be good friends or neighbors if we are not actively working to reconcile and heal the harms suffered upon them. Please vote ought to pass in keeping with the recommendations of the bipartisan task force and Indigenous people here today. It is time for the state to take significant steps toward repairing the harms caused Wabanaki people. Our shared future relies upon it. Thank you very much.
Thank you very much, Kelly, for your testimony and for being with us this afternoon. Committee members, are there any questions for Kelly Merrill? I am not seeing any. So again, thank you very much for your time today. I will now turn to Stacy Pickering-Mosen. Please begin your 3-minute testimony as soon as you are comfortable.
Thank you. Can everyone hear me?
Yes.
Great. Good afternoon, Senator Carney, Representative Harnett, and members of the Judiciary Committee, and to the Wabanaki elders and tribal leadership. Thank you for hearing me. My name is Stacy Pickering-Mosen, and I reside in Wabanaki in the town now presently known as Rockland. I'm here to testify today in support of the passage of LD ancestors, yours and mine. It's important in my lineages, as it is in most Native families, to honor your people and your homelands when you introduce yourself. I only wish that I could do that in my mother's traditional languages, but genocide and colonization prevent me, so English will have to do today. I was born and raised in Maine. I'm the daughter of an immigrant and a white man. I'm descended through my mother from the Muisca and Quenya peoples who live in the regions now known as the Altiplano of Colombia and also Chiriquí, Panama, since time immemorial. I'm also the daughter of a man descended from white British settlers. And in fact, I can trace my late father's ancestors to the first that colonized the Penobscot Bay area, stealing the lands of the Penobscot peoples. I'm the 7th generation here in Maine on my father's side, and my children are the 8th. I mention the ancestors because I'm sure at least some of you here today have sometime taken great pride in proving how your ancestors make you more of a Mainer than folks from away. I think all Mainers are proud of this place. It's a special place to be from. But you know who else is proud of this land? The Wabanaki peoples. In fact, they wrote the proverbial book on what it means to be proud and responsible citizens of this land. But the rest of us have not studied this book. In fact, many of Maine's laws for centuries have sought to deny the Wabanaki and their descendants at every turn. It is violent and it has far-reaching harms. Right now, Maine isn't even playing by the rules that the rest of the country is in respect to what happens on tribal lands. The legislature has wasted taxpayer dollars in lengthy court battles for years trying to keep the tribes from representing themselves and by extension, this place we all call home. Political Tetris moves like these don't just go back to the states twisting the Settlement Act. This is deeper, older, and it started with some of our ancestors. It would take way more than 3 minutes for me to talk about these atrocities. The trauma is long and ongoing. Yet despite these harms, the Wabanaki peoples are still here, and they have been making decisions in the best interest of this land, its creatures, and their people long before our settler ancestors arrived, and they'll be doing so, I pray, long after empire falls. Native people shouldn't have to ask to reclaim our rights to sustain our traditional values, practices, or governing systems. And the Wabanaki should not have to ask for their sovereignty. It's their human right. The passage of LD 1626 is the bare minimum on a long road of reconciliation, and it's long overdue. In closing, I stand with my Quenya and Muisca relatives and all Indigenous people, including my Wabanaki neighbors, friends, and relatives who continue to demand their sovereignty. As a mixed Indigenous person, I stand here too, calling to account my white ancestors and the ways in which they have caused harm, and I'm asking for you to do the same. We can be grateful to our ancestors for our existence at the same time that we refuse to participate in a legacy of racism and oppression that some of them have set into motion. And I implore you to acknowledge and continue to talk about the real history of the state. We can all learn so much from those who come before us. Let us be the kind of ancestors and the kind of Mainers we can really be proud of. Please support the passage of LD 1626. Thank you.
Thank you very much for your testimony this afternoon, Stacy. We appreciate you being with us to discuss this bill. Committee members, are there questions for Stacy Pickering-Mosen? Representative Thorne.
Thank you, Mr. Chair. Thank you for providing your testimony today. You mentioned something, and I'm not sure what it means. When you said long after the empire falls, what's meant by that?
Thank you for your question. The overculture of the current leadership in the country is that that's not represented by all the people. And so the current empire is that of white supremacy.
Thank you for clarifying that for me.
Thank you for your question.
Thank you for your question, Representative Thorne, and for your response, Stacy. Are there additional questions for Stacy? Seeing none, again, thank you very much for being with us this afternoon. It's much appreciated. The next person on my list is Julius St. Clair Voyers. I think I've got the Julius St. Clair part right. I'm not sure about the end there. Welcome to the Judiciary Committee. If you could please activate your microphone and begin your 3-minute testimony when you're comfortable.
Senator Carney, Representative Harnett, and members of the Joint Committee on the Judiciary and Wabanaki tribal members. My name is Julia St. Clair Voyers, and I speak today as a resident of South Portland and as a representative for Maine Youth for Climate Justice, MYCJ. We are a coalition of over 300 youth from across the state who are fighting for bold climate action and a just transition to a livable future in Maine. We stand in solidarity with the Penobscot Nation, Passamaquoddy Tribe, and Holton Band of Maliseets in support of LD 1626. At the core of NYCJ's work is climate justice. We acknowledge that the climate crisis is rooted in systemic failures and forms of oppression and disproportionately impacts marginalized communities. We work to center and uplift the voices of folks who have been historically excluded from narratives around climate change and environmental activism. Colonialism and climate change are inextricably linked, and in order to combat the climate crisis, we need to address the environmental injustices caused by colonialism. For these reasons, supporting tribal sovereignty is an important part of NYCJ's mission. Maine is the homeland of the Wabanaki people, and they have stewarded this land since time immemorial. However, when it comes to the decisions that impact their lands, waters, and livelihoods, the Wabanaki community has been denied or altogether excluded from decision-making processes. The state of Maine is currently preventing Wabanaki tribal nations from exercising their sovereign rights to regulate their lands and waters. This injustice is environmental racism. Some examples of the environmental racism experienced by the Wabanaki people in Maine include the lack of clean drinking water on the Passamaquoddy Reservation at Pleasant Point, and the pollution of the Penobscot River by paper mills, chemical companies, and the state-owned Juniper Ridge landfill, which has made it impossible for the Penobscot Nation to exercise their sustenance fishing rights. Indigenous peoples around the world are already frontline communities facing the worst impacts of climate change, and the Wabanaki tribal nations are no exception. For example, increasingly erratic flooding and warming waters are already fundamentally altering waterways and fish populations that the Wabanaki community has relied on for food and travel. Additionally, the emerald ash borer, an invasive species whose population has increased with a warming climate, has threatened the growth of ash trees, which were used in Wabanaki basket weaving and other culturally significant practices. NYCJ firmly believes that restoring tribal sovereignty and the rights to regulate land use and natural resources is essential for Wabanaki tribal nations to address the injustices of environmental racism and to work alongside non-native Mainers to combat climate change. LD 1626 would restore the sovereign rights to regulate hunting, fishing, natural resources, and land use on tribal lands to tribes in Maine, something that the Wabanaki community has done for years and is intended by federal law. Furthermore, it is essential that the Wabanaki community and all Indigenous peoples are able to adapt to and address the climate crisis with full sovereignty, access to resources, discretion, and decision-making power. It is past time for the state government to take serious and intentional steps to create meaningful relations with tribal nations in Maine. This bill is just the start. Tribal sovereignty is not something to be granted by the state of Maine, but restored. So as a coalition of youth fighting for climate justice, NYCJ believes that addressing the climate crisis goes hand in hand with creating a more just future where the inherent rights of the Wabanaki tribes are respected and uplifted. There is no climate justice in Maine without tribal sovereignty. For these reasons, our coalition in Maine urges you to vote ought to pass on LD 1626. Thank you for your consideration.
Thank you very much, Julia, for being with us this afternoon and presenting your testimony on LD 1626. Are there questions from committee members for Julia St. Clair Voyers? I am not seeing any. Again, please accept the thanks of the committee.
Representative Harnett, I would just like to greet my constituent and thank her for providing such fine testimony today.
Absolutely. Thank you for doing that.
Thank you, Senator Carney.
The last panelist that I have in this group here is Richard Burbank. Richard Burbank, if you could activate, if you could get your electronic hand down and activate your video and unmute your microphone. And we will welcome you to the Judiciary Committee. Thank you for being here today. Please begin your 3-minute testimony when you are comfortable.
Can you see me? I don't see a control for.
We cannot see you, but we can hear you. And given the hour of the day, I would ask you to proceed with your testimony.
Great.
Without
Thank
the video.
you. Thank you very much. Join as a panelist. I just had.
You're in two places at once. I don't quite understand what's happening, but there's a lot I don't understand.
Looks like it's working now.
There you go.
Representative Harnett, honorable members of the Judiciary Committee, thank you for your long, hard work today and listening to testimony today. My name is Richard Burbank from Falmouth. I am a descendant, early white traders and settlers in this land now recognized as the state of Maine. And coincidentally, as early as the year 1626 in Castine, my ancestors were among the settling Europeans to first interact with the Wabanaki people in trade and settling on their ancestral homelands and in building dams on their rivers, the Webhanet, Majabagadus, and Naquasset. I am a descendant who even now feels that I unjustly benefit from injustices from those early days. And I recognize that the Wabanaki people suffered due to the actions of my ancestors and could suffer more tomorrow if I do not act today. Therefore, I am before you to fulfill my ancestral obligation and duty, to urge you to recognize the sovereignty of the Wabanaki people and pass LD 1626. And for my testimony today, I'll read a poem I wrote 2 years ago after reflecting on my experience testifying in person in the Judiciary Committee 2 years ago, just months before the pandemic. Here's my poem. A still water runs deep. A still water runs so deep. A glassy, smooth, innocent, flowing water, a flattering flow of mythology. But should we sound the deep chronology, genealogy flowing down our ancestral river of time? A painful truth lies deep in the sediment. Pebbles and sands of atrocity and veracity in the sediment, and deeply lodged in our ancestral river of time. Is ignorance bliss when we ignore history? Does sounding the deep and dredging up truth muddy the waters? But left down in the deeps, it seeps and poisons the waters we drink, poisons the thoughts that we think. By sounding the deep, we can weep and sit in grief a while, turn a new leaf and seek to reconcile. But how can we reconcile atrocity? How can we reconcile atrocity? Justice has no expiration date. If we allow this injustice to continue, then this poison will continue to seep into the deep and taint our waters. The time is now to act and pass LD 1626. Thank you.
Thank you very much, Richard, for presenting your testimony and your poetry to us this afternoon. Committee appreciates your presence.
Thank you.
Committee members, are there questions for Richard Burbank? Seeing none, thank you very much again for taking time out of your day to be with us. Many thanks. Soupy, I keep thinking we're nearing the end and then I see more hands popping up, but we'll plug away. I would ask you to please move over Raphael Macias, Chris Buchanan, Rebecca Boulos, and Nicole Clegg. Give a few
Representative
seconds.
Barnett,
Yes, Senator Carney?
I just wanted to suggest that that we remind people that we're taking testimony from those speaking in favor of the legislation, and that we didn't have others who signed up in advance to testify in opposition or neither for nor against. We've covered all of those folks, but it might be nice to just do one final check to make sure more people haven't joined us who wish to speak in either of those categories.
I will do that, and thank you for the reminder.
Thank you.
Senator. Raphael, welcome to the Judiciary Committee. Thank you for being here today with us. Please, if you could activate your video again and begin your 3-minute testimony as soon as you are comfortable.
Can you hear me okay?
I can hear you fine, thank you.
And is my video on?
Video is fine as well.
Okay, cool. Thank you. Thank you, Representative Harnett and Senator Carney and members of the Judiciary Committee. My name is Raphael. and I live in Topsom. I'm here to testify in support of LD 1626. And I'm really here to trying to figure out why anyone, first as Attorney General and then as governor, would be against tribal sovereignty for indigenous people of this land, given the precedent already established nationwide. Excuse me. I'm a California native who moved here in 2007 with the Navy and retired here with my family in 2013. We fell in love with the land's natural beauty, and even after 2 snowy Maine winters, we knew we wanted to call this place our home, our little slice of paradise without a billboard in sight, too. I love it. Come to find out, though, the river we live on was once ranked as one of the most polluted rivers in the country. Paper mills treated the riverways as their personal trash cans, pouring sewage and poisons into our rivers for decades. You could smell the foam on the river for miles. That's a long way away from the beauty I see, hear, and smell on the Androscoggin River today. But even now, according to the state of Maine's website, pregnant women and small children should not enjoy eating anything out of the state's river. It's dangerous. So who would think to accept and trust the entity that allowed that to happen over the original inhabitants who have always left this land how they found it? Why would one sovereign state expect another sovereign state to submit to their demands for oversight and control over land that was clear-cut and polluted no end by that same demanding state? That's not sovereignty. And then to be the last state in the nation to correct this injustice and even double down with more injustice through legal battles and vetoes, it's disturbing, it's wrong. What could it be that is keeping the state of Maine from recognizing the sovereignty of the indigenous tribes of this land when every other state in the nation has already done so? That's not de rigueur at all. Any guesses as to why our entire governing body isn't unanimously determined to correct this obvious and long-standing wrong? It's not just one person standing in the way. Maine will correct this wrong eventually. May as well be now. I hope you all become champions for tribal sovereignty in Maine. Peace to you all.
Thank you, Raphael. We did lose your video after you began testifying, but now we see you again. Thank you for being here and sharing your thoughts with us on LD 1626. Committee members, are there any questions for Raphael? I am not seeing any. Again, thank you very much for your time today.
All right, thank you.
Next person to testify is Rebecca Boulos. Rebecca, if you could please activate your video so I know you're here and I see you and your microphone is unmuted. Welcome to the Judiciary Committee. Please begin your 3-minute testimony as soon as you are comfortable.
Good afternoon, Senator Carney, Representative Harnett, and distinguished members of the Joint Standing Committee on Judiciary. My name is Becca Bolas. I'm a resident of South Portland and Executive Director of Maine Public Health Association. MPHA is the state's oldest, largest, and most diverse association for public health professionals. Our mission is to improve and sustain the health and well-being of all people in Maine through health promotion, disease prevention, and the advancement of health equity. I'm here today in support of LD 1626. Everyone deserves just and fair opportunities to obtain good health. Members of tribal communities in Maine have faced unjust and unfair conditions that influence health, including contaminated water, food insecurity, cultural disrespect, unsafe housing, higher rates of incarceration, and poverty. All these factors are compounded by other determinants of health, including high rates of unemployment and limited access or proximity to quality and affordable health care. Historical and intergenerational trauma and discrimination and systemic racism are intricately intertwined in Maine public policies that influence determinants of tribal members' health. These structural inequities are pervasive and cross-cutting, leading to differential health outcomes for tribal communities in Maine and restricting their power to influence these determinants of health. The consequences of this structural inequity are clear. Tribal members living on the Passamaquoddy Reservation at Pleasant Point have not had clean drinking water for the past 40 years. That it has taken 4 decades to rectify this contamination is evident of structural inequity. MPHA supports this legislation because clearly the current system is not working. although it could unfortunately be argued that the system is working as intended, and that is to say to prevent members of Maine's tribal community from exercising their inherent right to self-governance. This current system is antithetical to principles of ethical public health and to the advancement of health equity. That is why we support this legislation. We believe it presents a path forward and will improve the health and well-being of tribal communities in Maine. You have heard that recognizing that the tribes in Maine are sovereign nations with inherent rights will allow them to access federal funds. These funds can be used to invest in strategies to improve root social and environmental causes of poor health. Sovereign determination can improve economic security and access to medical care, increase employment opportunities, improve academic achievement, and help improve basic infrastructure, including safe drinking water and healthy, safe, and affordable housing. And PHA is proud to support this legislation, and we respectfully request that you vote LD 1626 ought to pass. I thank you for your consideration and for your time today. I know that it's been a long day, so thank you very much.
Thank you very much, Rebecca Boulos, for your testimony this afternoon. We appreciate your being here. Are there questions from committee members? I am not seeing any. Again, thank you for your time today.
Thank you.
And I do want to assure everybody, I've been checking the electronic sign-in sheet, and I've not seen anybody who has indicated they wanted to speak against or neither for nor against LD 1626. And I will assure everyone, I can't ask for more hands to go up now. I've got to get through the hands that I see in front of me, but I will check the room again to make sure that every voice is heard regardless of position. And the next person on to testify is Nicole Clegg. Welcome back to the Judiciary Committee. Nicole, it's nice to see you again. Please begin your 3-minute testimony when you're comfortable.
Good afternoon, Senator Carney, Representative Harnett, and members of the Joint Standing Committee on Judiciary. My name is Nicole Clegg, and I serve as the Senior Vice President of Public Affairs at Planned Parenthood of Northern New England, and I'm here to submit testimony in support of LD 1626. As a mission-driven healthcare provider, we fundamentally believe everyone should be able to get affordable, high-quality healthcare in their communities, no matter where they live or how much money they make, and we advocate for policies to help make that vision a reality. For us at Planned Parenthood, it's important that we acknowledge the reproductive oppression that is tragically woven throughout the history of the state of Maine and its relations with Maine tribes. Reproductive oppression in Maine has taken many forms, but at its core is the denial of self-determination and agency, forced sterilization, child apprehension, forced evacuation, and the total and complete loss of decision-making about one's health and body are real and painful chapters in our history. Today, reproductive oppression is more insidious, but ever present. We don't have to look far to see how laws aimed at restricting access to healthcare continue to harm. To help right these wrongs, we support and advocate for reproductive justice, which is broadly understood as the complete physical, mental, spiritual, political, social, environmental, and economic well-being of women and girls. Put simply, reproductive justice is the human right to have personal bodily autonomy, have children, not have children, and parent the children in safe and sustainable communities. Indigenous communities have always been a central part of the reproductive justice movement. The road to reproductive justice in Maine runs through LD 1626 and the right to self-determine and self-govern for Maine tribes. Maine tribes deserve and have a right to make their own healthcare decisions without state government interference and ensure the provision of culturally safe and local healthcare. They deserve and should have the right to advance community health and address the pervasive health inequities that exist in Maine. They deserve and have the right to self-determination and inherent jurisdiction over their children and families. The time is now to stand by our tribal neighbors. When they prosper, Maine prospers. I urge the members of this committee to vote ought to pass on LD 1626. Thank you.
Thank you very much, Nicole, for being with us this afternoon and presenting your testimony. It's appreciated. Are there questions from committee members for Nicole Clegg? Seeing none, again, the committee extends its thanks to you for joining us this afternoon. The next person I have on my list to testify is Chris Buchanan. Chris, if you could activate your video and unmute your microphone so we can see you. Chris, are you able to? Chris Buchanan, you keep bouncing around on my screen. Here you go. Welcome to the Judiciary Committee. If you could please activate your microphone and begin your 3-minute testimony as soon as you are comfortable.
Thank you. Can you hear me now?
Yes, I can.
Great. Good evening, Representative Harnett, Senator Carney, and all the distinguished members of the Judiciary Committee. I know it's been a very long day for you. I've been here also since this morning, also popping in and out from work. And I just wanted to not repeat what other people have said in voicing my support for LD 1626. So what I'm going to add is that I did a little independent study about the gaming in particular, and uncovered that over the past 30 years, while the tribes have been trying to pass gaming proposals, if we look at the past 10 years specifically, what I found was that all of the Wabanaki initiated proposals were denied by the state. Meanwhile, 67% of the white based proposals were accepted, and they're from out-of-state corporations. And I just think that's kind of a definition of institutional racism in and of itself, to accept these other proposals and then say, no, we're not going to have any more gaming in the state. There's a current moratorium. So I just wanted to bring that up as an example of what I see as such frustration on behalf of the tribes, and an example of, such an economic disparity. I know the gaming is a hot button issue, and I hope that just provides an example of what folks have been dealing with. And I thank you. I thank you very much for your time and for listening to people all day.
Thank you very much for being with us this afternoon to present your testimony, Chris. Are there questions from committee members for Chris Buchanan? Not seeing any. Again, thank you for your time today. Greatly appreciated. Supi, if you could please move over Robin Merrill, John Leopold, Desti Homan Sprague, and Amy Winston. And it looks like some have been moved over. I will begin with Robin Merrill, but I think I'm seeing somebody other than Robin Merrill, but we're getting used to that today.
Sorry.
That's quite all right. Welcome to the Judiciary Committee. If you could please begin your 3-minute testimony with an introduction so we know who we're hearing from.
Yes, thank you. And Robin had to leave. Good evening, Senator Carney, Representative Harnett, and members of the committee. My name is Kathy Kilring Del Rio, and I'm the Advocacy and Programs Director at Maine Equal Justice, and I'm testifying on behalf of our Executive Director Robin Merrill, to express our strong support for LD 1626. Maine Equal Justice is a nonprofit legal aid organization working to increase economic security, opportunity, and equity for people in Maine. To achieve our mission, we must actively work to eliminate inequities in economic well-being for Wabanaki people, inequities that are rooted in tribal state relations dating back to the establishment of the state, and in relations with European settlers prior to that. With LD 1626, the legislature and governor have an opportunity to take a significant step toward repairing those relations by recognizing tribal sovereignty and establishing an equal government-to-government relationship between the state of Maine and each tribal nation. We firmly believe the best solution to structural inequity will come from meaningful collaboration with the people most impacted. That's why we work in partnership with people with low income in deciding what policies to prioritize and developing proactive policy solutions. As you know, this bill is based on consensus recommendations from a bipartisan task force of legislators and tribal representatives. For the tribes, this bill is representative of the kind of self-determining process that needs to take place, one that is led by and intimately informed by the communities seeking justice from systemic oppression. There's no doubt that is why the tribes are at the forefront of calling for you to pass this bill. In its most basic sense, tribal sovereignty, the inherent authority of tribes to govern themselves, allows tribes to honor and preserve their cultures and traditional ways of life and to exercise self-determination. When they are able to exercise their sovereignty, it will lead to greater economic opportunity and prosperity that will better us all. We hope you will vote ought to pass on this important bill. Thank you for your time and consideration.
Thank you very much for being with us. I can't even call it this afternoon anymore, this evening, and stepping in for Robin to provide the testimony. It's very much appreciated. Committee members, are there any questions? Seeing none, again, thank you very much for joining us today. I'll now turn to Desti Homan-Sprague. Hi, Desti. It's good to see you again. Could you welcome to the Judiciary Committee and please begin your 3-minute testimony as soon as you are comfortable.
Good evening, Representative Harnett. Thank you. And Senator Carney, members of the committee. I'm Desti Homan-Sprague, and I join you today on behalf of the Maine Women's Lobby. For over 40 years, we have advocated for gender responsive and gender equitable public policies, with a focus on those most affected by misogyny, sexism, and other forms of oppression. We are here today in strong support of LD 1626 and thank sponsor Representative Talbot Ross for her work on this bill, and also offer our thanks to the Wabanaki people of the region, the Aroostook Band of Micmacs, the Holton Band of Maliseets, the Passamaquoddy tribes, and the Penobscot Nation, and thank them for their care and commitment in organizing the voices that you've heard today. Our work at the Women's Lobby is rooted in the idea that public policy can be used as a tool to hold and consolidate power and resources, or as a tool of justice, supporting equity of gender, race, class, and more. For too long, Maine's public policy has held on to old notions of policy and power when it comes to their relationship with the tribes. Indeed, when the Indian Citizenship Act of 1924 was passed at the national level, Maine was one of the last states to enact the act almost 10 years later. And now we are one of the only states that persists in maintaining a relationship with the tribes that denies them access to their right to self-determination. We see the effects of this harm in myriad ways, especially on the lives of Native women and girls who are dramatically more likely to experience sexual violence, domestic violence, stalking, and other forms of personal trauma that are the result of colonization and legal structures that have disempowered the tribes. It doesn't have to be this way. There is an opportunity to choose a different path that's more respectful of the inherent right of the tribes to self-govern. At the heart of our work for gender equity and feminist public policy advocacy is the notion of self-determination and the dignity of bodily autonomy as a human right. We could not continue to work for our principles without supporting the same rights and recognition for the original stewards of these lands. We stand with the Wabanaki people in this work and hope you will vote ought to pass on LD 1626. Thank you.
Thank you very much for joining us this evening, Desti, and for providing testimony to the committee on LD 1926. Are there questions from committee members? Seeing none, again, thank you very much for your time today. I'll now turn to John Leopold. If you could activate your camera, and which you've done, and unmuted, please. Welcome to the Judiciary Committee. Please begin your 3-minute testimony as soon as you're comfortable.
Thank you. Can you hear me?
I hear you perfectly. Thank you.
Awesome. Senator Carney, Representative Harnett, and members of the Judiciary Committee. My name is John Leopold. I live in Orono, and I'm here to testify in support of LD 1626. As someone who grew up in Farmington, Maine, graduated from the University of Maine, and is currently working in Orono, I feel a strong sense of connection and community with all people who share this land here in Maine. As the program coordinator of the Wilson Center, a nonprofit organization in Orono that works to build community and create dialogue among people of differing faiths and cultural backgrounds, I feel that I must speak in support of my Wabanaki neighbors. As someone who comes from a Jewish family, my grandmother had to flee Nazi persecution in Europe and then deal with a lifetime of unfair treatment as a Jew in America. My entire family, who all live and work in Maine, understand what it is like to be treated without full dignity and respect. The tribes in Maine are asking to simply be treated like the other 570 federally recognized tribes. They should be able to determine their community's futures. They should have that right on their native lands without the state of Maine obstructing them. It is our duty to uplift and respect all people, especially those who have been treated as lessers for so many generations. I'd like to thank you for your time and consideration, and I hope you will support LD 1626. Thank you.
Thank you very much, John, and thank you for presenting testimony to the committee this evening. Committee members, are there any questions for John Leopold? I am not seeing any. Again, thank you for your time today. It's very much appreciated. Amy Winston, if you could please activate your video. Welcome to the Judiciary Committee. Please begin your testimony as soon as you're comfortable.
Okay, thank you very much, and thank you for having me, Senator Carney, Representative Harnett, and members of the Judiciary Committee. My name is Amy Winston, and I'm testifying as the State Policy Director in support of LD 1626 on behalf of Coastal Enterprises. CEI integrates business financing, industry expertise, and policy solutions to grow good jobs, environmentally sustainable enterprises, and shared prosperity in Maine. Like Four Directions, CEI is a community development financial institution. CEI's president, Keith Bisson, serves as the CDFI representative on Maine's Permanent Commission on the Status of Racial, Indigenous, and Tribal Populations, which has prioritized this bill. As economic development practitioners, we have learned that when local people are empowered to exercise agency over their own livelihoods, set the agenda, make decisions, and access resources needed for long-term development and investment, people's lives improve, businesses flourish, and communities are stronger. We know that existing economic development infrastructure does not always adequately serve rural communities and can lead to geographic disparities, short-term thinking, failed enterprises, and brain drain. It undermines hope. Research shows that this applies to Native North American nation communities as well as non-tribal communities in regions that are rural or otherwise peripheral to the mainstream. And this, as I understand it, is the purpose and impetus for this legislation. Tribal workers and families experience significant disparities in health, housing, and economic stability. The need for jobs and income is enormous and can be better served by a proactive approach to development based on an agenda that is set by the tribes for the tribes. The Wabanaki nations are telling all of us that tribal governments need a larger role in decision-making and resource allocation. Federal policy provides a modern-day federal tribal relationship, a legal and political framework that promotes self-determination. Legal sovereignty, which the Wabanaki don't have as a result of Maine's Implementing Act, is needed to practice self-determination. This has enabled tribal governments to expand into business operations and provide direct government services. The lessons, sovereignty is key to implementing economic development strategies that improve lives and create positive ripple effects in rural regions. And it is needed to access the capital to provide physical infrastructure, broadband, to start and sustain businesses, and to deliver needed services, education, and training. The lessons are in the stories. stories which illustrate the potential for sovereignty and self-determination to benefit both tribal and non-tribal communities in Maine. In my written testimony, which I have revised and I'm going to submit, I describe case studies of tribes that are actively using the tools at their disposal to rebuild their communities, cultures, and families. And there is further research that shows the relative success and longevity of tribally owned and operated businesses and the employment created by these enterprises. We recognize the concerns that are registered by towns along the Penobscot and St. Croix rivers. These communities are destination communities offering cultural tourism, quality of place.
Excuse me, Amy. Amy, I apologize for having to do this.
I'm just about to wrap up. I'll
Please
close
wrap
by
up in a sentence or two, please.
Yes, of course. We feel that the state can work with these towns to offset their financial impacts, and Maine's ability to engage cooperatively with the tribes in a government-to-government fashion will yield positive results and contribute to business and industry innovation that aligns with Maine's economic development plan. We urge the committee to listen to tribal and non-tribal constituents alike and pass this bill. Case studies of sovereignty-based development show its efficacy and show the importance of this. I thank you so much for taking the time to hear my testimony and to hopefully read my written testimony.
Thank you. We have your written testimony. I have it in front of me right now, and I appreciate you providing that to us. Thank you very much for being with us this evening. Are there, excuse me, questions from committee members for Amy Winston? I am not seeing any. I will now turn, again, thank you very much for being here. Greatly appreciate it. I will now turn to Senator Craig Hickman. Senator Hickman, nice to see you. I think you're just on the, are you on the other side of the wall for me, or have you gone home? You've gone home. Lucky you. Welcome to the Judiciary Committee. Please begin your testimony as soon as you're comfortable.
Thank you. Senator Carney, Representative Harnett, and other esteemed members of the Joint Standing Committee on Judiciary, my name is Craig Hickman. I am the senator from Southern Kennebec County. I represent 11 towns, including my hometown of Winthrop. I would like simply to present a piece of testimony from a constituent that he really wanted to share. And so I'm going to share it in his stead since he is not able to do so at this time. It reads as follows. My name is Scott Klinger. I am pleased to offer my enthusiastic support for LD 1626, an act implementing the recommendations of the task force on changes to the Maine Indian Claims Settlement Implementing Act. My wife and I moved to Maine 2 years ago and have been proud of the many ways our new state leads the nation in environmental protection, in care for one another, and in tolerance. It was therefore disturbing to us to learn that Maine ranks dead last among the US states in state-tribal relations. Since arriving, we have devoted ourselves to learning about the history and culture of the Wabanaki. We have appreciated the programming offered by Maine Historical Society, the Wabanaki Alliance, Maine Public, Maine Audubon, the Maine Episcopal Diocese, and LL Bean. It is clear that many in our state believe respectful government-to-government relations is a strong priority. I agree. The task force studying the Maine Indian Claims Settlement Act has done careful and thoughtful work. We should listen to it and adopt their recommendations. Those who oppose LD 1626 speak about their concerns about Maine having to cede some control and perhaps lose some state revenue. Yes, that's what indigenous sovereignty means. But these fears must not guide our pursuit of justice. I believe all Mainers will be better off if Maine's tribes are afforded the same federal rights and protections that other sovereign tribes in the United States currently enjoy. It saddens me that some of our leaders worry about what tribal ownership of additional land would mean for Maine's communities when they greet news of land acquisition by polluting corporations as something to celebrate and support. Throughout my life, I have been blessed to live and work in different indigenous communities across the United States. Turtle Mountain Ojibwe Reservation in North Dakota, on Yupik land in southwestern Alaska, with the Bay tribe in North Carolina, with the Oneida tribe of Wisconsin, and with the Inuit in Point Hope, Alaska, the oldest continuously inhabited community in North America. I have also worked with the Tahltan First Nation in British Columbia. In each of these settings, I have seen the benefit of strong and federal recognition of the tribes and the importance of strong nation-to-nation relations. Strong sovereignty protections for these tribes benefits tribal members and settlers alike. Respecting the sovereignty of tribes is not always easy. Tensions will crop up. Learning to negotiate between the state of Maine and the Indian nations will be ongoing. The Maine Indian Land Claim Settlement, in my opinion, should not be clung to as settled law. The negotiations for the Settlement Act were fraught by dramatic differences in power at the table, as so many Indian treaties have been throughout history. After years of negotiating with the state and federal government, the tribes faced the prospect of a new administration that left them fearful would cease negotiating altogether. Faced with the prospect of taking a bad deal or going who knows how long with no deal, they took the bad deal. For people in our time to say tough luck and walk away is not the right thing to do. I don't believe it reflects most Mainers' values. LD 1626 would take several more steps in the right direction. I hope the Maine legislature will soon pass it and that Governor Mills will promptly sign it. I look forward to being proud of my state as it becomes a leader in state tribal relations. Respectfully, W. Scott Klinger, Gardner, Maine. I will close simply to say thank you all for listening all day and into the evening. The Wabanaki people deserve your vote in favor of LD 1626. Not only am I the son of a Tuskegee Airman and the wisest of wise women, but Blackfoot and Cherokee blood courses through my veins. And so I can say that tribal sovereignty is something that I support deep down in my bone marrow. I urge you to pass this bill. I appreciate the time to provide testimony today. Thank you.
Thank you very much, Senator Hickman, and thank you for reading in testimony of a constituent of mine. Committee members, are there questions for Senator Hickman? Seeing none, again, thank you very much for your time today, Senator. Much appreciated by the committee. The next person that I have is Grant Provost. Grant, if you could activate your camera. And welcome to the Judiciary Committee. Please begin your 3-minute testimony as soon as you are comfortable.
Thank you. I appreciate the time you all are putting in today too. It's important. Thank you. Senator Carney, Representative Harnett, and members of the Joint Standing Committee on Judiciary. My name is Grant Provost. I'm the business agent for Ironworkers Local 7 in the state of Maine. I'm also a member of the AFL-CIO Executive Board. I sit on 3 Maine state workforce boards. I rise in favor of LD 1626, an act implementing the recommendations of the Task Force on Changes to the Maine Indian Claim Settlement Implementing Act. The bill is about fairness, the right to be treated as all other tribes in the United States are treated, and the chance for the people of the Wabanaki Alliance to be able to make their own governing decisions. Local towns in Maine have the ability to generate tax revenue or to make rules regulating their own natural resources. It's time for the tribes of Maine were able to do the same as well. I am proud to be part of a growing movement to respect our brothers and sisters of the tribes and their sovereign rights by standing beside them in their fight for equitable justice, especially since they are asking for the same deal all the other federally recognized tribes in the United States enjoy, not more. In my time with Ironworkers Local 7, I have worked beside many First Nations and Indigenous peoples. I have brothers and sisters who are members of the Mohawk, Wabanaki, Micmac, Wampanoag, and Nauset tribes, as well as many others. I am fortunate to be able to refer to these strong people as brothers and sisters. When I learned that some had been excluded from the very freedoms that most in this country enjoy, I knew I would be speaking today. These very brothers and sisters put their faith into me when they elected me to secure work and to fight for them in the state of Maine. Tribal sovereignty is about being treated as equals, respecting the tribe's right to govern themselves, enforce laws on their land, and to protect what is rightfully theirs, and to pass a future of equality to their children as we do to ours. The Maine Indian Claims Settlement Act was supposed to provide funds and outline the process for Maine tribes to repurchase more than 1 million acres that was unlawfully taken for them. To this date, the tribes have not been able to purchase nearly that amount back. What does this sound like to you? The committee here today can move this piece of legislation forward with an ought to pass recommendation and start a process that will bring fairness and equity to the Wabanaki Alliance. Thank you for your time today. I do appreciate all the time you guys are putting into this. Thank you.
Thank you very much, Grant, for taking time this evening to address the committee. Your comments are very much appreciated. Committee members, are there any questions for Grant Provost? Seeing none, again, the committee extends its thanks to you for being here today.
Have a good evening.
You as well. Paul Kelly, if you could unmute your microphone and begin your 3-minute testimony when you are comfortable, and welcome to the Judiciary Committee.
Thank you so much, Representative Harnett, excuse me, and Senator Carney and members of the Judiciary Committee. My name is Paul Kelly. I'm a retired elementary school teacher. I live in Blue Hill, Maine, where I still substitute teach up at the Bay School. And as we approach the end of this day-long discussion, I'd just like to do one thing. I'd really like to hearken back briefly and very respectfully to remarks that we heard this morning made by Ambassador Dana, and especially to her tone when she characterized the recommendations of the task force as, quote, a success. Yes, it was a huge success. I think several people have testified today that the dialogue and the legal work involved in collaborating on those 22 recommendations represents hard work, envisioning, listening, and reporting on the lived experience of our Wabanaki neighbors. And I think we owe a huge debt of gratitude to those people who devoted their attention to getting this right. And now, this is just my own humble opinion, but I believe that truth and especially justice aren't handed to us on a silver platter. I believe we have to figure them out case by case. To me, LD 1626 is a perfect example of people trying to figure it out. After listening to and reading today's testimonies and integrating them into your extensive knowledge of the recommendations, I would urge members of the Judiciary Committee to take the next step in our current understanding of justice by supporting Wabanaki sovereignty through LD 1626. Thank you.
Thank you very much, Paul, for joining us this evening to present your testimony on LD 1626. The committee appreciates your time. Are there questions from committee members? Seeing none, again, thank you very much for being with us today. I am going to ask the committee clerk, Soupy, if you could move over Martin Chartrand, and then I will go through the attendee room to make sure I have not missed anybody who wants to testify in any capacity. Martin Chartrand, if you could activate your video when you are set and unmute your microphone so we can see you and hear you.
Hi.
Hi, I want to welcome you to the Judiciary Committee, and please begin your 3-minute testimony when you are comfortable.
Thank you so much, Representative Harnett, Senator Carney, and members of the Judiciary Committee. Thank you for the time. My name is Martin Chartrand. I am a resident of the Penobscot Valley, and I'm here to testify in support of LD 1626. I grew up in Rockland along the coast, the Rocky Shores and spruce forests. And I moved to Bangor when I was 20 and started working with a nonprofit addressing poverty issues. I've since worked as an installation contractor and weatherization technician. And this place is my home. It's where I have the relationships that make up who I am, where I hope I'll have a family someday. Yet it's not my homeland. It's the homeland of the Penobscot people. And European colonists, like my own ancestors, took this land by force and by deceit. And that's a responsibility that I take seriously to make right. It hits home for me because I'm autistic. So I've been told a lot, or I've gotten the message that from others that they know better that how to take care than I know how to take care of myself, or how I should be learning. And it feels like that's what state's been doing for years, since the Maine Indian Land Claims Settlement Implementing Act to the Wabanaki people. And that's why I'm here today to testify in favor of this change, because everybody, whether we're individuals or nations, we thrives when we have the right to govern ourselves, and we're supported to do that. I believe very strongly this bill will improve the lives of everyone in Maine. It could give Wabanaki families more access to things like healthcare, or ability to decide together as a community to protect their natural resources. And for those of us who are settlers, it can help us in our own healing process to move past those wounds of violence and colonization, because we can't heal them until we stop causing them. And it will also benefit those who live alongside the Wabanaki, because they have a long history with this land, and they will make decisions that will benefit everybody materially. I encourage you strongly to vote ought to pass on this legislation. And I think that we have a choice before us, whether to continue the cycle of power and control, or to, as many speakers have attested to start a path toward a relationship of cooperation and mutual care for this very special, very unique place we call Maine, this place called Wabanaki, and this place we share as human beings. So I thank you for your time and your patience and your resilience listening for so long today, and for your leadership. And I hope you will vote ought to pass, and also advocate for this bill to move through the process and overcome any possible vetoes. Thank you.
Thank you very much, Martin, for being with us today and sticking it out till what we think is the very end. But we appreciate that very much, and we appreciate your testimony. Committee members, are there any questions for Martin Chartrand? I am not seeing any. So again, please accept the thanks of the committee for being with us this evening. Okay, I want to go back to the attendee room to check if there are any persons in the attendee room who wish to testify in opposition to LD 1626, to please raise your electronic hand. And I am not seeing any. I would ask if there are any persons in the attendee room who wish to speak neither for nor against LD 1626, to please raise your electronic hand. Again, I am not seeing any. And with no trepidation at all, I'm going to ask one more time, are there any people who wish to speak in support of LD 1626? Theodore Kanalakis, Supi, could you please move Theodore over as a panelist? Theodore, it appears that you've made it to the panelist room. If you could please activate your video so that we can see you. Thank you. Welcome to the Judiciary Committee. Please begin your 3-minute testimony as soon as you are comfortable.
Good evening. My name is Theodore Kanalakis, and I am speaking in support of ought to pass for LD 1626. Thank you to Senator Carney and Harnett and all the members of the Joint Standing Committee on Judiciary for this whole day of being together with both people who are testifying and listening to the wonderful expressions of care. I am a resident of Camden on Penobscot Nation territory. I am a retired New York City police lieutenant, 25 years of service. I am also an Episcopal priest serving the Episcopal Diocese of Maine and on its Committee on Indian Relations for the last dozen years. I speak to you for myself and from my heart. I would like to say that first, I want to do something that no one else has done yet today. And I hope you will bear with me for a few moments. I would ask us all to observe a moment of silence to recall the 2021 discovery of more than 1,000 unmarked Indigenous children's graves in Canada in proximity to residential schools. Thank you. I know that we know these children were taken from their homes and forced into institutions for learning because people in authority in government, state, and national and church authorities thought it was a good idea to change them from a life that they knew nothing about and to take them away from their families and from a culture that was more than 12,000 years old. There have been questions about why this happens. I think it's basically a problem of fear. When we're afraid of something, we run from it or we fight because we're afraid of losing something, whether it's our lives or in many cases, things we have, possessions or privilege. I've seen the best of human behavior, and I've seen some of the worst of human behavior. I've seen brother killing brother. I've seen people's lives completely destroyed because of inabilities to make peace with one another. There's something about gratefulness that opens the door to love and forgiveness. And I hope that my written testimony, which I have put in, will be something that some people may want to look at. But what my major hope is that all of us will continue to work hard in every way that we can to see that we move forward in this legislation for change. Besides voting for it, I think helping our fellow representatives also understand what we do is important. And I like our governor as a person. And I am sorry that she does not see what it is that many of us see. I hope she will find that out when she checks on the witnessing today. But this is an opportunity for her, for the committee, and for legislators throughout the state to move in a direction that will change life for each and every one of us for the future to come. I thank you so much for allowing me to speak before you. I give thanks for all of you and continue to keep you in my prayers. Thank you.
Thank you very much, Theodore, for being with us this evening and putting quite an end to what's been a very powerful day of testimony and a long day of testimony.
Thank you. Thank you.
Committee members, are there any questions for Theodore Kanalakis? And I am not seeing any. So at this point, having heard all of the testimony from members of the public on LD 1626, I want to close this public hearing, but I also want to extend a great deal of thanks and appreciation to the bill sponsor, to the probably over 100 people who testified today, and to the over 1,000 who submitted written testimony. I want to thank my colleagues, my co-chair, Senator Carney, my colleagues on the Judiciary Committee for sitting through this entire day with apt attention and with just open eyes, open hearts. So thank you all. I want to thank our two analysts who have been here all day, and Supi Panett, who has to move all these people around for me, and I appreciate that greatly. I would remind committee members, I'm going to close I know I have to turn to the analyst and Supi to see if they have something else to say. Supi is saying no. Peggy, do you have anything that needs to be shared? No. Janet? No. We will be meeting again on Thursday, the 17th, beginning with public hearings at 9 o'clock. Until then, please take good care, and I will see many of you tomorrow when we're in session in the legislature. Thank you all very, very much.
Thank
Good night, everyone.
Good night.
night.
Bruins.
Well done, Tom.
Thanks.
Rangers are going down tonight, Tom.
Okay. Okay. Take care, all.
Night.
See you soon.
Drive safe, Steve.
I will. Yeah.